Hey everyone, welcome to another special live discussion on immigration and jobs talk show. I'm your host Rivera, and we have got a special treat lined up for you because we are diving into not one, but two fascinating cases with our guest, Jonathan Wasden. John represents clients on strategies to overcome immigration denials, including bringing cases to federal court under Administrative Procedures Act. For a majority of his career, John worked as an attorney for various US governmental agencies where he defended immigration regulations and decisions under the APA. His last position in the government was with the Administrative Appeals Office, focusing on employment based legal issues and advising on litigation in these areas. He is now a partner at Wasden Banias, a Washington, D.C. metropolitan area law firm specializing in employment based immigration and Administrative Procedures Act litigation. All right. So, today, first up, we'll be talking about a case where Jonathan and his team scored a big win, a mega win. Okay, so picture this. A group of folks with special work visas called H1B visas were in hot water because their employer were accused of doing something shady stuff. But guess what? Jonathan swooped in like a legal superhero and fought tooth and nail for these people's right. And guess what again? He won. Yup. The court ruled in favor of these H1B visa holders, saying they deserve a fair shake and in the government. And the government can't just yank away their visas without a fair fight. Now, on to our second case, which is still hanging in the balance. It's all about a guy named Sridhar Alawala. He's in a bit of a pickle because his old boss got in some trouble for something sketchy ages ago. And now the government's threatening to take away Sridhar's visa because of it. But hold up. Sridhar didn't do anything wrong. So Jonathan on this case trying to make sure Sridhar doesn't get the short end of the stick. So buckle up, folks. We are in for a roller coaster ride through the twists and turns of the legal world with Jonathan as a guide. So let's get started. And before we move ahead, I would like to read out this important disclaimer that is on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Now, John, welcome to the show once again.
Thank you. It's good to be with you.
Thank you so much. And firstly, congratulations on your recent win in the H1B visa case. And if you can please share some of the messages that you got on social media. We were tracking your account. I mean, we were looking into the accounts and people were really congratulating you and on your big win. So if you can also please show it on the screen for the viewers, we would like to.
Yeah. So a lot of the cases that we're working on right now have a common element, which is the government didn't give the interested party in the case notice and an opportunity to respond prior to issuing what amounts to be a punishment, or what the law calls a sanction. So in the Narambalada case out in Seattle, in the Western District of Washington, it was one of those issues where the employees had all been selected in the H1B cap lottery, been assigned a cap number, were working, and then the government yanked the rug out from underneath them and said, your employer did something wrong, we're taking away your cap number. And so it's important to recognize that when you get your initial H1B approved, there's two different benefits going on. One is the benefit to the employer, which allows them to hire you and make money off of you. And then the other benefit goes to you, the employee, which is your right to change jobs, your right to extend indefinitely if you have an approved I-140. And so what they do in these cases is they take away the employer's right to employ and also try and strip the innocent employee of their cap number. And so very quickly in that case, in Narambalada, like early on, the government conceded the employees did nothing wrong. They're not the ones that are, alleged to have committed fraud. It's all the employer. And then they said, even if that's the case, the court shouldn't hear this issue, and they should dismiss the case. And our argument has always been that the interested party in the cap number revocation is the employee, and they're the only people that get noticed because it's all on them. It's all the negative impact is all on the employee. And so that was our argument, pushing, and there was a couple of other arguments, but that was our lead argument. And so the court says they are good to go forward and press their case in federal court.
Okay, great. Well, before we move into and before we dive into the details of this case more, I would like to actually show our viewers those congratulations messages by people on your big win. If you can please share those screenshots or those images here, please.
Me?
No. I'm asking my my team, not you. I was just talking to my team. I'm really sorry about the confusion.
That's all right.
So, yes, but John, meanwhile, my team shares these screenshots of these messages. I would like to know from you, how did the win feel? I mean, how did you feel?
It was nice to know that the clients have hope and they're not doomed forever and losing their H1Bs. It's also nice to know that you're right. So one minor correction to what you were saying earlier. So I'm not in Wasden Banis any longer. I'm just at Wasden Law, but I'm doing the Narambalata case with Jesse Bless, and he's another immigration litigation attorney.
Okay, all right. Thank you so much for clearing that out. And okay, and yeah, as people can see on their screen, see these messages from people, and can we also have more? You are fighting the good fight, and then if we can also thank you, Jonathan, for your support. And this is about the Sridhar's case actually, and if we can also show more. See, too many messages actually for John. Congrats on the great work. Make them pay. And this is awesome, John. Thank you for sharing. What a win. This is incredible. So a whole lot of messages from the people actually. So, and now, John, coming back to you again. And now I would like to talk more about the case. If you can please, also walk us through how you and your team actually stumbled upon this case in the first place, and what actually made you notice it.
So in the Narambalata case, it was all about the multiple registration issues that were, endemic in the 2022 and 2023 fiscal year lotteries. And I guess the 2024 as well was a hot mess. So what we saw is people getting selected in the lottery, working for the employer. A lot of times they didn't know that they had been entered in by multiple companies. They thought there was just one offer of employment. And the reason for that is manyfold. Sometimes the employers would get the list of employees that they wanted to hire. They would share with some other company, and then they would apply without the employee knowing. They also were using recruiting companies back in India who was selling the same list of employees to multiple different employers. And that really ratcheted up the number of duplicate registrations that were going on. But what we noticed is that, when they were revoking all of these H1s, most of the time, the employee had already moved on. They'd already transferred their H1B to a new employer. And so the old employer typically does not respond to the notices of intent to revoke, because USCIS has said they're going to criminally prosecute people. And so nobody wants to say anything, and those go unanswered. And the only person that really is impacted is the employee, because they're the one whose cap number is getting stripped. Yeah. The initial employer has already lost their right to employ. And so, they get blindsided by this at their new employer with a new notice of intent to revoke the second visa. And so if you were selected in those years that were tainted by the multiple registration, you should probably be checking your case status page regularly on the visa, just to make sure that USCIS hasn't revoked it without telling you. So you're not similarly blindsided. But the employees that came to us, they were obviously they had done nothing wrong. They were frustrated with the system. And so we looked into it. The first thing right off the bat we noticed is that under federal law, the statute, the immigration statute, you cannot strip a cap number away from an employee for fraud unless they're the one that commits fraud. And in these cases, the government was very clear early on. Their initial defense was there's no fraud on the employee's part because we're suing them, challenging fraud findings against the employees as well. So very quickly, they backtracked on that. And so under the statute, the employee didn't commit the fraud, so they really shouldn't have their cap number stripped away for the actions of a third party. The other issue I think that is more interesting from a nerdy lawyer perspective is that the anti-collusion rule that is being used to justify all of these revocations was never published the way the rules are supposed to be published. So USCIS went through this long rulemaking process where they provide notice to the public, they take comments, they analyze comments, and then they publish a final rule. They did that when they recreated the new lottery back in 2019. And they changed the structure of the lottery. So they went through the rulemaking process, and a lot of people commented, very well-known people within immigration commented that if they didn't change the structure, it would lead to massive duplicate registrations and frivolous filings that would cause unused petitions. And so people just wouldn't have enough work for the number of employees that they got selected for. USCIS's response to that was, we're not worried about it. What we'll do to solve that problem is we will just require them to make an attestation that they will file a petition. Now, notice there was no attestation about unfairly, working with another employer, nothing like that. So the first 2 years the lottery goes off without really much of a hitch. It's not that crazy. And then the numbers started to get crazy. USCIS realized they had screwed up. But instead of going back through the process that they're required to under the law to fix it and create new rules and put the public on notice, they essentially just put it up on their website, and that was the extent of their notice. So we're challenging that because they really did not follow the process. The federal courts are pretty clear. When you create a rule like that, you have to give the public notice in a very particular way, which is publishing it in the Federal Register. That's the only way that people know officially what's happening and what the agency is going to be doing. And they didn't do that. And so I think they have a rulemaking procedural problem. Almost all of the cases I do come under the Administrative Procedure Act, and that's the handbook the government has to follow when they make any type of decision or rule. If in my line of work, if we're arguing about facts, it's going to be a rough case. But when we're arguing about procedure, that's when we're at our best. And pointing out the procedural flaw in the rulemaking, I think, is ultimately going to be what wins the case.
Okay. All right. So, John, I'm definitely, you mentioned USCIS, and definitely I'm going to talk about the government, but a little later. But before I move into that, I actually would again like to ask my team, because I'm sure you are very busy. And also, I don't know if you get enough time to read all those comments that you get on your social media and also from people all over, basically. So if you can please respond to them right now. So if I can ask the control again to please post the screenshots of those messages and those comments, and we would like to get a reply for them from you.
Sure.
Great. So there is, I can't see the name actually. Okay. Okay, so William said something. He said, "You're fighting the good fight, indeed, Jonathan. Keep up the good work." And I encourage others in that situation to reach out to you. What would you like to say to William?
Yeah, so Bill Stock is somebody I've known for a while. He works at a great firm in Philadelphia, and he's one of the brighter minds in immigration law. So it's good to hear from him.
Amazing. Let's move to the next comment, please. Okay, this is about actually Sridhar's case, so maybe we can take it later. But if we can please move to so Charles is here, and Charles also says, congrats, great work, make them pay. And what would you like to say to Charles?
And Chuck's another person I've known for a long time. A
Okay.
great guy down in Atlanta. Has a really good firm down in Atlanta. But we've been working against stupid government decisions for a long time. He does some litigation in addition to his petition practice. And so a lot of these issues that we're fighting, will bounce off of people like Chuck.
Mm-hmm. Okay. And Roman also says that this is awesome news, Jonathan. Thank you for sharing. What a win. So, and then I would like to read the next comment also. He says, this is incredible, Jonathan, way to go. And so if you can, basically everyone is congratulating you on your big win. And you're going to get these a lot more because you have also had a recent win where you posted, I think, a couple of hours back. So you're again going to get a lot of messages. So if we can get a message for all those people from your side.
Yeah, I mean, it's just don't give up hope is the main thing. Is that, like I said in the post, the government can screw up your life within seconds of making a stupid decision. It's going to take you a long time to fix it, but you can fix a lot of these problems. Yeah. And that's what we do. We're problem solvers. And so, don't give up hope would be the big takeaway, I would say.
Okay. Thank you so much. Thank you so much for the lovely message, John. Now, I would like to come to my next question, actually. So about the H1B case that we were discussing, before we took the comments. So if you can please talk about who are the plaintiffs involved in this case and how did you decide to represent them? And are there other attorneys also involved in this case?
Yeah, so you're talking about the Narambalata case in Seattle for multiple registration.
Yeah. Mm-hmm.
Yeah, so I'm doing that case with Jesse Bless. Jesse also worked at the Justice Department. We were there at the same time. Mm-hmm. And then he got out, was in private practice, and became the litigation director for AILA for a while. And then we've been collaborating on cases now for 2.5, 3 years. And so we looked at the issue together, and we thought we had what was the better argument in the winning hand, and just went to work on it. The plaintiffs are all just recently selected H1Bs that had their cap numbers revoked, and they're all from all over the country, really. But the lead plaintiff was in Seattle.
Okay. All right. Thank you so much for giving the information about, the other attorney and also. John, can you hear me?
I can. You cut out for a second.
Okay. Am I back? Can you hear me now?
Yeah.
I'm so sorry about the lag. We have a lot of things going on. I don't know why it's happening, but I'm really sorry about it. Glad to be back. So, so I was saying about, thank you so much for talking about Jesse and also about, the case. So now I would like to know from you that what specific legal grounds did you base your argument on this recent H1B case that you won?
So the Administrative Procedure Act, like we were mentioning before, is the rule book that the government has to follow. And when they make a rule that they intend to use to punish people or sanction people, there's a very particular process they have to go through, because you've got to put the public on notice of what they want to do, what their proposed rule is. And then they have to let the public have enough time to analyze it and provide thoughtful comments.
Mm-hmm.
After they receive the comments, they go back and they excuse me, they go back and analyze them and decide if they should change the rule in accordance with some of the comments, but they have to respond to the comments as well. And so they went through that rulemaking process when they created the new system in the lottery. They went through that rulemaking process when they tried to change the way the lottery was structured to give better chances to people with higher wages.
Mm-hmm.
And then that one obviously got kicked out of by the court, and so is no longer in effect. What was interesting though is in both of those cases they were very clear that they had to go through rulemaking, and if there were additional changes that had to be made, the agency said we will go through rulemaking. But they didn't. And so what they did is when they realized that they had kind of screwed up,
mm-hmm.
they made a quick fix. They cut some corners, and they made this rule that they knew full well that they would be using to punish people and sanction people. And they didn't do it the right way. They didn't give public notice.
Mm-hmm.
So if you think about it, the only people that really saw this was the admin staff that were filing all the registrations. If collusion would occur, presumably it's going to be at the executive level. And so the admin staff filling out the forms isn't going to know. And so they're not on notice of what happened. And the executive staff who, made the decisions never knew ahead of time because the agency never published it in the Federal Register. So I think that violation of the notice and comment rulemaking is going to probably what gets us there.
Okay. But this must have taken a lot of strategy and a lot of planning from your and your team's end, right? From your and Jesse's end, especially. And so how did you and your team actually prepare for this battle? If you can also walk us through that. And were there any key legal concepts or strategies you relied on, or were there any precedents from past cases that influenced your strategy?
Yeah, so one of the interesting things is the Supreme Court 2 years ago came out with a ruling that said merely posting something on a government website is not an adequate substitute for notice and comment rulemaking. Mm-hmm. So that case for us is very helpful, put it that way. But in terms of the meat of the argument, a lot of research. I couldn't tell you how many hours I spent looking through old versions of the regulation, looking at the comments that were made during the rulemaking process for multiple different rules that impacted the lottery, and just looking for those small nuggets that will help the case. Mm-hmm. And we put in the time, we put in the work, and I think we have a good case on this issue.
Okay. And, now that we are speaking about the preparation, so was it like putting together a one-page complaint, or was it more like sorting out through those thousands pages of legal document? What exactly goes into, preparing a case like this?
I wish it were a one-page complaint. My life would be so much easier.
Right.
I think this one ended up being 40 some odd pages.
Okay.
So what you have to do is you have to look at the facts for each individual plaintiff, collect all their documentation, go through it, make sure that everything lines up, mm-hmm. and then you have to go through and you write your arguments. You put the facts of what happened, you put the details about the plaintiffs, then the background for the law, and then why the government violated the law. And it is a lot of work. To be honest,
I'm sure.
It's a lot. And so, it's something that when done right, it takes a lot of effort.
Wow. And how much time did it take for you to prepare those 40 pages document?
Well, so if you include the research going into it, probably 3 or 4 weeks.
Okay. Wow.
Yeah.
That's a lot. Okay. And now that we are speaking about the timeline, can you also talk to us about how much time did this case actually take from filing the complaint and everything, and then actually winning it?
So that there is one thing in the timeline of litigation that we can guarantee or predict with some certainty. Mm-hmm. And that is, once you file the complaint, the government has 60 days to review it and decide what they're going to do. Mm-hmm. A lot of times in that 60-day window, they will change their decision, issue a new approval notice, and go on their way. That has happened in one of the multiple registration cases so far. So if it doesn't resolve by the 60th day and they don't settle the case, mm-hmm. then they do one of two things: file a motion to dismiss or an answer. In the Rambalata case, I filed a motion to dismiss, saying that the court didn't have the authority to hear the case, basically. And so we responded to their motion to dismiss, and then they filed a reply brief, and it was with the judge for probably 2 to 3 months. Mm-hmm. So from the start of filing the complaint to a decision on the motion to dismiss was probably around 6 or so months, I think, as I recall. So that timeline was long. Now we move on to, they have to file an answer, mm-hmm. and they have to produce the administrative record in all of the plaintiff's cases. Mm-hmm. And so we will brief summary judgment using those administrative records. And summary judgment is how the court's going to make its final decision.
Okay. All right. Okay. And John, also, if you can talk to us about what actually motivated you to challenge the government's action, in this specific case.
It really kind of offends my conscience that they would punish people for the actions of another person. Mm. And we see that happen over and over again. They blindside the employees and make the employees pay for the actions of somebody else. Mm-hmm. I noticed that when I was working in the government, when it comes to H1Bs, the entire enforcement mechanism is geared towards hurting the employee, and they really don't have any plan or coherent strategy for dealing with employers. And so, it just, to me, it just seemed unethical and wrong that they would be doing this. Mm-hmm. And anytime you get annoyed or pissed off, you tend to work harder. And so that kind of helped dig into the case.
Okay. But then, John, also I would like to know from you, you have been on the government side for, defending them for the longest time also, right? So, but then now you have taken the plaintiff side. So what actually made you decide this shift?
So frustration, really. Just frustration dealing within the agency. Looking at the law, saying we're wrong, if we get sued on this, we're going to lose, and the agency really not caring. Mm-hmm. They were more concerned about the efficiency of their processes than they were about getting it right. And this whole issue of notice to beneficiaries who are about to be punished highlights that issue. It would be too much work for them to actually follow the law and give notice. So they do shortcuts, and they think that they can get away with it by not giving the person notice that deserves it and save some money and time by doing it that way. And hopefully that will change as a result of these suits.
Mm-hmm. Okay. But then, John, also I would like to know from you, it's no secret that taking on the government in a legal battle can be, intimidating for many people, right? And so there's often a fear that, they might get into trouble or face repercussions, right, for challenging the authorities. So if you can also talk to us about this common concern that people normally have, and what advice do you have for those individuals who may be hesitant to take the legal action against the government?
Mm-hmm. So the first thing to keep in mind is anytime you're suing the federal government, the rules are stacked in their favor. So you start off right off the bat with the government having a head start or a lead in the case. And so you really have to outwork and outthink them in order to win. So I would say probably the government wins more than 60 or 70% of cases that they litigate fully. So just understand that it's not a guarantee, it's not a walk, it's something that's going to require a lot of work to get done. But in terms of the actual employees, I think the best way to answer that is with an experience from when I was in the government. I would look at potential litigation cases at USCIS and the AAO, and there would be nothing in the file that would suggest that the petitioner was going to sue or do anything in court. It's just what's that?
Yeah. No. Please go ahead.
Oh, so with the AAO, I'd get these potential litigation cases, and there would be nothing in the file that would suggest it was a potential litigation case. It was just a regular appeal. And what made it a potential litigation case is the company had sued before. At that point in time, there was like 12 lawsuits a year on H1Bs. And so it was very rare. And somebody had sued before. It was everybody's memory of that happening. And so a potential litigation case was code for don't deny this if at all possible, because we don't want to have to do the extra work the litigation causes. And so I know a lot of people think that the government will retaliate against them or like seek them out and punish them. For the most part, I don't see that. For the most part, I see if you're annoying to the government, they try to leave you alone because they don't want to deal with the extra work.
Okay, but John, I also would like to know that is it even legal to sue the government? Because it sounds like a plot straight out of a legal drama.
It's not illegal to sue the government, but it's illegal for the government to retaliate. And so if they do retaliate, there's things called Bivens actions, which allow you to sue whoever was responsible for that decision. If you can prove that it was done illegally. And that's one of the few areas where you can actually get money damages as a result. But typically, it's very difficult to find that type of evidence that they targeted somebody. I think empirically, just looking at it, I don't really see it happening. I see most of the time when the government loses an issue, they change their decision, they issue a new approval, and that's the last we hear of it. And so I'm not terribly concerned about retaliation for people that sue the government. If you think about it, I know cultural differences exist.
Yeah.
Our American culture is far more confrontational, and we are far more disrespectful of authority, and our law kind of reflects that. The Administrative Procedure Act basically just invites the public to sue the government if they don't like what's happening. And so lawsuits for government employees, it's not a personal issue for them. It's just the cost of doing business. It's the way the system was set up. And it's something they kind of expect.
Okay. And, now that you have mentioned cost, so I would like to talk to you about cost as well, because many viewers, I'm constantly getting these messages from people on LinkedIn, YouTube, and also on my WhatsApp as well. So people are really wanting to hear some suggestions and answers from you. But before we move into viewers, I would like to actually, take all of my questions. So, yes, I was talking about cost because you mentioned that. So, many viewers here might be wondering the financial implications of taking legal action against the government, right? So if you can please break it down for us.
So the downside is that when you sue the government on these cases, you can't sue for damages. You can't sue for money to recoup the loss that you suffered because of their stupidity. So that's unfortunate, because a lot of people have to wait months and months and months without a visa, without work, before they get restitution. But they never get full restitution, they just get their visa back. And they pocket for living expenses for months. The only way you can get money back out of the government is if they fight the case tooth and nail all the way to the end and lose. And then the judge has to find that they were unreasonable in their defense of the case. If that happens, then you can get your attorney fees back. Probably, depending on how much is spent and how much the court awards, you may or may not cover all of your costs. So that's the expense. On the plaintiff side, it really depends on the type of case. If it's a case that we've seen and done before, that helps. It gives a little bit of a head start, and it makes things a little more cheap. But on a case that comes up that's an oddball issue that we've never worked on before, those are going to be a little bit more expensive.
Okay.
Yeah, there's also a difference between group cases and individual cases. Those oddball issues tend to be individual cases. And then the group cases are things where we're taking on a practice, procedure, or policy of the government that's impacting a whole bunch of people. In a group case, we can put them together and get economies of scale and then bring the costs down. For the individual cases, there's really no economy of scale because we're probably going to work that issue and never see it again. And so that's why those ones are more expensive.
Okay. All right. Got it. So, you also said that the government chances of winning is 60 to 70%. And, but then people, if you connect with John directly, so maybe the chances of government winning goes down and your chances of winning, gets high. So if you directly want to reach out to John, so what you can do is you can give him a call at his number, which is +1 703 2168 8148. His email is john@wasden.law and his website is wasden.law. And yes, you can reach out to him through these details. And John, also, I don't know if you got a chance or not, but there were a couple of articles also written about this. So I saw Times of India writing an article about this, and also Economic Times. So if I would like to ask my team to, if you can please show those two articles here on the screen so that people can also have a look at those articles. Yes, here they are. One is from Economic Times, and there were so many actually, but I chose these two articles, Economic Times and Times of India actually. So they covered this whole case and they talked about it. So John, Lubna Kalbi was the journalist who wrote, I think, on Economic Times. So I'm sure you must be really busy, and I don't know if you got time to go through these articles or not. But do you have any message for them?
Yeah, so I've dealt with Lubna on several cases where we've talked about our court wins and court developments, and I read her stuff all the time. She does really great reporting.
Great. Thank you so much. And also, John, but there are many viewers who also must be wondering that how exactly is this case going to benefit the H1B community and our viewers? So can you give some insight into the broader implications of your this recent victory?
Yeah. So assuming it catches on nationwide, we will probably have to fight the same issue in multiple different courts across the country in order for it to be a fixed and binding situation. But what it means is that they can't go after your cap number. These teams that are around looking for reasons to revoke a cap number a few months before your visa is current, that's not going to happen because they have to give you notice and an opportunity to respond if we're ultimately successful in this issue across the country. And you won't get blindsided by that. And that'll be a big benefit. A lot of extra security for everybody that's in the situation. And so, yeah, the frustrating thing is for those folks, that get blindsided with a cap number revocation. Even if they were to have found out about it ahead of time, the government wouldn't allow them to respond. They won't accept anything from the beneficiary. And then, a lot of these things are 12, 13, 14 years old. And, good luck getting information or evidence who keeps things that long to show that, the government's wrong. So it's a very stressful situation for folks. I think the fact that the government has to give them notice, or will start to have to give them notice, means the government will be doing less of this because of the workload.
Okay. But does this also have any relevance to the companies? In the interim, there was another problem, John, where companies have put start dates beyond October 1st. So for the viewers, let me tell you, when the H1B is picked, they have to file. When the H1B is picked and they have to file, it starts from October 1st. Even we have done, one starting January 1st of the next year, and they have denied the application actually. And later they came up with a new rule stating that no, it was incorrect, and whatever. So for those who may be facing similar challenges or need legal assistance, how can they reach out to you, and how can you help these people? And also, what kind of support can you offer to individuals in similar situations? And okay, maybe I can take this second part of my question after you answer this first part.
Sure. So anybody that's in a situation where they're facing an adverse consequence because of government action or procedure can challenge it in court. So then the screw ups in the mailroom that you're referencing, the denying cases because of the date incorrectly. And also another thing that we see kind of commonly is USCIS revoking things, saying that they sent out a notice of intent to revoke that was never responded to, but the employer never got it, the attorney never got it, nobody ever received any type of notice. And so a lot of times also the flip of that is they get the notice, they send in the response, and the government loses it and says, you never responded. Those cases are very easy to win. We file suit on that, and they usually resolve very quickly, especially when the employer or the attorney has, shipping confirmation that it was sent. And so that's a common scenario, unfortunately.
Okay, but then what are the services for the companies? And then,
So for companies, we do site visit defense. We train their employees on how to deal with FD&S. It's no shock to anybody on H1B that FD&S has become more and more aggressive, and one might say rude as time goes by, and their numbers have been increasing. So, in 2018, they had 800 employees at FD&S, and now I think they're getting close to 3,000. And so, we train the employees to handle site visits that are almost certainly going to happen. But the employers, when they have an issue that affects them all, they will go to court, usually under the IT-Serve organization, because IT-Serve can sue the government on regulations and clear, explicit policies that are out there on the behalf of their companies. And that's usually the most efficient or streamlined way to do it.
Okay. All right. Thank you so much for that, John. Now, before we, move into our second case, which is about Sridhar Aluwala, I would like to take a few comments from the people because I'm getting a lot of comments, actually. People are really looking for your guidance here. So let's just take Oluyinka. I hope I'm taking the name right. And he has posted on LinkedIn. And Oluyinka says, what guidance can you offer to Nigerians in the field of software engineering who aspire to relocate to the United States, particularly those who have faced multiple visa denials at the embassy? What do you have to say?
You got to find a petitioning employer that wants to hire you and have them put in for the lottery for the H1B. I mean, that's really your only option. Once you get an H1B, you should be fine, because one of the big problems that they have from people coming from Africa on other visa categories is the intent. You have to have a non-immigrant intent when you get that visa, meaning it's a temporary situation and you're going to come back to your home country. Far too many people can't show that they have a non-immigrant intent and that they don't actually want to permanently immigrate. The H1B doesn't have that requirement. It's a dual status visa, and so a dual purpose visa. So the H1B would be your really only option, I think, or your best option for getting into the US IT market.
Okay, so Olenka, I hope you've got the answer for your question. If you have any more questions, please let us know. Please post them. And thank you so much for joining this live session. So John, now let's take another viewer question. This is from a viewer called Empire, and Empire wants to know. Let me get the rules straight. So they can revoke the employer's petition for fraud, but can't revoke the cap number that was gained from the fraud once the employee is not involved.
So yeah, that's our argument, is they can't revoke the employee's cap number unless the employee is the one that committed fraud. And the government has to establish through evidence that it was the employee that actually committed the fraud.
Okay, and he also has a follow-up. So he is asking, I think, 2 or 3 questions. Let's take all of them. So second, he wants to know, unfair to lose your cap number because of someone else's bad action. It's also unfair that those employees benefited from this at the expense of an employee and employer that has done it correctly. I think there is a second part to it. And he says, the government needs a better system because someone else lost the opportunity because of that employer's fraud. What do you have to say?
Yeah, they did come back and they changed the way they did this year's lottery. And so what's funny is the way they restructured the lottery for this year is almost identical to the way that it was suggested in the comment process back in the 2019 rule. And so the government could have avoided this whole thing if they hadn't been in such a rush to push out a new regulation changing the lottery. But because they were in a rush, they didn't really want to do any work at the last minute to change their rule and their regulation. So the new regulation that came out went through the rulemaking process, prohibited, well, it didn't really prohibit multiple filings, but it took away any incentive for multiple filings. So now if you have 20 different people, 20 different companies registering for you, you're still only going to be in the lottery that one time. And so that has really kind of made things more fair, and it hasn't it's killed the situation that was in the news so much the last few years of the lottery.
Okay, all right. So John, I'm constantly looking on my WhatsApp as well because I'm getting a lot of messages from our viewers on WhatsApp too. But before I move into the WhatsApp viewers, I would like to take this next viewer question, SPK24, and he says, how will that work? They may start giving the employees notice which they can't respond. What do you have to say?
So, it would just depend on the notice and what they're alleging. If they're alleging that the employee did something wrong, that's something that's easily addressed. If they're alleging that the employer did something wrong, well, that's on the employer. They can lose their right to hire and employ you, but you still keep your cap number. And that's what we're shooting for.
Okay, all right. So SPK24, I hope you have got the answer. Thank you so much for your question. And also, please let us know where you're watching this live session from. And thank you again. And don't forget to subscribe to the channel. And let's take next question. And this is from Anushka. And she says, what proactive measures can individuals and employers take to minimize the likelihood of encountering legal hurdles in the H1B visa application process?
So the first thing I would say is be very, very careful anytime you're dealing with FDNS.
Mm-hmm.
And honestly, I would say you shouldn't talk to FDNS unless you're doing it through your attorney or your attorney's present. We've heard all kinds of horror stories about, FDNS people coming in, yelling and screaming and threatening, making threats they really can't make good on, but telling people you have to, give me a statement saying you did this or you're going to get your visa revoked. And so people get scared. People sign away their life basically in that situation, and they get taken advantage of. But the FDNS officer gets to write a great report and look like he's a hero. So if your attorney's there, that whole scenario is avoided. If your attorney's on the phone or they're present, the FDNS officer can't be an aggressive ape, basically. And so they have to control themselves, and that helps you. The other thing is, don't respond to their emails. Have your attorney respond to the emails. Anything that you say to the government could conceivably be used against you in a fraud finding. Anything your attorney says on your behalf can be attributed to you. And so you want to definitely avoid any type of fraud finding against you, and you want to avoid any communication that would lead to a revocation of your visa.
Okay, all right. So Anushka, I hope you've got the answer for your question as well. Yeah. So Anushka, thank you so much for your question. I hope you've got the answer for your question as well. So thank you so much, all the viewers, for your lovely question. I know I still have a lot more questions that I need to take. But before I move into that, John, let's quickly shift our focus to the case of Sridhar Aliwala, and which is truly a tale of injustice and confusion, right? Because firstly, John, okay, before I talk about anything else, I would like to know what exactly is Sridhar is being accused of, and from what we understand, he seems to be caught up in a mess that he had no part in creating.
Yeah, and the government's even admitted that. The government in court has admitted he didn't do anything wrong, and so it begs the question: why are we still here? Why are we still fighting?
Right.
I think that's another case where I'm optimistic of our chances for success. We've briefed summary judgment. Now we're just waiting on a court to make a decision. What happened in that case is they revoked his initial H1B without giving him notice. And 12, 13 years down the road, they try and kick him out of the country because he doesn't have a visa. Thankfully, his spouse is an H1, so he's able to switch to H4. But, that's kind of their game plan, is they want to eliminate as many H1Bs as they can. In his particular case, what they were alleging was that the work location on the LCA, that initial LCA, didn't match with where he actually worked. So you can have multiple LCA or multiple locations on one LCA and work at any of those locations, and then the employee has to be paid based on that location. What they didn't provide us in the evidence was that initial LCA that could have corroborated that he was actually working in the right location. So all the way back when he was on OPT, he had a project. He is working for, it was a major bank in the US, and then he gets selected for the lottery and then keeps that project with his new employer. So it's entirely likely, and I would say more likely than not, that when they filed the petition, they listed both the company headquarters and the client location on the LCA. And the government never provided the evidence that they didn't. And so that, I think, is going to be an area where they're going to have some problems.
Okay. All right. I mean, if the government, they themselves accepted it, so, we can only be hopeful that
Yeah,
you're also going to win this one. But John, also, I would like to know that, it's puzzling to hear that they are digging up records from as far back as 2010, when Sridhar wasn't even involved in any wrongdoing. And can you please explain why they are going so far back, especially when there are no legal requirements to keep records beyond 7 years?
yeah. It's something that started under the Trump administration.
Okay.
So, yeah, the Trump administration really kind of kicked off the explosion of FDNS,
Mhm.
and they needed work for these guys to do. What they actually did is they went back and they rehired a whole bunch of old employees that had retired as
Mhm.
contractors to go through all of these cases and look for any reason they could to eliminate people's cap numbers. The the weird thing about administrative agencies is the president comes in, he gives a little bit of direction, but what the president does, the policies he creates, tend to outlive their presidency. And so Trump came in, he really weaponized USCIS. He tried to make it more into an immigration Gestapo. And that mentality within the agency has not shifted back, even though there's a new president.
Mhm.
And I don't imagine it will shift back anytime soon.
Mm. Okay, okay. All right. But thank you for answering the question, John. But also, it's mind-boggling to think that Sridhar's entire life and career are being upended over something that happened over a decade ago, right? And
Yeah.
with his visa now at risk of revocation, what does the future hold for him? If you can please also talk about that.
So luckily, his spouse has an I-140 and will be able to apply for a green card relatively soon. So he can stay on H4. But
Okay.
I've had other clients that have had to leave the country because they don't have any status to go into.
Hmm.
So it's really unfair that you've got somebody working in a government office who has no understanding of what you're doing for your job.
Mhm.
You know, basically taking pot shots at you and your history on things they don't really fully understand. And they have a lot of ability to mess your life up very quickly.
Yeah. Yeah. But is he protected in this situation? And how is your team it, ensuring that his rights are upheld?
So I think we'll be successful in getting his initial H1 reinstated, or the government will be enjoined or stopped from saying that he doesn't have an initial H1.
Mhm.
So I think we'll win on that issue because the record just doesn't support their decision. And if he has his cap, no problem. As long as he has that cap number, he's fine.
Mm. Okay. Okay. All right. Well, I'm glad to hear that. But here's a burning question on many people's mind, John. So, while this legal battle is being fought, can Sridhar continue to work? And how are you planning to assist him in obtaining a work permit during this uncertain period?
So ordinarily for plaintiffs, if they don't have another status that they can change into that allows work authorization, once they lose their status, they can't work, which is obviously a huge strain on them because they've got to pay out of pocket while the case is being resolved. So if you can move into say like an H4 that has an EAD available, there will be a temporary disruption in your life while you're waiting for the agency to process the H4 and EAD, but you'll still be able to stay in the U.S. legally and work legally
Mhm.
while the case is being resolved in court.
Okay, understood. But John, also given Sridhar's cooperation with the government and his innocence in this matter, could he potentially fall under another visa category that provides him with some form of protection? Like, for example, does he qualify for the U visa considering his cooperation with the authorities?
Yeah, so there's the U and the T visa that conceivably he could qualify for.
Wow. Okay.
Yeah, the the T visa is an interesting one. It's for victims of labor trafficking. And what the government's alleging basically in his case
Mm-hmm.
would potentially qualify as labor trafficking. So it's possible, but my guess is, just knowing the agency, those types of petitions for H1B workers will face a lot more scrutiny than any other type of petition.
Mm-hmm. Okay. All right. And John, also, I saw your LinkedIn post about Sridhar's case, and there, when you mentioned the whole thing, at the end of your post, you wrote it is going to be a long wait, and you extended on the word, you actually emphasized on the word long. So,
Mhm.
I would like to know from you, can you elaborate on what factors contribute to this prolonged wait, and how do you and your team plan to navigate through this extended period of uncertainty for Sridhar?
Yeah, so right now we're at the stage where all we can do is wait. So all of the work on the case has been done, and we're just waiting for the judge to either hold a hearing and ask us questions or make a decision. And one of the nice things about being a federal court judge is you have lifetime tenure and can't be fired. So they can move at their own pace. And
Okay.
so, there's really no prediction on when the court will actually make its decision.
Well, hopefully soon. Let's hope for the best. And I mean, given that the court has already said that he's innocent and he has nothing to do with it, so maybe let's hope for a victory of yours soon on this
Yeah.
case as well. Okay, so lastly, John, about this specific case, can you share any insights into the broader implications of this case for other individuals, facing similar challenges with their visa, and how can individuals in need of legal assistance reach out to you for help in navigating through, such turbulent times?
Yeah. So the first thing I would recommend that everybody do is
Mm-hmm.
keep everything. Keep all of your records. Be very meticulous, because if you need them in a crunch,
Mm-hmm.
unexpectedly you get a notice of intent to revoke, you'll have the information that will be helpful in responding to that. So just document, document, document. Should
Right.
have everything you scan it all and have it on someplace on the cloud that you can access it for the rest of your life. In terms of working with us, my website has a scheduling app. If you want to schedule a time to talk, you can do that.
Okay, and everyone, his website is wasden.law. So if you want to schedule, you can do that by clicking on his website, which is wasden.law. And if you want to give him a call or send him a text or even WhatsApp message, his number is +1 703 216 8148. And you can also write to him on his email, which is john@wasden.law. All right. So, John, also, there are a few questions I would like to take before I let you go. I know you must be really, really busy, but I just would like to take, one or two questions before I end this session. So, Ashwin Daljit is here and he has a question. Can you discuss any recent precedents or trends in H1B visa litigation that applicants should be aware of?
So the main thing that we're pushing right now is notice to the impacted person. It's coming up in a couple of different ways. One is the multiple registration cases. One is the revocation of the initial cap number years ago.
Mm-hmm.
And then the other is the OPT scam companies, the scammed employees or students into paying them for training and then never doing anything to get them a job. So all of those cases share a common element, which is the government never gave them notice before punishing them, basically.
Mm-hmm.
And what we're fighting for is to give everybody a fair shake and a fair shot at resolving or answering the agency's questions before they get punished. And I think we're on our way there. The case in Seattle, I think, is huge because it says that the employees can sue. And if they can sue, really they're entitled to notice and an opportunity to respond at the administrative stage.
Okay, all right. Thank you so much for answering the question, John and Ashwin. I hope you have got the answer. And one more question I would like to take is of Rajesh. I actually had taken screenshots from Reddit and Quora so that I can ask you questions from, people commented actually a lot about these H1B frauds. So I just wanted to take that, but because I know, you're really busy. So maybe in another episode, maybe. But for now, this question. How Rajesh is saying, how can you effectively challenge the government's exercise of discretion in denying an H1B petition, particularly when the denial is based on a subjective determination that, can we have the second part, that the petitioner does not meet the specialty occupation requirement? And what legal arguments and evidence can you marshal to demonstrate that the government's decision was arbitrary and capricious?
Mm-hmm. Yeah, so when we're dealing with specialty occupation cases, that was an issue we fought years and years ago, and it's been successfully resolved. It used to be you would file your petition, and these USCIS employees who had no understanding of IT, software engineering, or any of that would make a decision as to whether or not your job qualified as a specialty occupation. Now, keep in mind, most of these people couldn't figure out how to map themselves to a printer. And that's how computer illiterate they were. But they were making these decisions that, you don't qualify. So they were really kind of twisting some language. And the Department of Labor's resources that kind of define occupations within the United States. The arguments in court went pretty well for us, which were, the Department of Labor said this occupation requires a degree in this specialty and this knowledge. Mm-hmm. The job that they offered requires that same degree and that same knowledge. Therefore, it meets the criteria for specialty occupation. The court really almost mocked USCIS's analysis and rationale for their denial on those cases. And now it's become much more simple and much more streamlined on the specialty occupation analysis. I think USCIS is trying to muddy those waters again with a new regulation, the modernization of the H1B. I think they're trying to bring back a lot of those murky standards. So we'll probably be fighting the same fight all over again.
Okay. All right. So thank you so much, Rajesh, for your question. Don't forget to subscribe to us. But one last question, John. One last question. I don't want to, miss out on this opportunity because I know you're really busy. So one last question I would like to take from the viewer. So Nancy wanted to know something, and she said, in what ways can skilled immigration contribute to addressing labor shortages in specific industries or regions? What role do social networks and support systems play in successful integration?
So, I think the answer to a lot of the country's problems is increasing high-skilled immigration. I personally want to live in a country that has the smartest people in the world, and we're starting to slip on our lead for that. And we need to bring in people. The frustrating thing is Congress is not going to do anything to fix a well understood problem. The immigration is broken for high skilled people. Mm-hmm. It's just not working right. And USCIS, for its part, has zero desire to change anything that they're doing. And so, you can advocate for change, that's great. But until Congress actually gets their stuff together and comes forward and does comprehensive immigration reform, it's just going to be ugly.
Okay, well, If Thank you so much, Nancy, for your question, and thank you so much, John, for answering. And there are a lot more questions, but I know you're really busy again. I would like to say this again and again because, this show was supposed to be for an hour, but then we extended. So thank you so much.
Mhm.
Uh, yeah, thank you so much for that. And unfortunately, viewers, that's all the time we have for the questions today. But don't worry, we will try to bring John back for another episode, and where we can discuss more about these cases, because you also have, like I said in the beginning, you had a recent win where you posted a couple of hours back about that, right? So maybe we can discuss about that too. Thank you so much for your time, John, and everyone. If if your question didn't if we didn't take your question, and if you directly want to reach out to John, what you can do is you can connect with him on his number, which is 703-216-8148. His email is john@wasden.law, and his website is wasden.law. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my email, which is rajni@higherightpeople.com. My number is +1 732 707 9151, and you can also visit our website, higherightpeople.com. Remember, we also sponsor H1B visas and green cards. And that's a wrap for today's show, folks. So we have covered a lot of ground exploring the triumphs and challenges within the legal world, with John by our side, from Victoria's H1B visa case to the ongoing saga of Sridhar's fight for justice. And it's been an eye-opening journey. So before we sign off, I want to extend a heartfelt thank you to you, John, for sharing your insight and your expertise with us. Your dedication to upholding the justice is truly, truly inspiring.
Well, thank you. It's good to be with you again.
Thank you so much for saying that. And to our lovely viewers out there, thank you so much for tuning in. And remember, if you find yourself facing legal hurdles or seeking guidance, don't hesitate to reach out for help. You already have John's number and his contact details. So we'll be back with another episode and another live session at 12. So just don't forget to stay tuned, and don't forget to subscribe to Immigration and Jobs Talk Show. But for now, I'll have to take your leave. I'm Rajni Barara signing out for now. Let's meet soon.
Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higherightpeople.com or visit our website www.higherightpeople.com.
Hello, everyone, and welcome back once again to Immigration and Jobs Talk Show. I'm feeling great to be here today on a Friday and looking ahead for a very, very long weekend. But before we get to all that excitement, I would like to tell you that I'm Nipasa Pradhan and I'm going to be your host for today for an hour or so from now. And I'm thrilled to have you join us, whether you're watching us on YouTube, LinkedIn, Facebook. Thank you so much for joining. And let me tell you that this is going to be a very participative session as well. So feel free to put your questions in the comments. And
oh no.
you agree and understand that the information, including comments and replies from users, is not legal advice. Use of information is at your own risk. So thank you once again, friends. Thank you for joining us. And yes, this is Immigration and Jobs Talk Show. And I think without further ado, like I was telling you, we're going to have a very intriguing session today as well. So our topic for today is curious about H1B visas. So if you have any questions about H1Bs, you are on the right path, on the right track, because we are going to have our guest join us today, none other than attorney Justin Rivera. Please help me welcome him back here. How are you doing, Justin? Thank you so much for joining us.
I'm doing all right. The weather's a little bad here, so I'm just giving you a heads up. So if there's any connectivity issues or anything like that, it's because of there's a thunderstorm rolling through right now. But hopefully that doesn't create any problems. But other than that, I'm having a great Friday.
Me too, and I'm excited for the long weekend.
Mm-hmm. Absolutely.
All right. Yes, yes. And so, Justin, dear friends, he is an employment based immigration attorney. And, he has been working with Wasden Immigration and Litigation. So, how has it been so far, Justin, with
It's
Wasden?
It's been great. I think finally settling into the role, which is nice, and really enjoying it. Working on different cases from what I used to work on at my former employer, so it's nice to see a bit of variation, and everything's different. At least I feel like I get a lot of different kinds of cases to work on, and I'm enjoying that. And I'm enjoying the challenge.
Great, great. So good to have you here today as well. And I'm looking forward for this whole intriguing session full of exciting discussions and I'm sure questions also. So let me tell you that this is an Ask Me Anything session. So friends out there, you can ask Attorney Justin Rivera anything that you have, especially with regard to the topic, and that is H1B visas. So before we dive into the discussion, it's important to also acknowledge the latest updates in the immigration world. So, Justin, maybe if you have anything to give out before we start off with the questions.
Yeah, I mean, not a whole lot, and for me at least, I would just, just kind of speaking on what I've been working on recently. I've definitely seen quite a few issues coming up with people's STEM OPT applications, with issues with violations of their OPT status at their former employers. So, obviously you need to be cognizant of those 90 days of unemployment for your OPT status and how failing to adhere to that can render you ineligible for the STEM OPT extension. I've been seeing a couple of those cases come in. And a couple other things I've been working on, just generally speaking, and really this actually kind of ties into the H1B stuff today. So I very recently saw someone, and I think that this is important to discuss because they were actually all the way at the end of their immigration journey, where they're scheduling the I-485, where they're attending their I-485 interview, and during that interview, they actually ended up telling admitting, because it's what happened, the officer, that they had actually been working from home. And the issue with that was that home address was not covered on the labor condition application. It was not in the LCA, and it unfortunately was not in the same what's called metropolitan statistical area, meaning that it was not technically permissible employment. So this person, they didn't realize it. I mean, this person was completely guiltless. They never got a copy of their LCA from their employer. And they never realized that their end client, when authorizing them to work from home, had not talked to the employer about it. So this person had been working for years, 4 years, a full H1B and an extension, not realizing that they were completely violating the LCA. And so they go for their I-485 interview, and they ended up getting a notice of intent to deny. on their I-485 based on the idea that they had violated their H-1B status for a period of more than 180 days. And it's crazy to think about, imagine you wait all that time in that backlog to get to this point. And, the process can be messed up as a result of a mistake that you didn't even realize was a mistake. And so that was just something that really makes me think that we need to do a better job of ensuring that the non-immigrants here in the U.S. that are going to be on H-1B status, that they are aware of these pitfalls, of these issues that could occur. So, I mean, always you're entitled to a copy of your labor condition application as a right. Failure to do so is failure to comply with DOL by the employer. So always make sure that you have a copy of your LCA if you're an H-1B employee, and make sure that you are working in the area that you say you are, because it can come back to bite you. I mean, this person had no idea this was going to be a problem for them. They were just saying what they've been doing for the last few years, and now they're staring down the barrel of a notice of intent to deny that adjustment of status.
It's crazy. And you deal with all these sorts of complicated cases very regularly, Justin. So I wonder, what do you do, to keep yourself sane, mentally? I mean, apart from your own life and everything, you also have these things to solve. So what do you do?
Just long walks with my dog.
That's lovely.
It's a way to think.
Discuss your cases with him?
Yes, we frequently discuss the cases, my dog and I.
That's sweet. That's sweet. Well, friends, this is an Ask Me Anything session, and the topic today is curious about H-1B visas. So I think, Justin, I am ready. Are you ready to take up questions?
Sure. Yeah, absolutely. I know we're on a tight schedule, so.
All right. So we have Priya with the first question on YouTube. Hi. While booking for H-1B visa stamping, I answered no for a question whether I held any previous visa other than B1 or B2, which should have been yes. For this, I was not given Dropbox option, but the portal took me to interview option and I was able to book one. I know that it's not possible to change it in the application now. Is there any way I can write to the consulate of this mistake, or will it be a problem while going for an interview for this wrong answer?
So I think if you want to be super careful, what you can do is fill out another DS-160, and just fill out and bring another DS-160 and explain that you're correcting a mistake in a prior submission. I think that's being as careful as possible. Consulates can vary based on what they want someone to do, so you can also try contacting the consulate first. But I definitely think that I think that the safest thing to do would be just go ahead and do another DS-160, correct the error, bring it with you to the interview, and admit it up front that you made a mistake on a selection of something, and then say, here, it was my fault, here's this. And then that's all. Because I really don't think it's that big of a deal, especially if you're admitting up front that there was a mistake that you made in the DS-160. I don't think it's necessary. I mean, don't cancel the appointment and make a new one just based on that, because then you're paying the fees again and everything. So I definitely think that would be the easiest course of action. Just submit a new or take a new DS-160 to the interview, because I don't think they'll let you submit it.
Okay, but it's always important to update, I mean, it's good that you are admitting the mistake, and updating it as immediately, I think, is always good. That way you're safe no matter what.
Yeah, and I mean, it's a B1, B2 visa doesn't carry work authorization with it or anything, so I wouldn't think it's that big of a deal. But at the same time, you do want to be upfront. Consulates are different, but for the most part, the consulates I've dealt with, the officers aren't there to get you, to put you in a situation where they're going to give you a 221G or deny you. They're more so just looking to figure out whether or not you qualify and that you've answered truthfully. So I think it goes a long way to just admitting the mistake up front and then providing a new document to replace the old one.
Cool. So Priya, thank you for your question. I hope you got your answer. And thank you so much, Justin, for taking that out. We have Short. What does the student studying on USA on F1 visa require to convert the visa from F1 to H1B visas? Is that the
Um,
question?
so I think that if I could kind of generally spin this in like, what is it that you should look for if you're an F1 going to H1B? I think
Mm-hmm.
for the most part, that's going to be people who've been selected in the lottery. So if you're selected in the lottery and your petitioner's filing an H1B for you, they file it one of two ways. They can either do change of status or consular notification. So change of status is going to mean that you convert to that H1B status on 10-1 typically, because that's going to be the first date of eligibility for the status. When you file a change of status, that means that sorry, emails. When you file a change of status, that means that your time spent in your current non-immigrant status is going to be reviewed. And so what that means is if USCIS determines that there has been a violation of that status, then your change of status can be denied. Now, the change of status being denied means you can no longer change status to H1B. You now have to depart the United States, go abroad, attend a visa interview, and come back in with an H1B stamp. So it does mean that you need to look out for certain things. If you're on F1 and you're on OPT, you need to look at your unemployment dates to make sure that it hasn't exceeded the threshold, which I believe is 90. And then when you go into STEM OPT, it's a larger number. Don't quote me exactly. I believe it's 120. But you need to look out for those dates because if you have violated that, then you may want to consider filing consular notification rather than risking your change of status being denied and carrying with it any penalty as a result. That's usually the big hurdle that I've seen for F1 change of status. The other thing that I have definitely seen is the day one CPT issue. And just kind of generally touching on that, that's where someone will maybe have exhausted their OPT and they enroll for a second major maybe at another university. There's a lot of universities that I won't specifically name, but I feel they're definitely on a list of day one CPT schools. They're kind of, if I remember right, in Kentucky or around that area. But there are schools that kind of seem like they're day one CPT hubs. So when that comes up, if you're a day one CPT person who's at the same degree level, you might see an RFE where USCIS alleges that you violated status because you shouldn't be doing CPT after OPT at that same degree level. So those are two issues I think that you would need to look at when you're filing your change of status. Hopefully you're working with an immigration attorney that's well-versed and is able to pick up on those issues at that time so that they can maybe advise you against filing a change of status. I know that people sometimes want to hedge and file a change of status and see if they get an RFE and then maybe try to convert to consular notification then. I've seen that work. I've seen it not work. It's really just dependent on what your risk threshold is. I would always say, the safest course of action is the one that carries with it the highest probability of a positive outcome. So I would probably lean towards just doing whatever's the safest. But each person's different and you're going to look at those factors. I think that was a very long-winded answer, but I did my best to kind of make an answer out of that.
You did cover, and I'm sure, short, that was very helpful. Please comment if you have more questions, and even if that was something you resonated, please comment. It'll be good to know. Moving on, let's go on to the next question we have. This is Akash. I have a query regarding attending H1B visa interview for the 2024-25 round. Currently, I live and work in Germany, so can I attend the interview from here and the stamping done, or shall I have to visit my home country? Also, for dependent stamping, which would be the preferred one, and what are the pros and cons for getting done together or separately?
Okay, so I think as a general rule of thumb, the easiest place to go for your visa interview is your home country. Almost always. It's going to be the easiest, the most simplistic course of action is going to be going through your home country. Now, is it possible to go through another country? Yeah, it typically is, and they're likely going to let you schedule an appointment. Third-party nationals, so someone who's not a citizen of that country, they may be kind of put at the back of the queue for scheduling purposes. So you may see an issue when you try to schedule an appointment that it's going to take you much longer than it would in your home country. But you can do it. Now, what is the pitfall of it? The only risk or the scary idea is if your visa gets denied, right? And if you're stuck in that country and it's not your home country. I assume this individual who's living and working in Germany, they're authorized to be there. They have a German work visa or something. I don't know German immigration, so I won't speak to it. But their pitfall would probably not be as big a deal. I think the people who I always recommend going to your home country for are people who are maybe like, I'm visiting country X and I'm going to go for my visa appointment. And it's like, all right, well, if you get denied, what are you going to do? Are you going to end up stuck in that country? So I would say, yeah, you can schedule. I always recommend doing everyone's appointments together. I don't recommend separating people's appointments. Just get it all done at the same time. I don't know if it's a psychological thing or what, but I just feel like when you bring your dependents with you to the appointment, you kind of show, I don't know, maybe the officer is going to be a little more like, oh, okay, inclined to approve that person. So yeah, I mean, I would do them together when you can. I just really don't see a reason not to. If you have to do them separately, it's possible. Obviously, you've got to get your H done first before your dependents. So I would think you'd have to take that into account during scheduling. But yeah, if you can all go together, just all go together. It's much easier to do it. Now, that being said, there are some countries that actually allow people to not bring children that are a certain age, under a certain age. The children are not actually required to attend the appointment. So I would look at the instructions on your visa appointment to see if your kids might qualify for not having to actually physically appear, and you can just bring their passports with you.
So cool. So Akash, I hope you figure out, and thank you so much, Justin, for taking that up for Akash.
Mm-hmm.
Let's move on now to this next question we have from Shruti on YouTube. She's asking for a friend. H1 was filed by current employer. A job is not directly related to the major of study. Would there be any issue during H1 transfers?
Yeah, I mean, it all depends on the officer reviewing the case. But if you have a position that has not had what I like to call a nexus tied between the employment and the degree of the individual. There's no connective tissue there. When that's not apparent, then you can get what's called a beneficiary qualifications RFE. So that's going to be a request for evidence from the service where they're basically asking, how does this person qualify for the position based on their degree? Hopefully you've sussed this out at the outset as a possible issue. The first thing I would recommend, if possible, is look at the actual specific courses taken by the individual and maybe try to explain how those courses give the person the qualifications for the position. Perhaps the position is a hybrid, something that crosses different fields, IT and accounting, business and science, something like that. So that's one way you can tackle it. Another way is what's called a combo eval. So that's where you're looking at combining education and employment experience into an evaluation that shows that the person has, based on the combination of their academic experience and their real life work experience, they have the equivalency of a degree that's in a relevant field. Usually for that, you're probably looking at, it really depends on the case, not to be too specific, but you'd like to have 3 years of work experience, I think, traditionally. Sometimes you may even need as much as 6 based on what the degree is. Again, that employment's going to need to make sense too. It's going to need to be rationally related to what the person's doing. When you request the evaluation, you should have experience letters from an authorized representative of the company who's willing to speak to not only the position and the duration that you held the position, but also, if possible, explain maybe the job duties or projects that you worked on. Because really what you don't want to do is allow the officer who's reviewing the case to look at that evidence that's supplied and be able to poke holes in it and say, well, this is, you said you worked 3 years at Google. You have a letter with a sentence that says this guy worked at Google. What was his position? How long was he there? What were his job duties? Who was his supervisor? There's all these things that they could look at. And you have to understand, with the H1B, once there were the third-party placement memos, once those got revoked, which, just for a quick understanding of that, is, there were memos that came out during the Trump administration saying, if you work at a third party, you got to show proof of contracts, employer, all this stuff, right? When those got revoked, it really kind of made it to where USCIS can only look at, for an H1B, the H1B position, does it qualify as a specialty occupation? And the beneficiary's qualifications. Does the employee qualify? So they're going to look at those hard, because it's really all they can poke holes in at this point. So again, I would definitely say look into getting an eval. Some employers like to wait and see if the case gets approved. That way they don't have to worry about getting an eval unless there's a request for evidence. That's an option. I like to present the strongest case possible up front to minimize the cost of an RFE. I think most firms probably operate in the same vein, where the filing is probably less than the RFE, because the RFE is going to be more tedious and time consuming. I would say, look into getting that eval. I do definitely think that if you're working with an immigration attorney, that's going to be identified prior to filing. I mean, it's not likely that they're going to be surprised when they get the RFE that your degree in business management did not qualify you to be a data scientist. That's it really. Those are really your only two courses of action, and then hopefully one of them works. If you don't have that requisite, I'm sorry, my nose is itching. If you don't have that requisite work experience, you're gonna have to try and tie your education. And if you have a master's and a bachelor's degree, you utilize the totality of it. Pull everything out of both of those degrees to create that nexus, and hope for the best with USCIS.
All the best, Shruti. And thank you for your question. Thank you, Justin, for taking that up.
Sure.
Now, this next one is from Mahinder, also on YouTube. I am a Canadian PR and Indian citizen, but my H1B got picked and approved. Do I need to travel to India to get it stamped from US consulate office, or can I look for an appointment in Canada's US embassy, say Toronto, Vancouver, Ottawa? Also, I have USA visitor visa. Can I travel to USA on a visitor visa next month and do a change of status to H1B after October 1st?
So I wouldn't recommend the second course of action, just generally speaking. I would, since you're outside the US, I would just go ahead and get your H1B visa stamp taken care of. The same issue I think that comes up with the individual who's in Germany, I think applies here to the Canadian as well. I would see if you can schedule a visa appointment in Canada, and if possible, see if you're able to schedule one. I think you should be able to. And then I would just go to your appointment in Canada. My one thing would be, I'm not super familiar with the wait times there, and I don't know if there's going to be a difference for you as a result between how long it takes to get an appointment in Canada versus in your home country. So I would just look at that. But I think I would just go ahead and try and schedule a visa appointment in Canada and see if you can get it done. Unfortunately, what's frustrating about scheduling your visa appointments is you can't look at the schedule until after you pay, which has always annoyed me, because it's very frustrating to be like, no, you have to put the money down and then we'll open the books and show you how long you got to wait for your appointment. I always feel like you should be able to look beforehand, but I don't think they're going to be making that change anytime soon.
Seeing is believing, they say. And
right. Well, I mean, because you want to ideally be able to forum shop. Like, if you think about it, if you're somebody who's stuck in Canada, if you're like, oh, in Canada, it takes 5 months to do a visa appointment. In India, it's in 2 months. Then I'll just schedule it in India and pop over there. But it puts you in a situation where you have to pay the fee in Canada to see those appointments. And then you have to pay the fee in India to see those appointments, because you also have to factor in that all of these consulates in different countries are operating on different websites. Like
Mhm.
you're not really using the same universal system. And just to give you guys a peek behind the curtain, as someone who did a lot of visa appointment scheduling over the past year, I have no problem saying that India has the absolute worst one.
Okay.
I'm sorry, you guys have the worst website for visa appointment scheduling. I have never struggled more with getting kicked out, with having things not go through than I do with that website. It is just atrocious. It is horrible. Anyway,
I really hope
that's.
they have some good updates and upgrades. Yes, that's much
Oh, I
needed.
mean, they
But
knock it down for maintenance like every 2 weeks, or at least it used to feel like it when I was scheduling visa appointments. It felt like they kicked it for maintenance every 2 weeks. You couldn't do anything for 4 or 5 hours because they were working on it, and then you'd go in and it
that's
would be just
disappointing.
as. Yeah, it's very frustrating. Like the idea that if you're from India, you have to deal with a lackluster website just by virtue of that being your home country. It just frustrates me. I remember scheduling for people in South America, like Brazil, Argentina, Mexico, 15, 20 minutes to schedule an appointment, if that.
Okay.
Versus
How long do you take for India?
sometimes an hour and a half. Because it's just you get kicked, your information doesn't save, and it's just so frustrating. I don't get why there's not uniformity to it, and everyone just doesn't have the
Mhm.
exact same type of system. But anyway, that's my rant for today.
Well, we'll take that, but I do hope that there will be good upgrades very soon. And Mahinder, I would like to say that sorry, am I? I would like to say that you can contact attorney Justin Rivera directly as well if you want to have a one-on-one with him. Why not
Sure.
call him instead? And call you can call him on this number. You can note it down. 844-592-7336. That is his number. You can even email Justin at support@wasden.law, and definitely go visit wasden.law to get to know more about Justin Rivera and, of course, Wasden Immigration and Litigation. Well, Justin, now I think we should move on to another question from our audience. Let's take
Mhm.
up Rahul. I'm seeking clarification on H4 visa travel regulations. A family member's spouse is in India with an H1B visa, while their wife is also in India with an H4 visa. They both recently traveled to India for urgent matters, but now the wife wishes to return to the United States alone. Can she travel back to the US on her H4 visa independently without her husband's accompaniment since he remains in India?
So there's a heightened level of risk in that you typically want the primary to travel with the dependent or the primary to already be physically present in the United States. So I definitely think that there's an added risk to that. Is it impossible? It shouldn't be, but I do think that you need to take extra steps from a documentation standpoint. So what does that mean? I would go so far as to carry a copy of the spouse's H1B approval notice, maybe even a copy of their petition, and maybe even an updated letter from their employer stating that he is coming to work imminently in the United States, but he's not able to be in the United States right now due to X. Urgent family matter, business matter outside the country, something like that. So I would do that just to make absolutely sure that you're okay with coming back, especially if they've come in and out of the US already a couple times, then it's easier. But if it's a first entry on a new H4, then you
Mhm.
really should have the primary with you. And if not, take all those extra steps and hope for the best. If you want to be as conservative as possible, though, I would travel together.
Great. So, Rahul, I think definitely they should travel together. Thank you for your question. And thank you, Justin, for taking that up. I think it's time now to take a short break, Justin, if that's okay with you as well.
That'd be great. Thank you.
All right. So, friends, don't go anywhere. Today, we are discussing if you are curious to get to know more about H1B visas, drop your questions. It's an Ask Me Anything session, and we'll be right back after this short break. So, don't go anywhere. Stay with us on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone. Welcome back once again to Immigration and Jobs Talk Show. And this is the second half of the webinar we are having right now on this topic. If you're curious about H1B visas, get your questions answered by the attorney, who is none other than our guest for today, Attorney Justin Rivera. Thank you so much for joining us all the way from Wasden Immigration Litigation. And friends, it's lovely to have you here with your questions as well. It's been interactive, and you can keep commenting wherever you're watching. We are streaming live on YouTube, LinkedIn, and Facebook, and it's been great having your questions. So recently, we've seen an increase in RFEs and NOIDs or NOIDs for H1B applications, especially in the wake of the heightened scrutiny under the current administration as well. So, but then also we also have the new fiscal year that's coming up starting October 1st. So a lot of you may have questions, and before we start off, maybe Justin, do you want to say anything on that too?
I would love to, if you wouldn't mind giving me a soapbox. A lot of you are going to be changing status on 10-1 to H1B. That carries with it different requirements and conditions than you're used to probably on your old status, which I know for a lot of you is F1. Maybe it was something else. But I would definitely say for those of you that are going to be moving over to H1B, make sure, like I said, kind of at the top of the call, that your work is in compliance with your labor condition application. Make sure you're working where you're supposed to be working. Make sure that if you move work sites, that you inform your employer, or your employer, speaks with you. You guys come to an agreement, and you make sure that you guys determine whether or not you need to file an amendment. A lot of factors go into whether or not an amendment should be filed, all the way from the work location to the wage level to the SOC code. So there's a whole bunch of new considerations that you're going to need to deal with as a result of moving to H1B. But for the most part, it's a smooth transition. You should start off right there on October 1st in H1B status. It's never too early to start thinking about perm, if that's something that you're thinking about once you max out at that 6 years. So I would definitely take that into consideration too. Once you're starting working. Another thing, just kind of generally speaking, on that kind of has come up over the past couple of years that I see in things like consultations and stuff like that. Sorry, my email's absolutely blowing up right now. I apologize. Something I do see come up, transfers, H1B, change of employers. Sometimes you join an employer and you start working with them on H1, and it's a couple weeks in and it's not what you wanted or expected, and you think, can I move employers? You can transfer, but just remember, if you're transferring and you just started an H1B, you have to show that you maintained status. And typically to do that, you have to be able to provide pay stubs. So I always recommend at least having 2 to 3 pay stubs available when you move employers. So I would definitely say be cognizant of that in the event that you start working with your H1B employer and you don't like the situation and you want to move. Is it possible to change employers sooner, than the 2 to 3 pay stubs? Maybe, but I wouldn't take the risk if you don't have to. And so those are, that's kind of the things that I think about most often is those quick change of employers, maintaining H1B status, and then just making sure that you're in compliance with your LCA. Making sure, again, that you're working where you're supposed to be working, performing the duties that you're supposed to be performing, and being paid the correct wage. Obviously, the point of that labor condition application is to ensure that you're being paid with what you're supposed to be being paid based on the type of job you're doing and where you're working. If you're not being paid the wages you're supposed to be paid, you do have the option to report the issue to the Department of Labor, to the DOL, and the Wage and Hour Division can open an investigation as needed. Hopefully that's not the case for anybody, but it is something that can be explored, because obviously we don't want bad actors in the H-1B program. We don't want employers that are not paying people what they're supposed to be paid or trying to circumvent the rules.
So true, so true. So thank you so much, Justin, for the update. And also, like friends, I'm sure you also have questions. So, and if these changes are going to impact your H1B status or your plans to apply, you might as well ask your questions because we're going to be here for some more time. And yes, we are discussing about H1B visas. So I think quickly we will take up this next question now from Shri. Shri is asking, I'm currently in India as my H1B 6 years maxed out, term awaited. Company will be filing 7th year extension next week. Question is, can we file H4EAD with 7th year extension from outside the United States of America?
I don't think you can file an H4EAD without an I-140, and it doesn't sound like you have an I-140.
Okay. So do you have an I-140, Shri? Tell us.
It doesn't sound like it if his perm's pending. So, no.
So does he have any options?
Not for an EAD for his spouse. He has to wait for the I-140, his I-140 to be approved.
Okay.
So, I mean, it needs to be filed.
Need to get that done. Thank you, Justin. Now, this next one is from Imran, also on YouTube. I raised FOIA request. USCIS conducted search for I-129 document and didn't find it. They provided me a note saying no records found. My H-1B got approved recently on April 25th, 2024. I requested them to provide I-129 and I-797. I provided my receipt number and they replied they can't find any documents. Does it mean my employer provided me someone else's receipt number?
I have no idea, man. I mean, look, what it sounds like is your employer just gave you a receipt number. There should be receipt notices. You should have received a receipt notice, and if your H-1B was approved, you should have received an approval notice. If you don't have those things and they weren't supplied to you by your employer, I don't know, man. They may have not filed an H-1B for you in the first place. Yeah, absolutely. That seems very nefarious. And especially if you're claiming that you submitted a FOIA request and the government wasn't able to turn over that information because they're saying it doesn't exist. I've gotten FOIAs back where they'll redact portions of information saying, they can't provide this for this reason, this reason, this reason. But I don't think I've ever seen somebody come back and say, we just flat out can't find this record. Yeah, man, that's a new one for me for sure. And I definitely think, sorry, I don't mean to laugh, but it's so ludicrous to me that the employer would have given you a fake receipt number or the receipt number of another person. That seems bizarre. But yeah, I would definitely say if you didn't get a copy of your receipt notice or your approval notice, I would be very worried about whether or not you have work authorization right now or whether or not you're in the correct status if you're in the country. And if you're out of the country, I would wonder whether or not your employer actually filed for you in the first place. I think I would love to know more facts about this because, if this is someone who registered in the CAP, can they show that you had a registration notice that was selected? Did they even have the ability to produce that? To show that they even registered for you in the first place. And then I would go, if they can't even produce that, no, they never filed anything for you. So yeah, that's wild. I
Imran,
mean,
sad to say. Yeah.
what's crazy about that is, I guess I'm kind of just spitting like hypotheticals. I mean, why would you do this? Maybe you have this person working on F1 status on OPT or STEM OPT, and you want to keep them employed.
Mhm.
And you're claiming you're filing for them, but then you didn't really. But to take that lie and extrapolate it out to the point where you're giving them another person's receipt notice is bizarre. That's a case of first impression for me. I have never heard of an employer doing that before.
Imran, I would say it's a little unfortunate right now, your situation, but I think you should go do a thorough investigation, find out all these things which Justin just mentioned and
It sounds like
see
he
if it's
tried.
really, yes.
I mean, if they're just from my experience, if you're coming back saying your employer's not providing you anything and you did a FOIA request and they're claiming that there are no records available, then that's why I would say, have you tried putting the receipt number into the My USCIS case status, maybe, and seeing if that's an option? That would be my thought process. I don't know.
Okay, Imran, maybe we need more information about you. You could tell us more, or better
No,
even just contact
send an
attorney.
email.
Yes,
Yeah,
best
send an
best to
email.
send an
That's
email.
such a nuanced case that I wouldn't even want to discuss that in more detail on the call.
There you go. So please mail him at support@wasden.law. Thank you for your question, by the way. All right, let's move on now to this next one. This is from Ishwar. Ah, okay, from Drive 10. Hi, Justin. Do you think the court ruling allowing H1B spouses to work could hurt American workers? What's your take on this concern?
I've heard that idea, that posited the idea that allowing H4 EADs can be harmful to the U.S. job market because the H1B visa has more stringent requirements. You have to go through a lottery. You have to have a specific degree type. All this stuff. But H1B, it's a different burden. And H4 EAD you can do anything with it. An H4 EAD, you can be self-employed. You can go work for a business. You can open your own company, whatever. I don't think that the H4 EAD is harmful. I actually think that first off, you're not just entitled to an H4 EAD. The H1B holder has to get an approved I-140 first. So there's already hurdles that exist. I think I've talked about it before here, but I will once again tell the story of someone who I actually had a case for, who was Canadian, and he and his spouse were going to come to the US. He had been selected in the lottery and got his H1B approved. And once he found out his wife was not entitled to work just on the H4, they actually didn't come. They ended up staying in Canada and working because his spouse made more money than him. So it literally didn't make sense for them to come to the United States. They would have harmed themselves financially by coming to the US. So I actually think that it can be a hindrance to not permit that immediate work authorization. You look at it as opposed to the L1, the L2 dependent spouse for the spouse, the visa carries with it automatic work authorization upon entry. You're able to just begin working once you come into the country. It's incident to status. So I think that there are already kind of like hurdles in place to even get the H4 EAD in the first place. I just don't see how it can be that problematic for the U.S. economy, for American workers. I can understand some of the argument. The whole point is the H-1B is governed by a labor condition application. The LCA exists to make sure that people aren't working on low wages replacing U.S. jobs, right? And then the H-4 EAD doesn't have that on it. But I think that it's important to ensure that there's an avenue to employment for people's spouses, because if there isn't, you're going to have like situations like my case where you have people from other countries who don't come to the US because then they don't have that opportunity for their spouse to work. And I think you want to keep, my opinion of immigration has always been, you want to keep people here that have utilized the institutions here. People that have come in here and gone to school here and gotten education here, I think you want to keep them here. because what's the point of educating them if you're not going to utilize what they've learned, and put them into the job market and put them into the labor force? I really don't think it should be harmful. Do I think it will limit opportunities and raise anti-immigrant sentiment? I don't. Sorry, I'm looking at his follow-up statement. I really just don't think. I really don't think that the H4 EAD is the end-all, be-all on which people are willing to die on, as to whether or not they are anti-immigrant. I think it's something people maybe can point to if that's an issue that they have with legal immigration. But overall, I don't think that somebody is. I don't think. Long story short, the H4 EAD is a good thing. I think it's a benefit. I think it's a way to keep people here in the United States while they wait in a backlog when their I-140 is approved, while they wait for the opportunity to adjust status, as an avenue for them and their partner to continue working in the United States. I don't think a country like America, that was founded on the ideals of having a competitive workforce, having a melting pot of people, I don't think that there's any problem created by that just because you're letting an H-1B holder's wife work. I really don't see the drawback in it whatsoever.
Thank you so much, Drive, for your questions, and I hope you got your answers. Thank you, Justin, for elaborately taking that up as well and answering to Drive.
It's okay. I mean, I think about it because I started practicing immigration law about 2016, 2017, around that time, and I think during that time, I have almost on a yearly basis seen some sort of animus exist towards the H4 EAD. And I just don't see the logic in it. I think it's ridiculous. I think, well, what is the alternative? You would rather that person's spouse not be able to work in the United States? They're already living here. Why not give them an opportunity to contribute to the workforce? I'm sorry. I'm done with that. All right. Sorry.
That's cool. But thank you so much for your answers and for elaborately explaining every situation. So, Drive, thank you for that interesting question. Let's move on now to this next one we have. This is from Galela. ISM on L1B expiring on September 2025. I got H1B selection and opted for consular for change of status. Can I request start date on 1st January 2025?
I'm sorry. I don't think I understand that question.
Because
first off,
L1B.
if your L1B is maxing, then your H1B is not going to work because you could have that extra 1 year. So you could have 1 year left. Okay. Change of status for same company. Okay. Yeah, sorry. I'm a little confused by this question. I'm going to take it in the way in which I think it is going to be, which is where you're trying to kind of use that extra 1 year for the H going from the L1B to the H1B. If you were selected in the lottery, your first date on H1, I believe, is 10/1. If you're changing status. I don't think you can delay the change of status, but at the same time, I could be wrong. I've never seen that happen. I don't think it will. I think if you were trying to delay your H1B time, you should have filed consular notification and then, leave the US, go get a visa stamp, and then come back in because you're trying to maximize that time in H1B status, if that's what you're saying. So yeah, I think you're going to be changing on 10/1, but you know what? I could be wrong. That's not something I've tried before, so don't quote me on it.
Okay. Galela, all the best. And if you have more questions, I think it would be best to email Justin. You can mail him at support@wasden.law.
Yeah, please.
Right,
I mean, if I could look into it more, it'd be great. Might be able to give a better response.
Yes, for sure. And now the next question we should take up is from Anabia. What are the consequences of a layoff or job termination for an H1B visa holder? And what are the options for maintaining legal status?
Yeah, this is a great question. It comes up a lot. Unfortunately, layoffs do happen, terminations do happen. In that circumstance, with the H-1B visa, you have options. It's not an immediate issue where you're immediately out of status.
Okay.
The regulations allow for 60 days to either change status, find a new employer in H-1B status, or depart the United States. Now, I do want to give a caveat to that because I don't think that this is explained enough. That 60
Mm-hmm.
days, it depends on how much time is left on what's called your I-94. It's
Okay.
either your I-94's expiration date or 60 days, whichever is longer. So what I mean by that
Okay.
is because I had a case recently that I was looking into where the person was terminated on, I believe, August 17th or 18th. And they were
Mm-hmm.
talking about using the 60-day grace period. And I realized their I-94 was actually only good till the end of September. So
Okay.
they had less time than they realized. But traditionally, best case scenario, you get the full 60 days because you've got time left on the I-94. So that's where you have the opportunity to look for new employment, change status to another status, or depart. Best case
Mm-hmm.
scenario typically is you find a new employer. You have them file the H-1B for you. Again, always factoring in that it takes 7 days for a labor condition application to certify. So being cognizant of that and realizing, like I tell everyone, 60 days is really 50 days because you need to bake in time to get that case
Yes.
filed and received by USCIS. So you have that period. Sorry, you have that grace period to use, but remember that it's shorter than you think it is. The other option, changing status. You can change maybe to a dependent status if you have a spouse that's on maybe an H1 or an L1, an F1. You have those dependent statuses as an option. The other
Mm-hmm.
options are moving to F1 as well. You could also maybe look into, if you have to, filing a B2 extension to give you more time to maybe try and locate an employer. You will get into a messy situation where you're going to have to file,
Okay.
change your status to B2, change your status back to H1B. And you basically ask the service to adjudicate those in tandem, to approve and then approve, but it's always at the discretion of the service. You could see a situation where the service denies the adjudication of the B2 to H1 because the B2 hasn't been adjudicated yet, and maybe you end up having to go abroad to actually utilize the H1B. But
Mm-hmm.
those are all options for you. I would, I think I've said before, if you're tiering them, I think at tier 1, you've got finding a new H1B employer. At tier 2, you've got changing status. And then at tier 3, you've got departing the United States. But at the
Mm-hmm.
end of the day, even if you do have to depart the United States, you've already gone through the lottery and had an approved H1B. So you're
Mm-hmm.
not having to deal with that. So you
Okay.
should have an easier time finding a new employer and coming back into the United States. The biggest thing I would say, do not violate status. Don't stay longer than you're entitled to, and don't perform unauthorized work.
Okay.
Those violations are serious violations that carry consequences, especially in the
Mm-hmm.
future when you're applying for a visa abroad. But that's pretty much it. If you guys have more questions on that or a specific situation, please feel free to send an email. We can even go so far as to set up a consultation if needed.
Absolutely. So thank you, Anabia, and I hope that was very helpful. I like how you put it, Justin. Thank you for taking that up as well.
Mhm.
Now we have Megha. What are the implications for my immigration status and future work authorization? Okay, but she's telling us more about her. I am an H1B visa holder, and I've recently gotten married to a US citizen. Can I apply for a green card while still working on my H1B visa, or do I need to switch to a different visa category?
No, I think I don't see any problem with being on an H1B visa. That's fine. It's a dual intent visa. You can
Mhm.
you can have the intent to immigrate permanently on an H1B visa. So I don't think you have any issue whatsoever. I think it's a very common thing for people on H1Bs to get married to U.S. citizens. Um, so yeah, I don't see any issues. If you want to file in the future, I think general with filing adjustment of status going for a green card. I try to tell people stay on your non-immigrant status, even if you get that EAD. It's just a rule of thumb. I like to think that just in case something bad happens, you don't marry yourself to the EAD. But anyway, I'm getting really into the weeds. Basically, I'm telling you, I don't think there should be any issues. I think you should be fine.
No issues, Meghna. You can go ahead. All the best. And now we'll take up, I think, Ishwar's question. We haven't taken that up. This is, I have a visa interview in Chennai in September 2024, and I will be traveling along with my 4-year-old kid. I don't have any friends or relatives in Chennai to take care of my kid. Can I take my 4-year-old who is a US citizen with me for the interview?
I mean, I think you would have to look at the rules that the consulates posited. There are definitely consulates that say they're not supposed to be kids below a certain age there. So that's all dependent on what the rules of the consulate are. I can't pretend to know the rules of every consulate. I definitely don't know Chennai's by heart. So I would just check. And I think even if there's, let's say hypothetically, there's a rule saying, you're not supposed to bring kids under a certain age, I would assume if you're able to contact the consulate, they might make an accommodation for you in the event that you have no other options. I mean, if you literally have no one else available to watch your child, then what's the alternative? You can't attend the visa interview. So I would say just talk to the consulate, try and work with them, see if there's a workaround if they say kids aren't permitted. As long as there's no rule that says kids aren't permitted, then I don't think there'd be an issue. But again, it's consulate specific. I've seen consulates say like you don't have to bring kids, and I've seen consulates where, if I remember right, the language is more akin to like don't bring people under age of whatever. You have to talk to the consulate specifically. Sorry. If I ever do learn the answer to that, I will share it on here though.
Okay.
Because
Thank you so
I
much,
might go
Justin,
look
for that.
at it. But yeah, just talk to the
Yeah,
consulate.
cool. Ishwar, thank you for your question. And Justin, thank you for taking that up. And we have Anavia, who you just answered, saying, thanks, Tony. Got my answer. Thank you, Anavia, once again. And Justin, I think we are coming to an end. We have taken up, I think, all the
Yeah,
questions from my audience as well. So we
I
should
think I'm
wrap up.
talked out.
Yeah, all right. But thank you so much. It's been great chatting with you and for all those. I mean, it was a great discussion. We had very interesting questions as well. And
Mhm.
what do you have to say to wrap up? Anything about H1B?
Um, that was a pleasure being on. I don't think we really talked about concurrent H1Bs at all. I mean,
Okay,
it just
so
didn't
why
come
not
up.
say a little bit?
There were no
Right.
questions about it, but not concurrent. I'm sorry, CAP exempt employers.
Cap exempt.
But
Yes.
yeah, CAP exempt employers is another avenue for H1Bs if you're not selected in the lottery. Just something I've been talking about recently. Concurrent employment H1Bs. Concurrent employment H1B, like if you're going to a cap subject. I'm sorry, I'm talked out. Long story short, look into if you did not get selected into the lottery, possibly working at a cap exempt employer. Those are typically going to
Mhm.
be research universities, healthcare that's affiliated with schools and universities, nonprofit organizations, stuff like that. And
Mhm.
that's pretty much all I got.
Okay. Thank you so much, Justin. I think, you totally deserve this long weekend. You seem to have worked a lot, and I'm sure, like we discussed earlier, you have these very complicated cases. You do a great job. So congratulations, and thank you for joining us once again. It was great having you here today on this discussion.
Yeah, thank you so much for having me. It's always a pleasure. You guys all have a great weekend, and I'm sure I'll be back on again in the near future.
Me too. Hoping to see you in the coming week. Bye bye,
All right.
Justin. Have a
Bye.
happy weekend. Bye
You
bye.
too.
Thank you, friends. And you feel free to contact Attorney Justin Rivera. His details are on the screen. You can call him on this number, 844-592-7336. Once again, let me repeat, 844-592-7336. You can email Justin at support@wasden.law and go check out wasden.law to get to know more about Wasden immigration litigation and also Justin Rivera. And also, don't forget to follow Wasden Immigration Litigation on LinkedIn for more immigration updates. And also, us, we are Immigration and Jobs Talk Show. If you resonated and you are into an immigration enthusiast, why not subscribe to our channel, hit the bell icon, and you will always be notified when we have discussions like these. Furthermore, you can also contact me if you have any questions regarding immigration or jobs. And also remember that we also sponsor H1B visas. So feel free to contact us. My number is 408-335-6444. And my email address is neep@higherightpeople.com. And to get to know more about us, check us out on www.higherightpeople.com. This is it for now, but don't go anywhere. Stay tuned to our space because I'll be joining you again in another hour with another webinar and another guest. So it's going to be very interesting. Thank you so much for joining us. Bye-bye for now.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at neep@higherightpeople.com or visit
Hello, everyone, and welcome to Immigration and Jobs Talk Show. And before I move ahead, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and today we are tackling a topic that is both timely and crucial for countless international students pursuing their dreams in the United States. Whether you are about to embark on your academic journey or you're already navigating life as an F1 student, this episode is one you cannot afford to miss. Well, imagine this. You have done everything right. Secured your F1 visa, packed your bags, and prepared yourself for an exciting future. But upon your arrival in the US, you're stopped at the airport, questioned, and before you know it, you're facing the possibility of being sent back home. This nightmare scenario is unfortunately a reality for some students who fall afoul of US immigration laws. So what can you do to avoid falling into this trap? And also, what are some common pitfalls and how can you safeguard your future? To discuss about all this, we have today with us none other than litigation attorney Jonathan Wasden. So without any further ado, let's welcome him once again to our show. John, welcome back once again to Immigration and Jobs Talk Show.
Good seeing you again.
Thank you so much. Likewise. And to our lovely viewers, I would like to tell you that we are live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any question that you would like to ask from John, so please keep commenting them in the comment section. Keep asking your questions. We'll be glad to take them. And now, John, before I talk about, today's topic, which is F1 students, how to avoid deportation. Before I talk about that, I also would like to ask you about the H1B second round of lottery, which was announced yesterday. So if you can, please provide a brief overview about the second H1B lottery announced by USCIS, and why do you think it was necessary?
Yeah, sure. So up until a few years ago, the way they ran the lottery was they would run everybody through the first round and then get to that 65,000 bachelor's cap. And then they would run the master's cap. So they flipped that, and now they run the master's cap first, and then they run the bachelor's cap. So this year, what happened is the master's cap was full after the first round of the lottery, but the bachelor's cap still was not full. They didn't have enough petitions filed after selection. So they're running the bachelor's cap again. Now, it's kind of a confusing way to phrase it, because the people with masters, PhDs, and bachelors all get run through the bachelor's cap all together. So it's for a master's degree or higher, it's really your third bite at the apple. And, bachelor's, it's your second bite of the apple. So to me, the reasons for it, just they didn't get the volume of petitions that they needed to, fully fill up their 85,000. And so they're going to redo the draft. It should happen relatively soon, because these visas have to be awarded prior to the end of the fiscal year, and that's September 30th. So I would anticipate we'd be seeing the new lottery in the next few weeks, maybe a month at the most, and then selection notices will be coming out then.
All right. So, and what about the applicants? I mean, what can they expect, and what is that they should be looking out for?
So just updates from USCIS about the lottery being run, and then checking their online account to see if they were selected.
Right. And now that the second lottery has been announced, do you think there's a possibility of also having a third lottery?
I don't think so. I think the second one will probably fill it up. I mean, we're already in August, so we've only got 2 months left in the fiscal year. So I don't know that we have actual time for a third lottery even. So I would expect this would be the last one.
Okay. All right. Thank you so much for answering the questions related to H1B second lottery, John. Now let's come to the topic that why we are here. To discuss the topic that we are here for, which is F1 students and how to avoid deportation. So my very first question about this topic is, so John, there has been a specific section of US immigration law, section 212A, 6, and C, that has been causing a lot of concern basically among the F1 students. So if you can please explain what section 212A, 6, C covers and why it's particularly relevant for F1 students.
Yeah, sure. The 6C finding is what the commonly referred to in immigration world is a fraud finding. It covers fraud or material misrepresentations that were knowingly made by the foreign national in an attempt to get an immigration benefit. So all of those things have to be met in order to substantiate a 6C finding. When USCIS makes a 6C finding in, say, a petition process, that's something that's very easy to challenge and take to court, because there's no protections for USCIS going to court. One of the most frustrating things, though, in immigration law is that the law makes decisions at the port of entry bulletproof to judicial attack. And so it's very frustrating, because you have very low information CBP officers making decisions on people's lives that have a far-reaching impact, and sometimes they're not doing it with all the best information or best motives at heart. So port of entry is an inherently dangerous situation for anybody coming to the country on a non-immigrant visa.
Okay. So, it sounds like this section covers some serious grounds on inadmissibility, right? So, So, how often do you see these cases where students are unaware that they violated this section? And do you think more awareness could prevent some of these issues in the future?
So it's really scary because I've seen cases where, the famous one was the Atlanta case a few months back, or maybe actually a year back now, where there was a group of students on a flight coming from India,
Right.
and they all got stopped, sent to secondary, and sent home with fraud findings saying that their F1s were shams or frauds. These students, many of them had evidence on their phones that they had acceptance letters from universities, they had paid for tuition, they had lined up housing, they had done everything in the world to show that they were actually going to school. But some yokel CBP officer decided that, that was fraud. Really, it's just a way to hassle people at the port of entry. I'm not a big fan of CBP. I don't think they do a great job, just full disclosure. And I think they have way too much power and authority for what they do and for the level of knowledge that they have. So it really comes down to protecting yourself from these low information government bureaucrats at the port of entry. One thing that we commonly see happen at the port of entry is your constitutional protections are lower at the port of entry inherently. So unlike a traffic stop or something like that where they need a warrant to search, the rules are more flexible at the port of entry. They can take your electronics, they can take your phone, they can go through your bags. So, you see oftentimes they'll go through somebody's phone, looking through all their old email accounts or WhatsApp messages, looking for anything that they can to, substantiate their theory of what's going on.
Right.
So, you got to ask yourself, is it worth it to carry your phone? Is it better to go without your portable brain for a couple of days, FedEx that to yourself, and then get it when you get here, instead of just exposing yourself to CBP rifling through your private information on your phone? So, that would probably be, something advisable if you're worried about this, just to FedEx your phone to yourself, just to avoid the potential problem that could happen.
Right, but what according to you should be their first step? Because, in a situation like this, when you have no clue about anything and your phones are taken away and, other things, mostly you are left with nothing, right? And you are in a country where you don't know what to do and whom to contact. So in a situation like this, what do you think the students should do?
So for F1s, I think it's important to know your contacts. People at the school that you've been dealing with have their phone numbers, have their emails, have their names. So when you're asked any questions, you can give that to CBP and they have somebody that they can contact to verify information. So I would take all of this just in a folder, just paper copies. That way you can just hand it over to the CBP people. Your acceptance letters for university, all of those types of things, proof that you've got housing lined up. All of that would be helpful to have in a tidy little folder that you can just hand over.
Right. Okay, thank you so much for answering the question, John. Also, John, I would like to know from you that what are some of the most common mistakes that F1 students might unintentionally make, that could lead to issues of fraud or misrepresentation under this section?
Sure. So there's maintenance of status issues, and then there's fraud issues.
Right.
What USCIS considers to be fraud, I think the biggest thing we're seeing right now is people that were scammed by fraudulent employers who were preying on recent college graduates with F1s, telling them that they were going to hire them, place them on a project, but you just need a little bit more training before they can put you on a project. And oh, by the way, we do the training and it's going to cost you. So that scheme is relatively common, or was more common recently. And anybody that was caught up with one of those companies, eventually at some point or time in the future, you're going to get, sent to secondary. You're going to have problems with, DHS with this issue. It might be at the State Department of the consulate, might be at the port of entry, but those fraudulent scam employers are the biggest threat probably right now that I see to people on an F1.
Mm-hmm, mm-hmm. And are there any support or help available for these students?
So you can request that you be able to call an attorney. Again, at the port of entry, your rights are very limited. If you do carry your cell phone, or if you do carry a dummy phone or a burner phone with you through the airport,
right,
I would just ask them if it's okay if you can record the conversation so that you have, make sure there's no language barriers or problems with understanding, so you have a clear record of actually what was said. If they have a problem with that, that lets you know you're not dealing with an honest officer. If somebody's afraid to be recorded, that's a red flag. The other thing that I would say is, excuse me, let me grab some water.
Sure.
Now I lost my train of thought. But yeah, I would say, ask them if you can record them. If they say no, be very suspicious of them at that point in time.
Right. Thank you so much for that great advice, John. And also, John, given how easily these mistakes can happen, so would you say these issues are mostly due to lack of understanding of the visa requirements, or are there other factors at play too?
So I think a lack of awareness on students' parts about, the scam employers is probably the biggest problem. USCIS didn't really help anybody out in this regard either, because they were aware of these scam companies out there. They had, identified them, they had blacklisted them and flagged them in the system, and then just waited for people to get caught in the scam. So, what a legitimate, law enforcement agency should do is alert the public that there's a problem out there and to be aware of it. But USCIS almost, fanned the flames here. They knew these companies were in existence. They didn't decertify them from E-Verify. They let people blindly walk into it and then held them accountable for the fraud that the company perpetrated. So, you got to really advocate for yourself in these situations and really thoroughly vet anybody you're taking a job from to make sure there's no problems. As a general rule, I would say anybody that's asking for payment for training or a letter or anything, you should not only stay away from, but run away from.
Mm-hmm. Right. And, any specific advice you would like to give these students to avoid these pitfalls? I mean, so that they don't get into these things? I mean, because...
to the extent you can, social media is a great thing. To the extent you can, contact people that have worked there, go off referrals from friends. Make sure that, if you're on STEM OPT, that you're following all the requirements for STEM OPT, or that company is actually following them. Because if you have a STEM OPT employer and you're not following the training plan or any of that, then if there's an RFE on whether or not you maintain status and you don't have that information, you're going to be in the world of hurt, and you will be found to have not maintained status because your employer wasn't documenting correctly, and then that'll mean you have to consular process. And as anybody knows, consular processing right now is a nightmare. It's the number of 221Gs going out is just astronomical right now, so you want to avoid that as much as possible. So you really have to advocate, and if your employer is not complying with the rules, you should probably look for a new employer, and just to protect yourself, consider reporting it to DHS just so you have a documented history of saying, hey, there was a problem, it wasn't my fault, I'm finding a new employer. So you may have to be a little bit more proactive. Now, that said, if you're going to go that route, highly recommend talking with an attorney first and maybe having them do the letter and them do the correspondence for you, just to make sure that you're not inadvertently saying something that's going to hurt your future.
Right. And is there a way to also find the right attorney for such cases?
Again, word of mouth, people that you trust, just Google reviews, that just look for somebody that has experience in this area that you can trust.
Right. Also, John, so beyond misrepresentation, what are the other main reasons, international students might face deportation? And again, how can they avoid finding themselves in, such situations?
So there's two different things. One is non-immigrant intent, and then the other is not having the right travel documents. The travel document one is, I think it's an A7. It's kind of disingenuous for them to give you an A7, because typically what they're saying is, you show up with a valid visa and the CBP officer says, you don't have the required documents because we're revoking your visa, but they're revoking it because of A6 for the fraud finding. And so, you're getting an expedited removal and it's for not having documents, but really it's a lifetime bar because of the fraud finding. The maintenance of status issue is something we're starting to see more commonly recently, where they start, looking into whether or not you're going to be returning home at the end of your stay. We see it a lot on B2 visas, especially, but F1s as well. So they will, be constantly probing to see if your intent at the time you enter the U.S. is to stay permanently, or if your intent is to finish your program and leave. And so, you just have to keep in mind what your non-immigrant intent is. One other thing before I forget, when you get pulled into secondary, if they're going to remove you, to a 235 removal, sometimes they will give you the option to withdraw your application for admission. If they ever give you that option, that is the best course of action to take, because that avoids having any bars against you from reapplying for admission. You can go to the consulate, you can do a trip report, you can try and fix whatever the problem is that CBP believes there was, and then reapply for admission. But if you get that expedited removal, it's much, much harder to get back into the country.
Right. And also, it is said that the visa officers also see your intentions. What are your intentions? So how can the student, show their correct intentions to the visa officers?
So for the students, it's a tough one, right? Because you're young, you don't own a home, you don't, have a lot of substantial business ties or anything like that. Yeah. So it's tough. You just have to, say the truth. You're just coming to get an education. This is the best place for it. And, you probably will, look for OPT to get experience to solidify your education. For the B2s, what we typically see them looking for is, proof that you have a residence in India that you're going to return to. Again, if you're younger, that's going to be tough to do, because if you're going to be gone for 6 months, you may not maintain an apartment. So, those are the types of things that they're looking for. Again, the system is set up to give CBP a lot of discretion on what they decide. And it really comes down to the eye of the beholder. What does that individual CBP officer think or want to find? And so that's why I said earlier, if you can record them or request to record them, if they say no, you're not dealing with an honest broker. You're dealing with somebody that wants to just find the facts to support their assumptions.
Right.
Along those lines, a lot of times they'll have you do a written statement, or what they'll do is they'll interview you. They will type up a summary of the statement, and then they'll put your signature on it.
Mhm.
They get your signature electronically before the beginning of that interview. And then they affix your signature to that written statement after the interview without letting you see that written statement. And that becomes the official record. So I would not sign anything when you go into that secondary. If they give you that digital signature pad, I wouldn't sign it. I'd say I'll wait until I see a written statement before I sign anything, because I want to make sure it's accurate, and demand that you see that written statement before you sign it. Read through and make sure it's accurate. Make annotations to it if it's wrong. So you really have to be assertive. You really have to protect yourself and advocate for yourself in that situation.
Right. Thank you so much for such great tips, John. Also, I would like to discuss, about this case. I think I don't know if this was the same case that you were also mentioning about the 33 students who were deported at the USA Chicago airport on January 15th this year, 2024. So, this incident has understandably caused a lot of concern. So, how can such cases be prevented in the future?
So the biggest things that I would say is never go through Chicago. Chicago's CBP is notorious. They are, without question, the worst airport in the world to travel through for abusive law enforcement tactics.
And why is that?
It has to do with leadership for that particular office, would be my guess. But it's been bad. I think the people that are working there just have a bias, and it's just someplace I would avoid like the plague if I could. So I would make your port of entry someplace, someplace other than that, or Atlanta. Atlanta's also got an overly aggressive CBP office that, they shoot first and ask questions later, so to speak. So I'd avoid those two places as your first line of defense. Even if it means taking a few extra hours to get to your destination, it's probably worth it.
Okay, and what role can universities and immigration advisors play in preventing these unfortunate events?
So that's a frustrating question, because some of these people, I talked with some of those students, and there is nothing in the world, there is no more information that they could have possibly had or presented to that officer to show that they were a legit student, that they were going to be engaged in a program of study, and everything lined up, all their documentation lined up, but it didn't matter. They just, did the expedited removal and said, you're not coming here to study, and sent them away. They used to be able to, right at the beginning of master's programs, at legit universities, like University of Chicago, some of them, like very, very solid, well-known, reputable colleges. And they had paid tuition, but it didn't matter. They had housing lined up, it didn't matter. So for those people, it's frustrating, because there is nothing in the world they could have done to alter the outcome other than possibly change the airport that they flew through.
Right. Okay. And, also I would like to take a moment to also discuss about, when students first enter the US. So how do these immigration officials at the port of entry determine if an F1 student is inadmissible under section 212, AC6? So, and what are the key factors? Are there any key factors they consider doing this?
So there's a database that's called the Consular Consolidated Database, and the Department of State, the consulate, can upload information to it and access information. CBP can access the information and upload to it, as well as USCIS. For the OPT scam employers, what they're doing is USCIS is identifying who is associated with these companies. They're going through their records, they're matching up, they rated the companies, they took their list of employees, and then they started matching up names. And so then they uploaded that to the CCD, that database. Now, some of these people stayed in the country, got H1Bs, extensions of H1Bs multiple times, and never heard a word from USCIS that there was a problem with their OPT experience. It's not until they go to the consulate or they go to the port of entry, that they learn about this. Because the first thing that happens at both the consulate and the port of entry is they get your biometrics and they pull up your file in the CCD, and if there's any flags or any hits in the system, you're immediately going to the secondary, or you're getting focused and attention. And USCIS is flagging people in the system and then waiting for them to go to the port of entry or go for stamping at the consulate, and that's where they're hitting problems. That's the very first thing that happens, is they notice that flag and they're pulled in.
Right. And let's say that if the immigration officer suspects something is wrong, then what happens next? And how can, and in a situation like that, how can the student respond during that moment? That can impact their situation.
Yeah. So the first thing to remember, if you get pulled into secondary, by and large, these people are bullies. They are basically mini little Trumps working around and just trying to throw their weight around in their authority. And so it is not uncommon at all for them to try and bully you, intimidate you, yell and scream at you, keep presenting you with a scenario of facts that they believe, and demand that you agree with them. And if you don't agree with them, for them to lose their temper and basically throw a tantrum like a toddler. So just be aware that that is their MO, that's their process that they go through. And when it happens, don't get flustered. Just stay calm, disagree with them where you need to. Again, ask for recording and refuse to sign anything, because if they're throwing a tantrum like that and making wild accusations, their summary of your conversation is not likely to be accurate.
Do you have a case, where something similar happened that you would like to discuss with us and the audiences?
Yeah, I mean that's such a common scenario where you get pulled into secondary and somebody starts yelling and screaming at you and accusing you of having done something wrong.
Right.
And no matter what you say, no matter what evidence you bring, in support of yourself, they keep on screaming. It's almost like they have a quota of people that they have to reject at the board of entry. So they're, maybe at the end of the month, you see this happen more as they're hitting their time for their quota. But, it happens all the time. Like I say, some airports are worse than others. But it's not exactly the way you'd want a reputable government agency to behave, but it's how they operate.
Right. All right. Thank you so much for answering the questions, John. And I can see people have started commenting their questions. So I would like to take a couple of them from the audiences. Okay, let's take maybe Ramesh's. So Ramesh is here and he says, I know this session is for F1, but related to H1B fiscal year 2023. My petition was revoked and back to India. What are my chances to secure my CAP number back where there no fault of mine and issues for fiscal year 2025? What do you have to say, John?
So this is an issue we've been suing USCIS on, and we're not at the end of the process yet, but so far the signs are positive. What we're trying to do is, for people in that situation, is to recapture their CAP number that they initially were assigned. Now, when we first started suing USCIS, what was happening was people would be going to the consulate for a new visa category, and they were told that they had a fraud finding applied against them based on their employer's multiple registrations. And so that was game over. They had a fraud finding in the system. We started suing and challenging that issue, and USCIS almost immediately realized that they were doing it wrong, and they changed their policy and the way that they were handling that situation. So now if you're the employee who was the subject of a multiple registration, you are no longer getting penalized by USCIS. And that's a huge change, and that's a huge benefit to you. So what that means is on future H1B lotteries, it shouldn't have any impact on your ability to get a visa.
Right, right. And he also has a second part. He says, my H1B petition for fiscal 2023 was revoked due to multiple registrations. Even though I wasn't involved, I had returned to India. What are my chances of getting a cap number for 2025? Any advice?
Yeah, there's not going to be anything, ideally nothing that is going to follow you or impact you from that multiple selection. If you get an RFE on it, we should talk and strategize for how to respond to that, because USCIS is on record in all kinds of court documents saying that they will not penalize the employee for the employer's alleged misconduct. So it shouldn't have any impact on your 2025 petition. I think you should be fine there.
Right, right. Okay. So, Ramesh, you don't have to worry. And yes, thank you so much for your question. Let us know if you have a follow up or if you'd like to know an answer to another question. Thank you so much for posting your question. Let's quickly take RK's question also. So, RK is here and he says, is there any truth that attorneys litigated against USCIS asking employers proof having a project before approved, because few employers use not requiring to show proof to take a genuine cap and bench their workers while looking for a project, while genuine students miss out? We know it's wrong what they are doing, but last chance students are losing out.
The structure of the H1B lottery system is very flawed, I guess, to say it in a very kind way. The lottery is held in March. And if you're working for a staffing company, the industry standard for a lot of these companies is to operate on 6-month projects. So the best case scenario is if you get selected, you get approved, and the stars line up and you get a visa stamp and you're able to enter the country by the beginning of that visa period, you're already past 6 months. And so it's almost impossible to have a project that's guaranteed at the time they file your registration. And really, no employer in the world is going to sign a legally binding contract for an employee to work at a client site when they don't even know the outcome of the lottery yet. And so it's really impossible to have that project requirement. And more importantly, that's just not my view of it. It's what the law says that Congress created. So the Congress, when they created the H1B restructuring, what they said is that you can legally bench people, but you have to pay them while benched. And so that's the protection, that's the trade-off, is that employers can take that risk. But once you're in the country and available for work, if they're not paying you, they have a substantial legal liability. And so that's the system is flawed, but that's the best remedy that people have. I think his question is really going more towards the people that were selected in the lottery still in India and are not able to get visas. That's a tough one, because if the employer doesn't have a project and they are not going to bring you, there's not much you can do there. But it's really more a flaw in the system than it is in the employers doing something wrong.
Right. He also has one more question. I would like to read that out. He says, how is it that the selected 130K with a 20K for the master cap, which was filed, for the remaining 110K, they weren't able to get 65K? Does this indicate employers just registering applicants?
Yeah, probably. There's a gap there. They registered, then business situations change. We're now like 5 months past the lottery, the initial lottery. A lot changes in 5 months. If you look at the tech industry, there's a lot of layoffs going on. And I think the rate of filing petitions kind of tracks the greater tech industry in general. So as the tech industry is shedding jobs, there's really not a need for those H1Bs you'd anticipated coming into the country and working on H1B. So, a lot of things in the business world can change and impact filing rates. And I think that's probably what we're seeing here.
Right. Thank you so much, RK, for your question. I hope you have got the answer. We still have a lot of questions from the viewers, John. But before I take them, I would like to go for a short break. And after the break, I would like to take these questions from the viewers, if that's okay to you.
Sure.
All right. So, guys, it's time to go for a short break. But you guys don't go anywhere, because post the break, we are going to take up questions from you. So, yes, keep on watching Immigration and Jobs Talk Show and stay tuned with us.
Consultant seeking a new opportunity? We offer job placement. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I am your host, Rajni Bharara, and today I'm here with none other than immigration litigation attorney Jonathan Wasden. And today we are discussing about F1 students, how to avoid deportation. And yes, we are getting questions from you. So now, without any further ado, let me take another question. So the next question that we have is from Vishwadas. Let's take Vishwa's question. He says, currently on F1 visa and my program end date is in 2 months. However, I need more time to complete my thesis. Can I apply for a program extension? And if so, what documentation do I need to provide?
So if you're still working on your program, theoretically, you should be able to get an extension of that. Now, the caveat being is you got to know your limitations. My limitation is I don't file these petitions. Yeah, I litigate on the fraud findings. I litigate on denied petitions, and kind of try and fix things that were broken in the process after the fact. So I would say talk to an immigration attorney that actually files this type of petition, because they're going to have standard formats that they've done this 1,000 times, and they can run you through it, and they can give you that information, and they can line up your package to make it as strong as possible to get what you need done.
Right. Okay. So Vishwa, I hope you've got the answer. Thank you so much for your question. Let us know if you have another one. Meanwhile, let's take Imran's question. So Imran says, I am on F1 visa and got married to a US citizen. Can I apply for a change of status to a spouse visa, CR2, or do I need to leave the US and apply for CR1 visa?
So if you're married to a US citizen, you would be looking to adjust status, and you should be able to do that while you're here in the country. So, I don't know that you would need to leave the country. Again, the caveat being I don't file these. It's not my area that I practice in on a regular basis, the family petitions. But my understanding is you can stay in the country while you make that application.
Okay, and he also has a part two, John. He says, what are the benefits and drawbacks of each option, and what are the required documents and filing fees?
So, if given a chance, seeking immigration benefits for marriage to a U.S. citizen is always your top choice. There's really no easier or better way to get that. Now, with U.S. citizens marrying foreign nationals, there is a lot of scrutiny that they give your application. They look for evidence or indicators of marriage fraud, things like that. So you're really going to want to go through and just show that the marriage is bona fide, and probably pictures of dating time, pictures of weddings, lists of who was at the wedding, things like that, just to show that this was a legit marriage and it's not just for the purpose of getting immigration benefits. Signs of cohabitation, shared utility bills, shared leases, shared addresses. Just anything that shows that you are a married couple is going to be very useful for your application. And the filing fees, like I said, I don't file these, so I don't know off the top of my head what the filing fees are. But you can just Google that on USCIS's website and it'll pop right up.
Right. So you can check that out on USCIS's website, Imran. And thank you for your question. Let us know if you have another part or a follow-up or maybe another question for John. Let's take Dipesh's question in the meanwhile. And he says, I have received an RFE on my F1 visa application stating that my bank statement doesn't show sufficient funds. However, I have since deposited more money into my bank account. Can I submit an updated bank statement or do I need to reapply entirely?
So if you haven't replied to the RFE yet, you can provide the new bank statement. If you've already replied to the RFE, you can try and do a supplemental. A lot of times USCIS will not accept the supplemental filing, but you can try. There's nothing that says you can't do it. So, I would say if you're past the point where you're outside that window of the normal reply time, maybe reapplying would be the way to go.
Right. So, Dipesh, I think, like John said, you should reply then. Then Paul is also here, and Paul says, I was on F1 visa and worked part-time for 6 months without authorization. I have since stopped working and want to apply for OPT. Can I apply for OPT or will my unauthorized work impact my eligibility?
If USCIS knows about the unauthorized employment, it will definitely be a problem. And that is one thing that they are, when they have that information, they don't always have it. A lot of times there's no way for them to know. But if they have that information, it's definitely going to be a problem for you. Unauthorized employment as a student can, create a 3-year bar to re-entry into the U.S. So it definitely will be an issue. My guess is if they have any information about that, they'll be giving you an RFE or an NOID. And so you'll be responding to that.
Right. So, Paul, thanks so much for your question. I hope you have got the answer. Ramesh's question, I think we already have taken. Vishwa's question also, I think we already took. RK also, I think we already have taken. Alok is also here, and he says, I have been on F1 visa for 6 years and have completed 2 master's degree. I want to apply for a PhD program, but I'm concerned about the impact on my F1 status. can I apply for a third degree on an F1 visa, or do I need to change my status to an H1B or J1 visa? What are the rules and regulations regarding F1 status and multiple degrees?
So typically as long as you're, advancing, making progress up the educational ladder, you should be fine. So a PhD, it's kind of a natural progression. You go from bachelor's, master's, PhD. So I wouldn't expect that to be a problem for you. I would expect if you filed for a third master's degree to get a lot of scrutiny in the application process. But for the PhD program, I think you're fine. But if you have the option of an H1, why not go for that and then do your PhD in a part-time. The one thing I will caution about PhD programs is just make sure that it's from a legit university, because they have a list at USCIS of colleges that are suspect, and degree mills, things like that. Places that only exist to issue CPT, and you don't want to be involved with one of those colleges. You want to be with a no kidding university that has a PhD program that has some legitimacy.
Right, but John, is there a reason behind the lot of scrutiny that you said?
Sorry, say again?
So is there a particular reason about the scrutiny that you mentioned?
Yeah, because it questions whether or not you're really looking to get an education, or if you're just really trying to stick around to work. And so if the immigration agency looks at it as you're just trying to game the system to work, they will inquire further into your application.
Right. Thank you so much for answering the question. And Alok, thank you so much for your question. Let us know if you have another follow-up or maybe another question. Meanwhile, Biraj is also here, and he says, I'm on F1 visa and was recently arrested for a DUI. Will this affect my F1 status, and can I still apply for OPT or a green card in the future? Okay, let's
So
take
so it could impact your F1 status.
Mm-hmm.
So typically the way these things work is your arrest record gets reported to DHS. DHS uploads that to the consular consolidated database. You're flagged. Then it goes to the consulate, and the consulate decides whether or not to revoke your F1 visa. If they send you an email, and I would keep an eye on your spam folder, I would keep an eye on your email inbox. If they send you an email contacting you saying that your F1 is revoked, what that means is you don't have to leave the country right away. You just won't be able to come back into the country once you leave. So it shouldn't be a problem for finishing your program. I doubt it's something that will come up in the OPT process. They could RFE on it, but it's not one of the things that they would typically focus in on an OPT.
Okay, and he also has a second part, and he says, what are the potential consequences of a criminal record on my immigration status?
Yeah, so the real problem is going to be going for stamping, or whether or not you maintain, if they're going to find that to be some type of violation of your non-immigrant status. USCIS may deny a change of status or an extension of status. Probably not the most likely outcome. The most likely scenario is going to the consulate, and the consulate making a decision on you because of your criminal, conviction for DUI.
Right. Okay, so Biraj, thank you so much for your question. I hope you have got the answer. Malika Arjun Rao is also here. Let's take his question. So he says, I am currently on an F1 visa and want to transfer to a different university. Can I transfer my service record to the new university, or do I need to apply for a new F1 visa?
Yeah, so again, limitations are I don't file these, but I believe you can transfer to a new university without having to file a new F1 visa. So, talk with your DSO, the designated school officer or the DSO. They know this process backwards and forwards. So, get an appointment to go in and speak with them about how to do that. Now, if you're transferring universities, again, the caution I give everybody on F1 is make sure the university you're going to is not a degree mill. It's not a CPT mill. It's a legit university that's offering legit courses, studies, that it's reputable. And that's, very important for avoiding problems in the future.
Right. And he also, again, has a second part, and he says, what are the requirements and procedures for transferring my service record?
Yeah, again, there you want to talk to your DSO, and the DSO will be able to walk you through that whole process.
Okay, so Mallikarjun, I hope you have got the answer to all your questions. Thank you so much for posting them in the comment section. And John, I also have questions from the viewers actually on my WhatsApp. So let me quickly read these questions. I'm so sorry, I'm taking a bit time. Okay, so here it is. The question is, will I be deported if I say that I'm staying at my friend's place because the university is close to his locality?
You mean, I guess they're asking if when they're coming through the port of entry, if they're asking where they're living. That wouldn't necessarily be a deal breaker. But if you have a lease or you have some type of documentation of where you're going to be living, that would be best. If you have some type of agreement with your friend to split costs, if you can get that in writing, that would be a great piece of information to have. But just staying at a friend's place isn't going to be a deal breaker. People have roommates all the time, so.
Okay, all right. Thank you so much for answering the question also, John. And again, okay, so I have one more question for you. And this question is actually from a guy, and he says, I already got my F1 visa, but just after, where is it? I already got my F1 visa, but just after it was issued, my I-130 filed by my stepmother got approved. Will this be a problem at immigration?
I've never seen that scenario come up. It shouldn't be. Although typically when you have an immigrant visa petition and a non-immigrant visa petition, they focus on your non-immigrant intent. What are you going to do? I don't know how long the wait period is, for a I-130 in this situation, but you're just going to want to make clear that at the end of your F1 program that you plan to return back home until your priority date's current. You can get a visa on the 130. And that's really going to be the issue. What is your non-immigrant intent coming in on the F1?
Right. And I also have one more question. And the question is, where is it? Okay, what should I do if my F1 visa got revoked and I received a 5-year ban? Can I go to the USA for my studies again?
So it really depends on why it was revoked. If it was revoked with a fraud finding, no. You're going to have to deal with that fraud finding before you can get another visa. If you're still within that 5-year ban window, you're going to have to, get a waiver for that, or figure out a way around that. But if it's not for fraud and you're outside that 5-year period, theoretically you should be fine. Now, when you go for stamping, or you go for, the port of entry, they may ask you questions about it, and you just have to, answer that as best as you can. I'd say consult with a, immigration attorney before you go to the consulate or before you go to the port of entry, just to get some, pointers on what the questions will be based on your specific facts, and how best to answer that based on your history.
Right. And, these were some questions posted in some groups. So we try to look for these questions also. And one more question, one last question for this episode. I got my USA visa on 12th January and I'm going to the University of South Dakota in July. I have paid my enrollment deposit and first semester fee, and all my documents are legit. However, I'm afraid due to the recent news about deportation involving students from South Dakota. Any suggestions?
So I hadn't heard about students in South Dakota facing issues. My first suggestion would be buy the warmest clothes you can possibly find, because South Dakota is the coldest place I've ever been. In terms of documentation, same rules apply. Just make sure that you've got proof that you can pay for the tuition, or you have paid for the tuition. You've got housing lined up. Correspondence back and forth between the school if you've got it. Have a contact at the school that can vouch for you and say, yes, they're coming. Yes, I've been discussing with them. Just make sure that you have all of your bases covered when you go through the port of entry. And again, Chicago might be convenient to South Dakota for port of entry, but I would avoid it. I would look for a different place to go as your initial stop in the U.S.
Right. Okay, so John, one last question before I let you go. Any last feedback or any last suggestion for the F1 students, who might be worried about their deportation at the moment?
Yeah, so I would say you have to be your biggest advocate. You have to be assertive, and you have to look out for your future. So, when it comes to picking a university or a college for a program, make sure they're legit. Make sure they're reputable. They're offering real courses of study, and it's not just a degree mill. When we're talking about post-employment on OPT, make sure that they're following the rules. The employer's following the rules. Watch out for people that are asking to, receive money for you to work for them. Avoid those types of situations and make sure. There are worse things than being unemployed and having to return back home because you don't have a job. And that worst thing is never being able to come back into the U.S. again if they find you have committed immigration fraud. So, be very, very careful with your choices on F1, and you've got to protect yourself that way.
Right. Thank you so much again, John, for coming and doing the show. It was, again, a great episode. And to our lovely viewers, I would like to say that if you want to get in touch with John, so you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. You can email him at support@wasden.law. Is that right, John?
Correct, yes.
Yeah. And you can also visit his website, which is wasden.law. So you can also check that out. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1 732-707 9151. My email is rajni@higheritpeople.com. And our website is www.higheritpeople.com. Remember, we sponsor H1B visas and other work visas based on job availability and regulations. All right. With that, thank you so much again, John. Hoping to see you next week with another great episode and great topic.
It's good being with you. Thank you.
Thank you so much. And to our lovely viewers, thank you so much again for turning in such huge numbers and continuously posting your questions, asking your questions. It really means a lot. If you like the episode, don't forget to like it, share it, and also comment down below. And yes, keep watching and keep subscribing to Immigration and Jobs Talk Show. We have 2 more webinars coming up at 12 and 2, so don't forget to check that out. And for now, I will have to take your leave too, and I'll be meeting with you soon. But yes, for now, I'm Rajni Bharara signing off. You guys take care and keep on subscribing.
Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Hello, everyone. Welcome back to another episode of Immigration and Jobs Talk Show. I'm Rajni Bharara. And before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and today we are tackling a topic that's incredibly relevant in the current job market. Tech layoffs hit hard. What H1Bs should know. Joining me today are two experts who will help us navigate this complex issue. We have Justin Rivera, an experienced associate attorney specializing in immigration, and Jonathan Wasden, a seasoned immigration litigation attorney from Wasden Immigration Litigation. So without any further ado, let's give them a very warm welcome. So Justin and John, it has got a nice ring to it, the name of you two. So thank you so much for being here.
It's good to be with you.
Yeah, thank you very much for having us.
Thank you so much. And to our lovely audiences, I would like to say that we are live on YouTube, LinkedIn, Facebook, and also, I guess, on Twitter. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And yes, if you have any question related to this topic, you are more than welcome to ask your question in the comments. So keep posting your questions in the comments below. And without any further ado, let's take our very first question. So, Justin, I would like to start the show with you, and I would like to ask my very first question to you, and then we will go into the legal aspects, and then I'll come to you, John. But Justin, let me talk to you first about the 60-day grace period. So let's start by understanding what happens immediately after a layoff for H1B workers. So if you can please explain the 60-day grace period for H1B visa holders after a layoff, and one by one, if you can please answer this.
Sure. So the 60-day grace period is, in essence, an opportunity for someone who has suffered a job loss that is on H1B to do one of three things. So they can either find a new H1B employer, they can file a change of status to another non-immigrant status, say, for example, F1 or maybe B2, or they can depart the United States. So that's the purpose and intent of the grace period. Again, it is 60 days. That 60 days, I think a common question is, when does that 60 days begin? So it should count from the cessation of employment. So what that means is basically from the time you are actually laid off from the employer, that's going to be the start date of your 60-day grace period. And the reason for that is you're no longer following the H1B petition because you're no longer employed with that entity that sponsored your H1B. So that's going to kind of start your countdown clock. Just to kind of give some general information about the grace period and how it applies to the H1B, while you do have 60 days, if you are looking to change employers to another H1B employer, remember that petitioner is going to need to go through all of the steps of filing an H1B for you. So that's going to include filing and posting the labor condition application, the LCA, and then going through the process of putting together the petition, working with the employer, likely the attorney and yourself. And then once you get that certified LCA, submitting it and making sure that it's received by USCIS within the time frame. So a lot of times I like to tell people, while the grace period is a 60-day grace period, if you're trying to move H1B employers, maybe think of it closer to 50, because you do want to make sure that you leave enough time for you to timely file that H1B change of employer.
Right, but how many times can this grace period be utilized? Because you have talked about if an employee wants to change its employer, so how many times can this grace period be utilized?
So the way that the grace period works is you kind of just get one bite at the apple. The whole purpose of the grace period is to give you an opportunity to move employers or change status or depart the United States within that timeline. So what I mean by that is, say, hypothetically, you file a transfer in the grace period and that transfer is pending, and then later on you file another transfer. Now, it's possible USCIS is going to see that second transfer as a filing that has already gone outside the grace period because you filed with that first employer. So my recommendation would be make sure that you know the action that you're taking within the grace period before you take it. So ensure that you are done with that decision, that you know for a fact you're going with this employer, or let's say you're going to file a change of status to B2 or a change of status to F1. So you need to be very very certain of what you're doing when you make that decision within the grace period.
Right, right. I mean, that's something that's really, really important. With that, I also would like to know from you, Justin, that, are there also any other circumstances under which this grace period could be extended, or is it strictly limited to 60 days?
No, you're really kind of stuck within that 60-day time frame that you've been provided to make a determination on what you're going to do. I mean, and that's kind of the whole point of the cessation, the grace period, is when you have that cessation of employment, it's a safety net. Right. It gives you something to where you're not going to be out of status immediately or accruing unlawful presence. And the reason that it was put into place is to make sure that you do have that timeline to move along. Now, kind of speaking from a strategy perspective, there is kind of a way that you can extend your period in the United States to look for an employer. And that would be filing a B2 change of status. So let's say hypothetically you are moving, you're not able to find an employer within the grace period. And as a result, you file a change of status to B2. Then let's say that B2 is pending adjudication and a couple months go by and you find an H1B employer who is willing to your H1. There is a situation where, without getting into too many specifics, you can attempt to file basically a change of status back to H1B and request that the B2 be adjudicated in tandem with the H1B change of employer. I would also recommend that you would have to do that in premium processing. So again, I know that was a lot of specifics thrown out there, but that is kind of an option for someone who's trying to extend their period in the United States. Now, the thing about that is the B2 is not giving you work authorization. So while you're able to legally remain in the U.S., you're not going to be able to work. So that's something that you have to factor in as well. But it's a way to sort of extend your timeline in the United States to look for an employer if you need to.
Right, right. Thank you so much for answering the question, Justin. John, now we would like to switch gears to the legal side a bit. So now I would like to know from you, what legal avenues are available for H1B workers, who believe that their layoff was maybe unjust or discriminatory?
So when it comes to employment in the US, most states have kind of moved towards an employment at will model. And that means that the employer can fire you at any time for no cause, and there's really no recourse. It gets even more tenuous if you're an H1B holder, because once you lose your status, then you're unemployable. And if the employer withdraws the petition or informs DHS that you've been terminated, that's it. There's nothing you can do. So your legal recourse against an employer for firing you is very, very limited. And so you really have to, look out for yourself and find ways to find a new job on time or, alternate arrangements.
Right, right. But is there any example maybe where the H1B worker was successfully, pursued legal action after a layoff?
So not really, not that I'm aware of.
Okay.
I haven't ever heard of that working out. I think there's so many, legal hurdles to that. I don't, maybe Justin's heard of something, but I haven't heard of anything that has ever worked out that way.
Okay. Justin, what about you? Have you heard of a case like this?
No, not really. I mean, the only thing that I could possibly think of would be if someone wasn't paid wages that they were owed, prior to their termination. Because then they would no longer be complying with the H1B. That's something that the employer the employee could report, and then they could open up an investigation as a result. But that would be kind of the only avenue I could think of. So I mean, because obviously even when you're laid off, you're still going to be entitled to the money that you earned while you were there for the hours worked. But outside of that, I'm in agreement with John. There's not a whole lot of recourse for them.
Yeah, and if they're going to go that route with the Department of Labor, it's important that you realize what your timelines are for filing a complaint with the Department of Labor. You have to do it within a year. And if you don't do it within a year, your chances to regain that money is gone. The other thing, to consider is if you've been working without pay, or you've been employed by that company without pay, and you're owed back pay, cooperating with DOL may help you if you file like a T visa for labor trafficking victims. So those are some things to consider when you're in that situation. You got a year, and if you're cooperating, you may make yourself eligible for another type of visa.
Okay. And what if, during that 60-day grace period, if the person gets arrested, then what should the person do, or what are the next steps?
If they get arrested, as in like a DUI or something, that's always a bad situation to be in. I guess it really would depend on what type of crime it is. If it's something where there's significant exposure to jail time, I would say if you still have your passport, go home. But otherwise, I think it might come up in an RFE, but typically not so much. I don't know. What's your experience, Justin?
I haven't, not for non-immigrant visas. I usually haven't seen it come up in an RFE. Where I do see that kind of become an issue is going to be at the consulate.
Yeah.
So if when you're going to get a visa, a new visa, and you're undergoing your interview, there's questions related to that in the DS-160. And obviously those need to be answered truthfully. And as a result, it's probably it's going to come up, and you could end up getting a denial as a result.
Okay.
Yeah. Justin's point about answering it truthfully is very important, because you got to keep in mind that all of the data with all these federal government and state law enforcement, systems are connected, and most of it is done on biometrics now. And so it's very easy to link up and aggregate information about a particular individual. And then that gets input into the consular consolidated database. And so the first thing that's going to happen when you go to the consulate is that database pops up. And if you've got a flag for whatever reason, they're going to know. They're more than likely going to know before you show up that there is, an arrest out there. So failure to disclose something on the DS-160 like that is really going to be the kiss of death for your immigration future, I think.
Okay. All right. We have also started getting questions from the viewers. So a lot of people have started asking their questions. So in between, I also would like to take the questions from the viewers. So if you would allow, I would like to take questions from the viewers. Is that okay, John and Justin?
Yeah, that's great. Sure.
Okay, so Madhvi is here, and then RK is here, Benisha is here. Hi guys, I hope you're doing well. Let's take RK's question. RK says, what impact will the increased registration fee next year have on the H1B program, as the program has become very expensive between filing fees, extension, etc. Who would like to take this?
So we probably both have different perspectives on this.
Sure.
Mine is more of an economic issue, which is when you drive up cost, you decrease demand. And USCIS has jacked up fees so much that they're really, cutting into any type of profit margin people have for hiring a foreign worker. So, companies that are used to transitioning employees in and out frequently are not going to be very profitable because of these increased fees, and will probably file fewer petitions going forward, would be my guess.
What about you, Justin?
I agree with John. I definitely think that unfortunately the increased fees are going to have they're going to be most harmful to smaller companies. Unfortunately, I think the bigger organizations that just have the bigger war chest, that have more more money to throw around, I don't think they're going to be as worried about the increases. But I do think it's going to give pause to smaller companies that are looking to hire foreign nationals, just because it's a big investment. I mean, you do have the increase that's also going in to the lottery next year for registrations too. And I think right now we've been dealing with such a low entry point for that fee that it was very easy to say, all right, whatever, it's nothing. It's $10 a person. Let's throw this person in. If they get selected, great. We'll figure it out. Raising it now, I think you are going to see employers probably pausing a little bit and digging a little bit more into how viable it is to register the individual. I could tell you from experience that I was working with a company last year that had a couple people who got selected that they just didn't file for because they never really even bothered into looking into their status or seeing, what it was going to be for them to change status or what steps they would need to take. And as a result, they ended up not filing for them. Now, when you're just eating $10, that's not that big of a deal. When you're eating more money, I think, there's more of a consideration. And then like John said, the fees have been continuously raised to where you are really making a financial investment filing for an individual. So I think, taking both of those together, you might see less people filing as a result.
Yeah. And maybe then, people won't be expecting people because there will be less chances, and there won't be too many people waiting for a second lottery or the third lottery, right? So in the second lottery, I think some 14,000 have something around 14,000 people have been selected in the second lottery, but still there are a lot of people. 14,534 to be exact. But there are still a lot of them, who must be waiting to still get selected. Do you think we still have an option for a third round? What do you have to say, John? Can they be hopeful?
I think the third round, it comes down to an issue of timing because they've got to wrap this up by September 30th. And knowing how slow USCIS does everything, that would be a real challenge for them to get a third lottery in.
Right. Justin, what about you? What do you think?
Yeah, I agree. And I think that's kind of echoed by the window for the filing period that they gave on the selection notices, which run, if I remember right, all the way into November. I can't see them because they're going to wait for everything to conclude because everyone has that window to file that 90-day period. And then only after that time would they really be able to kind of look and make a determination of whether or not they have more spots available. Like John said, with the way the government works, how slowly they operate, I don't think it's realistic to expect there to be a third lottery.
Wow. Okay. I'm sure a lot of people will get disheartened after hearing this, but if that's the truth, I mean,
I would love to be wrong. I would love to be wrong.
Right. Okay. And RK also has one more question. He says, do you see more employers just saying it's cheaper to just poach workers rather than spending thousands of dollars to register for the lottery? What do you think, John?
So I think when it comes to the consultancy companies, you look at the way their business model works, and there's a lot of turnover, and that drives costs on petitions. So poaching employees doesn't really save you a whole lot of money. You're still having to pay filing fees. You're still having to pay, lawyer fees for petitions. And so the people that are in the smaller businesses, like Justin mentioned, tend to have bigger turnover, and their costs are going to be higher. And my guess is you'll see a decline in their filings, and you'll also see a decline in revenue that USCIS collects. And the grand irony of this is, if I'm right, and they do lose a lot of revenue because of the cost, because of the supply and demand, USCIS is going to have a bigger budget shortfall than they already do, because they've started hiring in anticipation of these new fees being collected at the same rate as the old fees. And when that doesn't pan out, there's going to be, a huge gap in their budget. So it remains to be seen how effective this new fee increase is going to be.
Okay. And we have one more question, and this question is from Maria, and she says, I heard in a video that employers can only file petition one H1B employee. Is that true? Justin, do you think it's true?
So typically when you're filing an H1B, you're going to be sponsoring one beneficiary. Or is the question asking something else? Are they asking if you can only file as the petitioner for one individual? I'm a bit confused.
I think that employees can only, it seems a bit general. I heard in a video that employees can only file petition one H1B employee. Right. Even now, I'm trying to understand the question whether it's talking about one employer or one.
I guess if we're talking about the lottery, then no, because the petitioner is able to file for, however many selected individuals they have. Now, if they are saying, can they only file for the employee that has been selected in the registration notice? That is correct. You can only file for the individual that actually has the selection notice with their information on it. So in that circumstance, yes, you can only file for that person. You cannot transfer a selection notice, meaning you can't use it for somebody else. And it works the same way for the petitioner. You can't have a different employer sponsor you just because you were selected by employer A. So you can't just move over to employer B to have them file your H1B in the event that A no longer has a position available for you. I hope that answers the question.
Yeah, it does. It does. But John, would you like to add something to it?
No, I think Justin covered that pretty well.
All right. Okay. So Maria, I hope you have got the answer, and let us know if you would like to know something else, or maybe you can rephrase your question if you meant something else, so that Justin can maybe give a proper answer to your question. And now,
I did want to say just real quick, if I could, about the whole poaching employers versus filing in the lottery. I think John made great points on that, and I did want to add too. I will say that, when you get a new H1B employer, you do have them for 6 years, or at least they have 6 years on that H1B. And obviously you can go through the perm process and get an I-140 that allows you to continue extending. A new employer that's just starting that first year of H1B has different considerations than someone who's maybe in their 4th or 5th year on an H1. So, if they're in their 4th or 5th year and they haven't started the perm process, or they don't have that approved I-140, that's something an employer is going to, or at least should take into consideration when they're looking to transfer the employee. So I would definitely say that there's going to be employers that think it's better to just have that new employer on an H1B. Rather than going to look for someone else that's going to carry all the hiccups of maybe needing to extend beyond 6 years.
Okay. All right. Thank you so much again for answering the question, Justin. And again, I would like to come to you, and I would like to come back to my own questions again. Then of course, in some time, I will again move to the audience's question. But right now, I would again like to ask from you that once, an H1B worker is laid off, so what should be the immediate steps that they should take to maintain their legal status in the US?
Okay. So yeah, I think that it's going to be determined based on whether or not, first off, I think the best situation for pretty much anyone's going to be, can you move to another employer on an H1B and continue your H1B? Because that's going to be the easiest part. The easiest way. It's the most straightforward way to deal with the situation. So after you unfortunately lose your job, I would say immediately begin, reaching out or using a recruiter or taking those steps to begin finding another avenue of employment. As we talked about at the beginning of the call, it is a 60-day grace period, but for that H1B, it's actually a shorter timeline because you got to make sure that the case is filed and received by USCIS. So that would be my first option. My best course of action would be that. Second option is going to probably be changing status. That could be maybe if you decide to file a change of status to F1, maybe you're able to pursue a second master's or your first master's degree in the United States, based on if you were selected with a bachelor's degree only. So that would be option number 2. Again, you want to make sure that that's filed and received by USCIS within the grace period. Option 3, and probably the option people don't want to hear, is going to be just departing the United States. Now, while that's not an ideal situation for anyone, you can think about it like this. Just because you're leaving the U.S. doesn't mean you can't have someone sponsor you for a new H-1B. They'll just have to file a consular notification or consular processing. So that is still something that you could explore. Now, I do put it at the bottom of the options because I think it's the one people least want to pursue. But it is something that's on the table. So I would definitely say in tiers, tier 1, getting a transfer to another H1B employer. Tier 2, filing that change of status. Maybe you file a change of status to B2 to buy yourself some more time to find a new employer for your H1B transfer. And then you have to go through that strategy of filing the change of employer, the change status back to H1B and premium. And then tier 3, maybe having to depart the US and wait until you can find a new employer to sponsor your H1B consular notification.
Okay. And John, in your experience, how quickly do most laid off workers find new employment, and what do you think are the most challenges do they typically face in the job market?
So I think it's really just dependent on the economy at the time they get laid off. Usually, when there's layoffs, that's usually a bad indicator for the broader economy. It's going to be harder to find jobs because most employers are pulling back. So, it's going to be a challenge for people, I think, in the tech industry to find new jobs in the short term until the economy starts to improve a little bit. So I wouldn't be surprised if there's a lot of people who hit that 60-day window and end up losing their status.
Okay. And what do you think? What happens to H4 EAD if someone gets laid off?
Then nothing. I mean, they're totally fine. That's the best case scenario of all of these options. That's the best case scenario. If you're an H4 and you have an EAD and you get laid off, you have all the time in the world to find a new job, and there's no problem with your status. And there's no problem with your EAD because it's not tied to the employer.
Okay. Justin, would you like to add something to it?
No, it's just, for whatever reason, the H4 EAD, it seems like a better deal than the H1B. But yeah, John's right. You get laid off, no problem. There's no work requirement for the H4 EAD. Right. So you got plenty of time to find a new job as long as the principal, the H1B holders, is remaining in status, you're fine.
Okay, and we have one question, which is here on LinkedIn, and the question is from Abbas, and he says, after 6 years of H1B, what are the extension options? Who would like to take it, John or Justin?
So I can take a high level. Justin might have some more in depth, but sure. You don't have a lot of options. If you don't have an I-140 or a immigrant visa in progress, then you don't have any extension beyond the 6 years available to you. So you've either got to leave the country, find a new visa status, or go back into the H1 lottery again and get a new H1 that allows you another 6 years. Did I miss anything there, Justin?
No, that's it, really. I mean, there's a very narrow caveated situation where you could have a perm that was filed before your 6th year. So you got to file it basically a full year before you max out. And then if it's still pending for whatever reason after your 6th year, at the 6-year expiration point, you can apply for a 1-year extension. And that's really the only other option that you have. And that's very nuanced and specific. It requires, you have to strategize that. I mean, really with your attorney, because you've got to be filing right. I mean, if not right at, then well before that 365-day period before the 6th year hits. But outside of those circumstances, it's like John said. I mean, that's really your only options.
Okay. All right. So Abbas, I hope you have got the answer. Thank you so much for your question. Let us know if you have another one. John, I would like to come back to you again, and I would like to know from you that have you noticed any trends in litigation related to layoffs in the tech sector, particularly concerning immigration status?
So I think the biggest trend that was beginning to develop was with something called OCAHO. It's a administrative court system that the Justice Department runs for claims of discrimination based on immigration status and employment. And there's these, advocates for the tech industry that file a bunch of very specious claims with OCAHO. they're not really looking for employment, but they just go onto all these job websites and they apply for all these jobs. And when they don't get selected, they claim it's because they're preferring immigrants, and so then they're suing within OCOHO. That was a trend until OCOHO got shut down recently by a federal court because it has some legal problems with the way that it's structured. So depending on how that works out and how that's resolved, that issue may come back or it may go away entirely.
Okay, and what implication do these trends have, in terms of compliance and risk management?
So for the OCOHO cases, it's frustrating because you can comply with all of the Department of Labor's rules for recruitment, and you can do everything right according to the book, but still make out an OCOHO complaint that makes the employer liable. So it's very frustrating because you're kind of in this gray area. Even you're damned if you do, you're damned if you don't. You can follow all the rules and still have to pay a hefty penalty to the government for it. So it's one of the more frustrating areas of immigration law right now.
Okay. All right. Thank you so much for answering the question again, John. And RK is back, and he says, what happens to the H4 EAD if the spouse on why am I not able to display it on screen? Let me, okay, here it is. What happens to the H4 EAD if the spouse on H1B gets laid off, for which your H4 is dependent on? Dustin, would you like to take it?
Yeah, I think that's a difficult spot. I think that it's unfortunately a difficult spot because the H4 is dependent on the H1B. So as a result, you're not immediately impacted by the layoff. What I mean by that is the EAD doesn't just go away, and there's not any issue with the H4 holders failing to maintain status during that period. The problem becomes, if the H1B holder is not able to transfer to another status, or if the H1B holder has to change status, then you get into a situation where the primary is no longer maintaining their H1B status, which that H4 is dependent on. So I think you get into a bit of a gray area situation there where you're saying, well, is the H4 going to still be valid as a result? And as a result, will the EAD be valid as well? I think that's kind of going into a little bit more detail than my thought process would be, and John can tell me if he agrees or if he differs. My thought process would be, if you're changing status, then arguably until the change of status goes into effect, there's not anything happening to the H4 itself. But once that primary does change status, if they move to B2 or F1, then you can no longer hold H4 status because it's dependent on the primary. So that would be my thought. And then as a result, once you're no longer able to be an H4, you can't utilize the EAD. I don't know if John sees it differently or if he thinks the impact of just filing the change of status would impact them.
So it's one of those areas that USCIS has never given any guidance to the public on. And a lot of times when they do that, they can enforce it both ways if they want to, because there's really no rule that says they can't do something, and there's no rule that says what they have to do. I think in this situation, if both arguments are probably equally as strong, whether or not either the status and the EAD terminate at the end of the 60th day, or whether or not they're good until there's an adjudication on the change of status petition. We just don't know how USCIS will answer that question in any given particular situation. So if you're worried about it, caution is always the best thing to do when it comes to your immigration status. So talk to an attorney just to make sure you're not going to jam yourself up.
Right. Mm-hmm. And I do think that, the H4 EAD itself, I don't think is really it's not going to go away. I don't think just because the H1B holder loses their job. But the issue kind of for me becomes, are you maintaining your H4 status if your primary has already filed a change of status to move into another status, because they're no longer in H1B. They're not holding it. They're in the United States because they timely filed a change of status to another status. So I'm not sure if that means does USCIS actually make an action or a move to invalidate the underlying H4 status or the EAD. I'm not sure. I haven't seen that specifically, but I do think John makes a great point. You kind of preach caution. You don't want to be violating your status. So yeah, I would just be careful about that, and hopefully you're not dealing with that situation because the H1B holder is able to find another employer.
Right. And he's also back with another question. So he says, after max out, do you re-enter the lottery? I thought you just had to stay outside the country for 1 year before returning without needing to re-enter the lottery. What do you have to say, Justin?
Oh man, I think if I remember right, and maybe not. I don't know if did I say that? I think if I remember right, that you can still remain cap exempt if you leave for a year. I'm pretty sure. I haven't encountered that question, so maybe in a while. So maybe don't take my word for it. But I do think it is possible where you can stay out for a year. But I'm so sorry. I can't remember that right now.
John, what do you think? I mean, have you encountered that question?
So, statutorily, unless there's something in the regulations that I'm missing, statutorily, you're capped at 6 years for the H1B. So there may be some ambiguity in the statute that the agency's exploited to create an exception. I just don't know off the top of my head. I'd have to look into that.
And if you're thinking about a situation where you don't utilize all 6 years of the H1B and then you depart the United States and stay outside for a year, is that maybe more an option that you're talking about exploring? Because if you completely max out, I'm pretty sure, if I remember correctly, that you're going to have to go back into the lottery.
You can do recapture, right? You can So that's probably the option that you've got, is go through your pay stubs, go through your travel history, and see when you were not working in the U.S. and try and do recapture. You've got a little bit of time to play with.
Mm-hmm.
Okay. And let's say if the H1B worker cannot find a job within the grace period, so what options do they have to change their status?
If you're not able to find a new job, you can move to another non-immigrant status. I would definitely say the B2 option is going to be there for you because it's a visitor visa. It gives
you cannot work on that visa, right?
No, you're not given any work authorization on that. You get it's 6 months, and it can be subject to an extension. But it allows you to remain in the United States. Now, the other option is going to be an F1. If you move to F1 status, then you have maybe potentially the option to work, depending on what your school situation is and what type of degree you're pursuing. Maybe you're able to do CPT or something like that. Then I would also say, kind of just thinking off the top of my head, a great situation would definitely be, if your spouse is an H1B holder, or maybe an L1 holder, maybe they have a visa that allows you to change status to H4 or L2, which would give you about an opportunity to get work authorization. Now, for the L2, if I remember correctly, your work authorization is going to be incident to status. So that would be a situation where you could just change status and start working immediately. Whereas the H4, you are going to need your spouse to have that approved I-140 in order for you to apply for the EAD. So, it would depend, but that's still going to give you a better situation likely than if you're going to be transferring to a B2 or an F1. That being said, as I kind of talked about a little bit earlier, you do have that option with the B2 to kind of use it as a bit of an extension period to find another employer. And then you can maybe hopefully find an H1B employer who's willing to sponsor you, and then file that change of status in premium back to H1B. Typically, when I had done those cases in the past, what I would do is just ask USCIS if the B2 is not adjudicated to adjudicate both cases in tandem. So meaning at the same time. So you would basically put a note or a cover letter or something just saying, B2 is pending for this individual. They're legally in the United States. In order for them to move back to H1B, we ask at this time that USCIS adjudicate the B2 and then the H1B so that the individual can be put into H1B status and continue working with employer X.
Okay. Thank you so much for answering the question again, Justin. John, I would like to come to you. Are there any particular visa categories that are more accessible for laid off H1B workers? And if yes, what is the application process like?
So like Justin says, the B2 and the F1 are probably the most common that we see people transition into. Yeah, if you're doing an F1, just, my advice is to always try and go to one level higher of education if you can, instead of just getting a lateral degree. USCIS tends to be suspicious of the lateral degrees, the second degree. So those are your two best options at this point, I think, unless you're married to, like Justin says, an L1 or an H1, and then you've got those options available to you to transition to a dependent spouse visa. And the L2 is a great one because you have work incident to status, and it didn't used to be that way. It used to be USCIS made people pay for application fees and wait 6 to 7 months for a EAD card. But after losing that issue in court, now it's just incident to status. So if you have an L2, you can work.
Right. And we are still getting a lot of questions from our viewers, and Abbas is actually back. He says, if the perm is in process and you are past the 365 days, even if your 6 years of the H1B are done, you are still in status? Justin, would you like to take that?
I think this might be kind of piggybacking on what I was saying earlier, and I don't think that it's kind of understanding what I was trying to say. So what I was trying to explain was there's a very specific situation where if you file, if your perm is filed 365 days before you reach 6 years. So what that means is one year before your max out date, and it is still pending before your 6 years maxes, then you are eligible for 1 year of an extension of your H1B. So what that means is you can file for a 1 year extension with the understanding that 1 year is going to allow the perm process to conclude, or for you to file your I-140 after it's approved. That's kind of the specifics of what I was trying to talk about earlier.
Okay. And we have one more question. And this question is from a LinkedIn user. We don't see a name here, but the question is, if my H1B got approved, but my employer is not allowing me for stamping, is there any chance to transfer my H1? Do I have to file entire H1B petition or only LCA is fine? John, would you like to take this?
Actually, that's probably an area that Justin's more of an expert than me. So I'll defer to him on that.
Sure. Yeah, I got you. My H1's approved and the employer is not allowing me to go for stamping. Can I still transfer my H1? Do I have to file the entire H1B petition? Yeah. So if you're changing employers, you have to file a petition. It's not sufficient to just file an LCA. So if you're in a situation where your employer is not allowing you to go for visa stamping, and I guess maybe because they're going to get rid of your position if you depart the U.S. for an extensive period of time, and you want to transfer your H1, you can do that. But it's not sufficient to just file a labor condition application with the new employer. You need to file a new H1B. And I would also go as far as to say, wait for the H1B to be approved before you're traveling. And since it's not a change of status, it's not going to be denied just because you've departed the U.S. But I do think you want to stay in and make sure that case gets approved before you go abroad and try to get a visa stamp, just in the event that maybe you get an RFE that draws the case out, or maybe in the event that you end up unfortunately getting a denial and you have to remain with that first employer.
Okay. All right. So the name is Yashwant actually, but we can't see the name here. So Yashwant, I hope you have got the answer. Thank you so much for your question. We're still getting a lot of questions. Let me quickly take other questions too. So Hamid is also here and he says, can you talk about EB2 or H1B? Well, H1B is something that we're already talking about. So if you can talk about EB2. So John, would you like to talk a little bit about EB2 as well?
Yeah, I guess which type of EB2, I guess, would be my first question. Is he looking at a national interest waiver or just the advanced degree, professional degree visa? So, the national interest waiver is tough to get, but it is highly sought after, I think, by a lot of people, just because it avoids a lot of the hassle and the administrative work that has to go into filing a petition. But the EB2, just regular EB2, just requires you to have a master's degree or an advanced degree in order to qualify. So the EB3 professional category requires that you have a 4-year bachelor's degree. So a lot of countries have a 3-year bachelor's degree. USCIS will not accept a baccalaureate degree. They require you to have a 4-year. So they'll take a combination of, say, a 3-year degree and then a 2-year master's degree to qualify for the EB3 professional. But if you want to qualify for the EB2, you've either got to get a new master's degree, or you have to have over 5 years of relevant work experience, and that's progressively developmental in that area in order to qualify as a substitute for the degree. So it's a very high level overview of it, but regular EB2 requires a labor cert, so it takes just as much time as the EB3.
Okay. But Justin, would you like to add something to it?
No, not on the EB2 part. I will say for the H1B part, because I know we had discussed earlier about the whole issue of maxing out your 6 years. I did want to go ahead and look into it. And it does look like under INA 214G4, it does look like if you do reside and remain physically present outside the U.S. for 1 full year, there is eligibility for a new 6-year period H1B status that restarts. So I did want to clear that up and look into it. So it does look like if you do max that 6 years out and then you go remain outside the U.S. for a full year abroad, you can restart your 6-year period.
Okay, this is so great. Yeah, even though we are taking questions, the new questions, but you're not forgetting about the old ones. So thank you so much for also doing that.
Yeah, no problem. It just bothered me.
Thank you so much. And John, I would like to again come back to you and talk to you a little bit about how do tech layoffs affect individuals who are in the process of applying for a green card, especially those with pending I-485 applications.
Yeah, that's a very tough situation, because you've got to have that continuing offer of employment, and it's going to be a case-by-case situation, but you've got to have a 485J that is backed by a legitimate offer of employment, and getting that in this environment might be a little tough, but it's what you've got to do. Justin, you got a different take on that?
So I think the people who are in the process with the 485 applications, they're in a tough spot. I think the people who are really just out of luck are people that are going through perm. Because if you're in the perm process, you're maybe going through recruitment or something like that, and you get laid off, there's no recourse. It's done. You don't have an opportunity to move forward. And you're not going to be able to, go through with perm and then get to the I-140 process. Now, if you have an approved I-140 and your I-140 has been pending, has remained with the employer, I believe it's 180 days, then I believe you can end up transferring over that I-140 in the future, so you can maintain that benefit. But I think the people who are most affected by it are going to be people that are going through perm. I actually saw that, unfortunately, in my prior position, where you just had recruitment cease on all these people that were undergoing layoffs. And, these people are under the belief that, that their H1Bs maybe in its second or third year. They have plenty of time to go in and have everything set up to where they can get their I-140 approved. And if they're from a country where they have to wait a while, they at least have the ability to continue extending that H1B. And then that's all gone because they're laid off. So it's kind of like you're dealing with two problems. Not only are you dealing with the problem that, you have to look for an H1B employer, but then you turn around and have to consider, oh, great, now I have to restart this entire process, which it's a long process. I mean, the prevailing wage determination alone right now is taking between, I think, 3 to 5 months. Mm-hmm. So, I do feel bad for people that are dealing with that. I definitely would say your priority one should obviously be trying to move employers just so you can maintain your H1B. But then once that happens, I think priority two is saying, hey, if you don't have that I-140, we got to get moving on perm. So yeah, that would just kind of be my input. Is it's a tough situation to be in for multiple reasons. And that's why I think when you're having a conversation, with your attorney or whoever you're working with during the transfer process, I think that's definitely something you should bring up, or at least make everyone involved aware of, your employer as well. Like, hey, my 6-year max is X, and what are we going to do to address that?
Okay, so any advice would you like to give to those in the middle of their green card process who are now facing uncertainty due to layoff, maybe?
I don't really have, John, if you have anything. I mean, it's just hope your employer is going to sponsor that position, but I don't know.
John, what advice do you have for them?
No pearls of wisdom on that one. That's a tough spot. It really is.
Mm-hmm. All right. Okay. So I think we still have a few questions from our viewers, so let me quickly take them as well. And then I have a separate question actually for the both of you, so I will take that towards the end. So Benisha is also here, and she says, I'm facing a layoff and considering transitioning to another visa category such as O1 or F1. What guidance can you offer, and what are the key considerations for each option? John, would you like to take this?
So for the F1, it requires you to pay for tuition. That's expensive. I honestly don't understand how people do it. You're unemployable many times on the F1, and you're having to pay a god-awful amount of money for tuition. Just seems like it's a tough time. The O1, much cheaper, but your standards are quite a bit higher. If you're, depending on where you're working, what field you're in, if you're in AI, great. Your odds of getting an O1 have just been dramatically increased by the Biden administration. But O1s are one of those kind of weird areas of law where the standards are so vague that it really is just in the eye of the beholder of the individual adjudicator. And the frustrating thing is, and this was frustrating to me when I was watching it happen when I worked for USCIS, is that you have people that can barely turn on their computer, that can't map themselves to a printer. And they're making these decisions on these O1s and whether or not, they're really outstanding and whether or not they're, head and shoulders above their peers in their abilities, when they really don't have any clue what you do. So that's the frustration with the O1, is that it's kind of like art. It's in the eye of the beholder, and the only beholder that matters is that individual adjudicator.
Okay. So Justin, would you like to add something?
Yeah, I would say that for the O1, I've done a few of them, and like John said, I mean, you're looking at a pretty high bar. It's a lot. Evidentiary, you're looking at a lot that needs to be supplied, and then you're kind of having to be a teacher as the attorney, because the adjudicators don't understand what these people do. So not only are you trying to explain what this person does and what makes them prestigious, you're also having to basically spoon feed that officer an understanding, or at least a layman terms understanding of what this person is and what they bring to the table. Now, it's easier to do that when you can show awards, things like, he placed in this competition or he received this distinguished award. That helps, but that's not always an easy thing to do. So it really turns on, the ability of the attorney to interpret the information provided by the employee and just how much data really the employee can put together to be used. I will say that, I've done some unique O1s that were approved that were for, people in marketing positions that had just, they had worked at prestigious companies and they'd received a lot of accolades as a result. And that we were able to successfully adjudicate those get those adjudicated without issue. And then I've also done one for tech people who seemed extremely prestigious. They had a lot of, research papers and things like that made them very distinguished. And we ended up getting RFEs on those. Whereas I kind of thought, oh, these people seem so clear cut. I can't believe that it would even merit an RFE. But I do think it kind of goes back to what John says. It's up to that officer really to make that determination. And we don't know who that officer is or how much they understand about, like John said, for example, artificial intelligence. So yeah, I would just say, between the two, the O1 is going to be the much higher burden, the much higher evidentiary requirement, and it's going to be the much more difficult petition to put together. I would definitely say you need to talk to an immigration attorney before you try to consider an O1. I would never ever consider filing something like that on your own.
Okay. So, Vinisha, I hope you've got the answer. You've got the answer actually from both of them, from John and Justin. So, thank you so much for your question. And John and Justin, before I let you go, there's one case that we got on WhatsApp. So, I would like to read this case for you, and I would like to take both of your opinions on this. So, it says, my mom's green card application I-130 was approved. She's currently in India, so I filed an I-824 to forward the approval to the NVC for processing at the correct consulate in India for her biometrics appointment. Despite multiple follow-up requests, I haven't received any updates from USCIS. Online case status shows received, but I did not get a mail confirmation. Communication requested status via email was directed to reach out to the lockbox email, but received no response. What steps can I take to expedite this process and get a response from USCIS? John, would you like to take this?
Yeah, so USCIS's mailroom has always been a little bit spotty in their efficiency and their capabilities. They lose mail all the time that they're sending. They lose mail all the time that they're receiving. And it sounds like she's in that situation. USCIS, as frequently as they screw up, will never admit that. And so when you're trying to fix a USCIS screw up, it's always going to take a lot of work to do that. And so there's no quick, easy way, because the agency has basically walled themselves off from the public, and there's no engagement with the public, and there's no way to simply or easily resolve a problem. But they are required by law to give you that receipt notice. And the fact that they haven't done it means that they haven't complied with the law. And anytime that happens, when it's clear cut like that, you can file a complaint in court saying, hey, I want my receipt. And you'll probably get it within 60 days because the government has 60 days to respond to a complaint in federal court. And the U.S. Attorney's Office that gets that complaint is going to look at it. And the first thing they're going to do is they're going to call the agency and say, mail this out. I don't want to deal with this case. Make it go away. And you'll get that. I don't know if Justin has an easier way to fix this problem, but
Justin, do you?
I mean, not really. It seems like she's gone through the avenues that are generally recommended. You could try using EMA, which is like the service that's on USCIS's website, to raise a service request, to explain that you haven't received the notification. That would be one avenue that you could try pursuing. But that would be kind of the only real advice that I could give you. It's gonna take time, because they're gonna intake it, and then they're gonna say, hey, we're gonna have X amount of days to respond. But that would be my general advice. Would be to try to use that service. I know some people have actually been able to use it recently to get like typographical errors on receipt notices corrected. and sent to them. So, I mean, if it's advanced enough to be able to handle a situation like that, maybe it could handle something as simplistic as locating a receipt notice.
And we can only hope that they really incorporate AI into their operations and replace all of their adjudicators.
Okay. On that note, thank you so much, both of you, for coming and doing the show. We always do it with John or either Justin, but having two of you together it made it even better. So thank you so much for your time.
It was good being here.
But
Yeah,
so
thank you
before
so
I let you go, any last message for the ones who are facing layoff? Let's start with Justin. Justin, any last message?
Yeah, I would just say, I know getting laid off is tough. Trust me, I've undergone that experience myself. So I would just say, brush yourself off. Get the online resume ready. I would probably try to work with a recruiter to see if you can move into a position. Maybe be open to something that you wouldn't traditionally be open to. If it's a drop in salary, it is what it is. I think the primary goal here right now is, ensuring that you're staying in the United States and staying in status. A transfer doesn't mean you're with the employer forever. It just means you're with the employer right now. So that would kind of be my general advice is, look for what you can find it as fast as you can. And I would also say from practice experience, when you're moving to a new employer, you might need to be a little bit of a pain to make sure that case gets timely filed. Because if it's an employer that doesn't hire a lot of H1B employees, they may not realize how long the time process is or all the steps that go in to having the H1B filed. So you might need to be on top of them from the moment that offer letter gets signed until you know that the H1B has been delivered.
Okay. And what about you, John? What advice do you have?
So this kind of applies to people who haven't been selected in the lottery and are in this situation with layoffs. One thing to keep in mind is that there are cap exempt employers out there, and they tend to be large organizations that run on annual fiscal year budgets that aren't quite as impacted by the sways and the fluctuations of the economy, and provide a lot more stability. The wages tend to be lower, but it does give you additional flexibility. And if you're married to somebody and you have a cap exempt H1, they're an H4 eligible, potentially eligible for an EAD if you have a labor cert in progress. So, that's something to consider. I would look for those cap exempt employers as a potential opportunity.
Okay. Thank you so much again, John and Justin, for doing the show. But we have just received another question from a viewer. So can I please take that if that's okay for you? Before I let you. Okay. So Justin, don't worry. This is going to be the last one.
Oh, no, I'm fine.
Okay. So this question says, can I apply for a B? Okay. Can I apply for a B1 or F1 visa if my H1 has already been approved by my employer, who is not allowing me? I don't know why am I not able to show it here on screen. Okay, here it is. Can I apply for a B1 or F1 visa if my H1 has already been approved by my employer, who is not allowing me to go for an interview? If I apply for a B1 with same employer or F1 again, will there be any issues regarding being considered a potential immigrant?
Okay. Trying to be as nice as possible. This question's a little all over the place. If your H1B has already been approved by your employer and they're not letting you go for an interview, I'm assuming that means they're not letting them go for a visa interview abroad. If I apply for a B1 with the same employer, you don't apply for a B1 with an employer. That's a visitor. That's a business visa or a visitor visa, like a tourist visa. Right? A B1 or an F1. An F1's definitely not employer specific. Will there be any issues? Potential immigrant. So I'm guessing this whole question kind of is that they're asking about immigrant intent. The worry about immigrant intent if they switch between an H1B and an F1 or a B1 is that what's being asked?
Okay, so Yashwant, if you can please clarify, because yeah, B1 and F1, you don't need an employer to. That's right. But with whatever that you can understand, do you have an answer, or maybe John, do you have an answer with whatever that you can understand from this
Well,
question?
they're all non-immigrant visa categories.
Yeah.
So there, I don't really see anything there that would impact, the immigrant intent issue. Immigrant intent is usually when you have, an application for an immigrant visa and you're trying to come in on a, non-immigrant visa that is not a dual intent visa, then there's issues there in terms of establishing your non-immigrant intent. But where all of these are non-immigrant visas, I don't really see that being an issue.
Okay. Okay. Right.
Yeah, I guess too. What's I guess kind of throwing me off about this question, and I think we've seen another question about this too, is this issue that your employer is not letting you go for a visa interview. I'm that's an interesting thing for me to see. I mean, I've definitely seen employers say, "Hey, don't go," during a busy season or a certain period. But I mean, you're gonna be allowed to. You're eligible for vacation. I mean, if it's part of what you were hired on and part of
Yeah.
like your employment package. So it seems odd that they would, just be able to block you off from going for visa stamping. If you're traveling abroad and you've scheduled an appointment, you should be able to go. I don't know. It's interesting for me to see that this is a second question about, people having issues where their employers are not letting them go for a visa interview.
Okay, so Yashwant, what you can do is maybe you can directly get in touch with John and Justin, and here are their contact details. The number is 844-592-7336. I would like to repeat the number, 844-592-7336. Their email is support@wasden.law, and you can also check their website out, which is wasden.law. So yes, get in touch with them, everyone, and Yashwant, specifically you, so that you can get a better answer from them. And thank you so much. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is 732-707-9151. And my email is rajni@higheritpeople.com, and our website is www.higheritpeople.com. So yes, you can also check that out. Remember, we sponsor H1B visas and other work visas based on job availability and regulations. With that, thank you so much again, John and Justin, for being here. And it was a great, great episode, and looking forward to our next episode now.
It's good being with you. Thank you.
Yeah, thank you for having us. Have a good day.
Thank you so much. And to our lovely viewers, I hope you enjoyed the episode too. Thank you so much for sending in your questions. We greatly enjoyed, taking them. And I'm sure John and Justin also enjoyed answering their questions. So we have another webinars coming up at 12 and 2. So don't forget to, watch them. So stay tuned with Immigration and Jobs Talk Show. I'm Rajni Bharara. Keep subscribing, keep watching our channel. And yes, if you like our webinars, if you like our videos, so don't forget to like them, share them, and also subscribe to our channel. And right now I'll have to take your leave because in about half an hour, or I think 40 minutes, we have another webinar coming up with immigration attorney Prashanthi Reddy. So don't miss that. And for now, bye, take care, and keep subscribing to Immigration and Jobs Talk Show. Take care.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higherit
Hello, everyone, and welcome to Immigration and Jobs Talk Show. And before I move ahead, I would like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and today we are tackling a topic that is both timely and crucial for countless international students pursuing their dreams in the United States. Whether you are about to embark on your academic journey or you're already navigating life as an F1 student, this episode is one you cannot afford to miss. Well, imagine this. You have done everything right. Secured your F1 visa, packed your bags, and prepared yourself for an exciting future. But upon your arrival in the US, you're stopped at the airport, questioned, and before you know it, you're facing the possibility of being sent back home. This nightmare scenario is unfortunately a reality for some students who fall afoul of US immigration laws. So, what can you do to avoid falling into this trap? And also, what are some common pitfalls and how can you safeguard your future? To discuss about all this, we have today with us none other than litigation attorney Jonathan Wasden. So, without any further ado, let's welcome him once again to our show. John, welcome back once again to Immigration and Jobs Talk Show.
Good seeing you again.
Thank you so much. Likewise. And to our lovely viewers, I would like to tell you that we are live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. So don't forget to subscribe to us. And if you have any question that you would like to ask from John, so please keep commenting them in the comment section. Keep asking your questions. We'll be glad to take them. And now, John, before I talk about, today's topic, which is F1 students, how to avoid deportation. Before I talk about that, I also would like to ask you about the H1B second round of lottery, which was announced yesterday. So if you can, please provide a brief overview about the second H1B lottery announced by USCIS, and why do you think it was necessary?
Yeah, sure. So up until a few years ago, the way they ran the lottery was they would run everybody through the first round and then get to that 65,000 bachelor's cap. And then they would run the master's cap. So they flipped that, and now they run the master's cap first, and then they run the bachelor's cap. So this year, what happened is the master's cap was full after the first round of the lottery, but the bachelor's cap still was not full. They didn't have enough petitions filed after selection. So they're running the bachelor's cap again. Now, it's kind of a confusing way to phrase it because the people with masters, PhDs, and bachelors all get run through the bachelor's cap all together. So it's for a master's degree or higher, it's really your third bite at the apple. And, bachelor's, it's your second bite of the apple. So to me, the reasons for it, just they didn't get the volume of petitions that they needed to, fully fill up their 85,000. And so they're going to redo the draft. It should happen relatively soon because these visas have to be awarded prior to the end of the fiscal year, and that's September 30th. So I would anticipate we'd be seeing the new lottery in the next few weeks, maybe a month at the most, and then selection notices will be coming out then.
All right. So, and what about the applicants? I mean, what can they expect, and what is that they should be looking out for?
So just updates from USCIS about the lottery being run, and then checking their online account to see if they were selected.
Right. And now that the second lottery has been announced, do you think there's a possibility of also having a third lottery?
I don't think so. I think the second one will probably fill it up. I mean, we're already in August, so we've only got 2 months left in the fiscal year. So I don't know that we have actual time for a third lottery even. So I would expect this would be the last one.
Okay. All right. Thank you so much for answering the questions related to H1B second lottery, John. Now let's come to the topic that why we are here. to discuss the topic that we are here for, which is F1 students and how to avoid deportation. So my very first question about this topic is, so, John, there's been a specific section of US immigration law, section 212A, 6 and C, that has been causing a lot of concern basically among the F1 students. So if you can please explain what section 212A, 6 C covers and why it's particularly relevant for F1 students.
Yeah, sure. The 6C finding is what the commonly referred to in immigration world is a fraud finding. It covers fraud or material misrepresentations that were knowingly made by the foreign national in an attempt to get an immigration benefit. So all of those things have to be met in order to substantiate a 6C finding. When USCIS makes a 6C finding in, say, a petition process, that's something that's very easy to challenge and take to court because there's no protections for USCIS going to court. One of the most frustrating things, though, in immigration law is that the law makes decisions at the port of entry bulletproof to judicial attack. And so it's very frustrating because you have very low information CBP officers making decisions on people's lives that have a far-reaching impact, and sometimes they're not doing it with all the best information or best motives at heart. So port of entry is an inherently dangerous situation for anybody coming to the country on a non-immigrant visa.
Okay. So, it sounds like this section covers some serious grounds on inadmissibility, right? So, So, how often do you see these cases where students are unaware that they violated this section? And do you think more awareness could prevent some of these issues in the future?
So it's really scary because I've seen cases where, the famous one was the Atlanta case a few months back, or maybe actually a year back now, where there was a group of students on a flight coming from India, right, and they all got stopped, sent to secondary, and sent home with fraud findings saying that their F1s were shams or frauds. These students, many of them had evidence on their phones that they had acceptance letters from universities, they had paid for tuition, they had lined up housing, they had done everything in the world to show that they were actually going to school. But some yokel CBP officer decided that, that was fraud. Really, it's just a way to hassle people at the port of entry. I'm not a big fan of CBP. I don't think they do a great job, just full disclosure. And I think they have way too much power and authority for what they do and for the level of knowledge that they have. So it really comes down to protecting yourself from these low information government bureaucrats at the port of entry. One thing that we commonly see happen at the port of entry is your constitutional protections are lower at the port of entry inherently. So unlike a traffic stop or something like that where they need a warrant to search, the rules are more flexible at the port of entry. They can take your electronics, they can take your phone, they can go through your bags. So, you see oftentimes they'll go through somebody's phone, looking through all their old email accounts or WhatsApp messages, looking for anything that they can to, substantiate their theory of what's going on.
Right.
So, you got to ask yourself, is it worth it to carry your phone? Is it better to go without your portable brain for a couple of days, FedEx that to yourself, and then get it when you get here, instead of just exposing yourself to CBP rifling through your private information on your phone? So, that would probably be, something advisable if you're worried about this, just to FedEx your phone to yourself, just to avoid the potential problem that could happen.
Right, but what according to you should be their first step? Because, in a situation like this, when you have no clue about anything, and your phones are taken away, and other things. Mostly you are left with nothing, right? And you're
Yeah.
in a country where you don't know what to do and whom to contact. So in a situation like this, what do you think the students should do?
So for F1s, I think it's important to know your contacts. People at
Right.
the school that you've been dealing with, have their phone numbers, have their emails, have their names. So when you're asked any questions, you can give that to CBP and they have somebody that they can contact to verify information. So I would take all of this just in a folder, just paper copies. That way you can just hand it over to the CBP people. Your acceptance letters for university, all of those types of things, proof that you've got housing lined up. All of that would be helpful to have in a tidy little folder that you can just hand over.
Right, right. Okay, thank you so much for answering the question, John. Also, John, I would like to know from you that what are some of the most common mistakes that F1 students might unintentionally make, that could lead to issues of fraud or misrepresentation under this section?
Sure. So there's maintenance of status issues, and then there's fraud issues.
Right.
What USCIS considers to be fraud, I think the biggest thing we're seeing right now is people that were scammed by fraudulent employers who were preying on recent college graduates with F1s, telling them that they were going to hire them, place them on a project, but you just need a little bit more training before they can put you on a project. And oh, by the way, we do the training and it's going to cost you. So that scheme is relatively common, or was more common recently. And anybody that was caught up with one of those companies, eventually at some point or time in the future, you're going to get, sent to secondary. You're going to have problems with, DHS with this issue. It might be at the State Department of the Consulate, might be at the port of entry, but those fraudulent scam employers are the biggest threat probably right now that I see to people on an F1.
Mm-hmm, mm-hmm. And are there any support or help available for these students?
So you can request that you be able to call an attorney. Again, at the port of entry, your rights are very limited. If you do carry your cell phone, or if you do carry a dummy phone or a burner phone with you through the airport,
right,
I would just ask them if it's okay if you can record the conversation so that you have, make sure there's no language barriers or problems with understanding, so you have a clear record of actually what was said. If they have a problem with that, that lets you know you're not dealing with an honest officer. If somebody's afraid to be recorded, that's a red flag. The other thing that I would say is, excuse me, let me grab some water.
sure.
Now I lost my train of thought. But yeah, I would say, ask them if you can record them. If they say no, be very suspicious of them at that point in time.
Right, right. Thank you so much for that great advice, John. And also, John, given how easily these mistakes can happen, so would you say these issues are mostly due to lack of understanding of the visa requirements, or are there other factors at play too?
So I think a lack of awareness on students' parts about, the scam employers is probably the biggest problem. The USCIS didn't really help anybody out in this regard either, because they were aware of these scam companies out there. They had, identified them, they had blacklisted them and flagged them in the system, and then just waited for people to get caught in the scam. So, what a legitimate, law enforcement agency should do is alert the public that there's a problem out there and to be aware of it. But USCIS almost, fanned the flames here. They knew these companies were in existence. They didn't decertify them from E-Verify. They let people blindly walk into it and then held them accountable for the fraud that the company perpetrated. So, you gotta really advocate for yourself in these situations and really thoroughly vet anybody you're taking a job from to make sure there's no problems. As a general rule, I would say anybody that's asking for payment for training or a letter or anything, you should not only stay away from, but run away from.
Right. And any specific advice you would like to give these students to avoid these pitfalls? I mean, so that they don't get into these things. I mean, because
to the extent you can, I mean, social media is a great thing. To the extent you can, contact people that have worked there. Go off referrals from friends. Make sure that if you're on STEM OPT, that you're following all the requirements for STEM OPT, or that company is actually following them. Because if you have a STEM OPT employer and you're not following the training plan or any of that, then if there's an RFE on whether or not you maintain status and you don't have that information, you're going to be in the world of hurt, and you will be found to have not maintained status because your employer wasn't documenting correctly, and then that'll mean you have to consular process. And as anybody knows, consular processing right now is a nightmare. It's the number of 221Gs going out is just astronomical right now, so you want to avoid that as much as possible. So you really have to advocate, and if your employer is not complying with the rules, you should probably look for a new employer, and just to protect yourself, consider reporting it to DHS just so you have a documented history of saying, hey, there was a problem, it wasn't my fault, I'm finding a new employer. So you may have to be a little bit more proactive. Now, that said, if you're going to go that route, highly recommend talking with an attorney first and maybe having them do the letter and them do the correspondence for you, just to make sure that you're not inadvertently saying something that's going to hurt your future.
Right. And is there a way to also find the right attorney for such cases?
Again, word of mouth, people that you trust, just Google reviews, that just look for somebody that has experience in this area that you can trust.
Right. Also, John, so beyond misrepresentation, what are the other main reasons, international students might face deportation? And again, how can they avoid finding themselves in, such situations?
So there's two different things. One is non-immigrant intent, and then the other is not having the right travel documents. The travel document one is, I think it's an A7. It's kind of disingenuous for them to give you an A7, because typically what they're saying is, you show up with a valid visa and the CBP officer says, you don't have the required documents because we're revoking your visa, but they're revoking it because of A6 for the fraud finding. And so, you're getting an expedited removal, and it's for not having documents, but really it's a lifetime bar because of the fraud finding. The maintenance of status issue is something we're starting to see more commonly recently, where they start, looking into whether or not you're going to be returning home at the end of your stay. We see it a lot on B2 visas, especially, but F1s as well. So they will, be constantly probing to see if your intent at the time you enter the US is to stay permanently, or if your intent is to finish your program and leave. And so, you just have to keep in mind what your non-immigrant intent is. One other thing before I forget, when you get pulled into secondary, if they're going to remove you to a 235 removal, sometimes they will give you the option to withdraw your application for admission. If they ever give you that option, that is the best course of action to take, because that avoids having any bars against you from reapplying for admission. You can go to the consulate, you can do a trip report, you can try and fix whatever the problem is that CBP believes there was, and then reapply for admission. But if you get that expedited removal, it's much, much harder to get back into the country.
Right. And also, it is said that the visa officers also see your intentions. What are your intentions? So how can the student, show their correct intentions to the visa officers?
So for the students, it's a tough one, right?
Right.
Because you're young, you don't own a home, you don't, have a lot of substantial business ties or anything like that.
Yeah.
So it's tough. You just have to, say the truth. You're just coming to get an education. This is the best place for it. And, you probably will, look for OPT to get experience to solidify your education.
Mhm.
For the B2s, what we typically see them looking for is, proof that you have a residence in India that you're going to return to. Again, if you're younger, that's going to be tough to
Yeah.
do, because if you're going to be gone for 6 months, you may not maintain an apartment. So, those are the types of things that they're looking for. Again, the system is set up to give CBP a lot of discretion on what they decide. And it really comes down to the eye of the beholder. What does that individual CBP officer think or want to find?
Mhm.
And so that's why I said earlier, if you can record them or request to record them, if they say no, you're not dealing with an honest broker. You're dealing with somebody that wants to just find the facts to support their assumptions.
Right.
Along those lines, a lot of times they'll have you do a written statement, or what they'll do is they'll interview you. They will type up a summary of the statement, and then they'll put your signature on it.
Mhm.
They get your signature electronically before the beginning of that interview. And then they affix your signature to that written statement after the interview without letting you see that written statement. And that becomes the official record. So I would not sign anything when you go into that secondary. If they give you that digital signature pad, I wouldn't sign it. I'd say I'll wait until I see a written statement before I sign anything, because I want to make sure it's accurate, and demand that you see that written statement before you sign it. Read through and make sure it's accurate. Make annotations to it if it's wrong. So you really have to be assertive. You really have to protect yourself and advocate for yourself in that situation.
Right. Thank you so much for such great tips, John. Also, I would like to discuss, about this case. I think I don't know if this was the same case that you were also mentioning about the 33 students who were deported at the USA Chicago airport on January 15th this year, 2024. So, this incident has understandably caused a lot of concern. So, how can such cases be prevented in the future?
So the biggest things that I would say is never go through Chicago. Chicago's CBP is notorious. They are, without question, the worst airport in the world to travel through for abusive law enforcement tactics.
And why is that?
It has to do with leadership for that particular office, would be my guess. But it's been bad. I think the people that are working there just have a bias, and it's just someplace I would avoid like the plague if I could. So I would make your port of entry someplace other than that, or Atlanta. Atlanta's also got an overly aggressive CBP office that, they shoot first and ask questions later, so to speak. So I'd avoid those two places as your first line of defense. Even if it means taking a few extra hours to get to your destination, it's probably worth it.
Okay, and what role can universities and immigration advisors play in preventing these unfortunate events?
So, that's a frustrating question, because some of these people, I talked with some of those students, and there is nothing in the world, there's no more information that they could have possibly had or presented to that officer to show that they were a legit student, that they were going to be engaged in a program of study, and everything lined up, all their documentation lined up, but it didn't matter. They just, did the expedited removal and said, you're not coming here to study, and sent them away. Now, these are people right at the beginning of master's programs, these at legit universities, like University of Chicago, some of them, like very, very solid, well-known, reputable colleges. And they had paid tuition, but it didn't matter. They had housing lined up, it didn't matter. So for those people, it's frustrating because there is nothing in the world they could have done to alter the outcome other than possibly change the airport that they flew through.
Right. Okay. And, also I would like to take a moment to also discuss about, when students first enter the US. So how do these immigration officials at the port of entry determine if an F1 student is inadmissible under section 212, AC6? So, and what are the key factors? Are there any key factors they consider doing this?
So there's a database that's called the Consular Consolidated Database. And the Department of State, the consulate, can upload information to it and access information. CBP can access the information and upload to it, as well as USCIS. For the OPT scam employers, what they're doing is USCIS is identifying who is associated with these companies. They're going through their records, they're matching up, they rated the companies, they took their list of employees, and then they started matching up names. And so then they uploaded that to the CCD, that database. Now, some of these people stayed in the country, got H1Bs, extensions of H1Bs multiple times, and never heard a word from USCIS that there was a problem with their OPT experience. It's not until they go to the consulate or they go to the port of entry that they learn about this, because the first thing that happens at both the consulate and the port of entry is they get your biometrics and they pull up your file in the CCD, and if there's any flags or any hits in the system, you're immediately going to a secondary, or you're getting focused and attention. And USCIS is flagging people in the system and then waiting for them to go to the port of entry or go for stamping at the consulate, and that's where they're hitting problems. That's the very first thing that happens, is they notice that flag and they're pulled in.
Right. And let's say that if the immigration officer suspects something is wrong, then what happens next? And how can in a situation like that, how can the student respond during that moment? That can impact their situation.
Yeah. So the first thing to remember, if you get pulled into secondary, by and large, these people are bullies. They are basically mini little Trumps working around and just trying to throw their weight around in their authority. And so it is not uncommon at all for them to try and bully you, intimidate you, yell and scream at you, keep presenting you with a scenario of facts that they believe and demand that you agree with them. And if you don't agree with them, for them to lose their temper and basically throw a tantrum like a toddler. So just be aware that that is their MO, that's their process that they go through. And when it happens, don't get flustered. Just stay calm, disagree with them where you need to. Again, ask for recording and refuse to sign anything, because if they're throwing a tantrum like that and making wild accusations, their summary of your conversation is not likely to be accurate.
Do you have a case, where something similar happened that you would like to discuss with us and the audiences?
Yeah, I mean that's such a common scenario where you get pulled into secondary and somebody starts yelling and screaming at you and accusing you of having done something wrong.
Right.
And no matter what you say, no matter what evidence you bring, in support of yourself, they keep on screaming. It's almost like they have a quota of people that they have to reject at the board of entry. So they're, maybe at the end of the month, you see this happen more as they're hitting their time for their quota. But, it happens all the time. Like I say, some airports are worse than others. But it's not exactly the way you'd want a reputable government agency to behave, but it's how they operate.
Right, right. All right, thank you so much for answering the questions, John. And I can see people have started commenting their questions. So I would like to take a couple of them from the audiences. Okay, let's take maybe Ramesh's. So Ramesh is here and he says, I know this session is for F1, but related to H1B fiscal year 2023. My petition was revoked and back to India. What are my chances to secure my cap number back where there no fault of mine and issues for fiscal year 2025? What do you have to say, John?
So this is an issue we've been suing USCIS on, and we're not at the end of the process yet, but so far the signs are positive. What we're trying to do is, for people in that situation, is to recapture their cap number that they initially were assigned. Now, when we first started suing USCIS, what was happening was people would be going to the consulate for a new visa category, and they were told that they had a fraud finding applied against them based on their employer's multiple registrations. And so that was game over. They had a fraud finding in the system. We started suing and challenging that issue, and USCIS almost immediately realized that they were doing it wrong, and they changed their policy and the way that they were handling that situation. So now if you're the employee who was, the subject of a multiple registration, you are no longer getting penalized by USCIS. And that's a huge change, and that's a huge, benefit to you. So what that means is on future H1B lotteries, it shouldn't have any impact on your ability to get a visa.
Right. And he also has a second part. He says, my H1B petition for fiscal 2023 was revoked due to multiple registrations. Even though I wasn't involved, I had returned to India. What are my chances of getting a cap number for 2025? Any advice?
Yeah, there's not going to be anything, ideally nothing that is going to follow you or impact you from that multiple selection. If you get an RFE on it, we should talk and strategize for how to respond to that, because USCIS is on record in all kinds of court documents saying that they will not penalize the employee for the employer's alleged misconduct. So it shouldn't have any impact on your 2025 petition. I think you should be fine there.
Right. Okay. So Ramesh, you don't have to worry. And yes, thank you so much for your question. Let us know if you have a follow-up or if you'd like to know an answer to another question. Thank you so much for posting your question. Let's quickly take RK's question also. So RK is here and he says, is there any truth that attorneys litigated against USCIS asking employers proof having a project before approved, because few employers use not requiring to show proof to take a genuine cap and bench their workers while looking for a project, while genuine students miss out? We know it's wrong what they are doing, but last chance students are losing out.
The structure of the H1B lottery system is very flawed, I guess, to say it in a very kind way. The lottery is held in March. And if you're working for a staffing company, the industry standard for a lot of these companies is to operate on 6-month projects. So the best case scenario is if you get selected, you get approved, and the stars line up and you get a visa stamp and you're able to enter the country by the beginning of that visa period, you're already past 6 months. And so it's almost impossible to have a project that's guaranteed at the time they file your registration. And really, no employer in the world is going to sign a legally binding contract for an employee to work at a client site when they don't even know the outcome of the lottery yet. And so it's really impossible to have that project requirement. And more importantly, that's just not my view of it. It's what the law says that Congress created. So the Congress, when they created the H1B restructuring, what they said is that you can legally bench people, but you have to pay them while benched. And so that's the protection, that's the trade-off, is that employers can take that risk. But once you're in the country and available for work, if they're not paying you, they have a substantial legal liability. And so that's the system is flawed, but that's the best remedy that people have. I think his question is really going more towards the people that were selected in the lottery still in India and are not able to get visas. That's a tough one, because if the employer doesn't have a project and they are not going to bring you, there's not much you can do there. But it's really more a flaw in the system than it is in the employers doing something wrong.
Right. He also has one more question. I would like to read that out. He says, how is it that the selected 130K with a 20K for the master cab, which was filed, for the remaining 110K, they weren't able to get 65K? Does this indicate employers just registering applicants?
Yeah, probably. There's a gap there. They registered, then business situations change. We're now, like 5 months past the initial lottery. A lot changes in 5 months. If you look at the tech industry, there's a lot of layoffs going on. And I think the rate of filing petitions kind of tracks the greater tech industry in general. So as the tech industry is shedding jobs, there's really not a need for those H1Bs you'd anticipated coming into the country and working on H1B. So, a lot of things in the business world can change that impact filing rates. And I think that's probably what we're seeing here.
Right. Thank you so much, RK, for your question. I hope you have got the answer. We still have a lot of questions from the viewers, John. But before I take them, I would like to go for a short break. And after the break, I would like to take these questions from the viewers, if that's okay to you.
Sure.
All right. So, guys, it's time to go for a short break. But you guys don't go anywhere, because post the break, we are going to take up questions from you. So, yes, keep on watching Immigration and Jobs Talk Show and stay tuned with us.
Consultant seeking a new opportunity? We offer job placement. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green card.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and today I'm here with none other than immigration litigation attorney Jonathan Wasden. And today we are discussing about F1 students, how to avoid deportation. And yes, we are getting questions from you. So now, without any further ado, let me take another question. So the next question that we have is from Vishwadas. Let's take Vishwa's question. He says, currently on F1 visa and my program end date is in 2 months. However, I need more time to complete my thesis. Can I apply for a program extension? And if so, what documentation do I need to provide?
So if you're still working on your program, theoretically, you should be able to get an extension of that. Now, the caveat being is you got to know your limitations. My limitation is I don't file these petitions. Yeah, I litigate on the fraud findings, I litigate on denied petitions, and kind of try and fix things that were broken in the process after the fact. So I would say talk to an immigration attorney that actually files this type of petition, because they're going to have standard formats that they've done this 1,000 times, and they can run you through it, and they can give you that information, and they can line up your package to make it as strong as possible to get what you need done.
Right. Okay. So Vishwa, I hope you've got the answer. Thank you so much for your question. Let us know if you have another one. Meanwhile, let's take Imran's question. So Imran says, I am on F1 visa and got married to a US citizen. Can I apply for a change of status to a spouse visa, CR2, or do I need to leave the US and apply for CR1 visa?
So if you're married to a US citizen, you would be looking to adjust status, and you should be able to do that while you're here in the country. So, I don't know that you would need to leave the country. Again, the caveat being I don't file these. It's not my area that I practice in on a regular basis, the family petitions. But my understanding is you can stay in the country while you make that application.
Okay, and he also has a part two, John. He says, what are the benefits and drawbacks of each option, and what are the required documents and filing fees?
So if given a chance, seeking immigration benefits for marriage to a US citizen is always your top choice. There's really no easier or better way to get that. Now, with US citizens marrying foreign nationals, there's a lot of scrutiny that they give your application. They look for evidence or indicators of marriage fraud, things like that. So you're really going to want to go through and just show that the marriage is bona fide, and probably pictures of dating time, pictures of weddings, lists of who was at the wedding, things like that, just to show that this was a legit marriage and it's not just for the purpose of getting immigration benefits. Signs of cohabitation, shared utility bills, shared leases, shared addresses. Just anything that shows that you are a married couple is going to be very useful for your application. And the filing fees, like I said, I don't file these, so I don't know off the top of my head what the filing fees are. But you can just Google that on USCIS's website, and it'll pop right up.
Right. So you can check that out on USCIS's website, Imran. And thank you for your question. Let us know if you have another part or a follow-up or maybe another question for John. Let's take Dipesh's question in the meanwhile. And he says, I have received an RFE on my F1 visa application stating that my bank statement doesn't show sufficient funds. However, I have since deposited more money into my bank account. Can I submit an updated bank statement, or do I need to reapply entirely?
So if you haven't replied to the RFE yet, you can provide the new bank statement. If you've already replied to the RFE, you can try and do a supplemental. A lot of times USCIS will not accept the supplemental filing, but you can try. There's nothing that says you can't do it. So, I would say if you're past the point where you're outside that window of the normal reply time, yeah, maybe reapplying would be the way to go.
Right. So, Dipesh, I think, like John said, you should reply then. Then Paul is also here, and Paul says, I was on F1 visa and worked part time for 6 months without authorization. I have since stopped working and want to apply for OPT. Can I apply for OPT, or will my unauthorized work impact my eligibility?
If USCIS knows about the unauthorized employment, it will definitely be a problem. And that is one thing that they are, you know, when they have that information, they don't always have it. A lot of times there's no way for them to know. But if they have that information, it's definitely going to be a problem for you. Unauthorized employment as a student can, create a 3-year bar to re-entry into the U.S. So it definitely will be an issue. My guess is if they have any information about that, they'll be giving you an RFE or an NOID. And so you'll be responding to that.
Right. So, Paul, thanks so much for your question. I hope you have got the answer. Ramesh's question, I think we already have taken. Vishwa's question also, I think we already took. RK also, I think we already have taken. Alok is also here, and he says, I have been on F1 visa for 6 years and have completed 2 master's degree. I want to apply for a PhD program, but I'm concerned about the impact on my F1 status. Can I apply for a third degree on an F1 visa, or do I need to change my status to an H1B or J1 visa? What are the rules and regulations regarding F1 status and multiple degrees?
So typically as long as you're, advancing, making progress up the educational ladder, you should be fine. So a PhD, it's kind of a natural progression. You go from bachelor's, master's, PhD. So I wouldn't expect that to be a problem for you. I would expect if you filed for a third master's degree to get a lot of scrutiny in the application process. But for the PhD program, I think you're fine. But if you have the option of an H1, why not go for that and then do your PhD in the part-time. The one thing I will caution about PhD programs is just make sure that it's from a legit university, because they have a list at USCIS of colleges that are suspect, and degree mills, things like that, just places that only exist to issue CPT. And you don't want to be involved with one of those colleges. You want to be with a no kidding university that has a PhD program that has some legitimacy.
Right. But John, is there a reason behind the lot of scrutiny that you said?
Sorry, say again?
So is there a particular reason about the scrutiny that you mentioned?
Yeah, because it questions whether or not you're really looking to get an education, or if you're just really trying to stick around to work. And so if the immigration agency looks at it as you're just trying to game the system to work, they will inquire further into your application.
Right. Thank you so much for answering the question. And Alok, thank you so much for your question. Let us know if you have another follow-up or maybe another question. Meanwhile, Biraj is also here, and he says, I'm on F1 visa and was recently arrested for a DUI. Will this affect my F1 status, and can I still apply for OPT or a green card in the future? Okay, let's
So
take
it could impact your F1 status. Mm-hmm. So typically the way these things work is your arrest record gets reported to DHS. DHS uploads that to the consular consolidated database. You're flagged. Then it goes to the consulate, and the consulate decides whether or not to revoke your F1 visa. If they send you an email, and I would keep an eye on your spam folder, I would keep an eye on your email inbox. If they send you an email contacting you saying that your F1 is revoked, what that means is that you don't have to leave the country right away. You just won't be able to come back into the country once you leave. So it shouldn't be, a problem for finishing your program. I doubt it's something that will come up in the OPT process. They could RFE you on it, but it's not one of the things that they would typically, focus in on an OPT.
Okay, and he also has a second part, and he says, what are the potential consequences of a criminal record on my immigration status?
Yeah. So, the real problem is going to be going for stamping, or whether or not you maintain, if they're going to find that to be some type of violation of your non-immigrant status. USCIS may deny a change of status or an extension of status. Probably not the most likely outcome. The most likely scenario is going to the consulate and the consulate making a decision on you because of your criminal, conviction for DUI.
Right. Okay, so Viraj, thank you so much for your question. I hope you have got the answer. Malika Arjun Rao is also here. Let's take his question. So he says, I am currently on an F1 visa and want to transfer to a different university. Can I transfer my service record to the new university, or do I need to apply for a new F1 visa?
Yeah, so again, limitations are I don't file these, but I believe you can transfer to a new university without having to file a new F1 visa. So, talk with your DSO, the designated school officer or the DSO. They know this process backwards and forwards. So, get an appointment to go in and speak with them about how to do that. Now, if you're transferring universities, again, the caution I give everybody on F1 is make sure the university you're going to is not a degree mill. It's not a CPT mill. It's a legit university that's offering legit courses, studies, that it's reputable. And that's, very important for avoiding problems in the future.
Right. And he also, again, has a second part, and he says, what are the requirements and procedures for transferring my service record?
Yeah, again, there you want to talk to your DSO, and the DSO will be able to walk you through that whole process.
Okay, so Mallikarjun, I hope you have got the answer to all your questions. Thank you so much for posting them in the comment section. And John, I also have questions from the viewers actually on my WhatsApp. So let me quickly read these questions. I'm so sorry, I'm taking a bit time. Okay, so here it is. The question is, will I be deported if I say that I'm staying at my friend's place because the university is close to his locality?
You mean, I guess they're asking if when they're coming through the port of entry, if they're asking where they're living. That wouldn't necessarily be a deal breaker. But if you have a lease or you have some type of documentation of where you're going to be living, that would be best. If you have some type of agreement with your friend to split costs, if you can get that in writing, that would be a great piece of information to have. But just staying at a friend's place isn't going to be a deal breaker. People have roommates all the time, so.
Okay, all right. Thank you so much for answering the question also, John. And again, okay, so I have one more question for you. And this question is actually from a guy, and he says, I already got my F1 visa, but just after, where is it? I already got my F1 visa, but just after it was issued, my I-130 filed by my stepmother got approved. Will this be a problem at immigration?
I've never seen that scenario come up. It shouldn't be. Although typically when you have an immigrant visa petition and a non-immigrant visa petition, they focus on your non-immigrant intent. What are you going to do? I don't know how long the wait period is, for a I-130 in this situation, but you're just going to want to make clear that at the end of your F1 program that you plan to return back home until your priority date's current. You can get a visa on the 130. And that's really going to be the issue. What is your non-immigrant intent coming in on the F1?
Right. And I also have one more question. And the question is, where is it? Okay, what should I do if my F1 visa got revoked and I received a 5-year ban? Can I go to the USA for my studies again?
So it really depends on why it was revoked. If it was revoked with a fraud finding, no. You're going to have to deal with that fraud finding before you can get another visa. If you're still within that 5-year ban window, you're going to have to, get a waiver for that, or figure out a way around that. But if it's not for fraud and you're outside that 5-year period, theoretically you should be fine. Now, when you go for stamping, or you go for, the port of entry, they may ask you questions about it, and you just have to, answer that as best as you can. I'd say consult with a, immigration attorney before you go to the consulate or before you go to the port of entry, just to get some, pointers on what the questions will be based on your specific facts, and how best to answer that based on your history.
Right. And, these are some questions posted in some groups. So we try to look for these questions also. And one more question, one last question for this episode. I got my USA visa on 12th January, and I'm going to the University of South Dakota in July. I have paid my enrollment deposit and first semester fee, and all my documents are legit. However, I'm afraid due to the recent news about deportation involving students from South Dakota. Any suggestions?
So I hadn't heard about students in South Dakota facing issues. My first suggestion would be buy the warmest clothes you can possibly find, because South Dakota is the coldest place I've ever been. In terms of documentation, same rules apply. Just make sure that you've got proof that you can pay for the tuition, or you have paid for the tuition. You've got housing lined up. Correspondence back and forth between the school, if you've got it. Have a contact at the school that can vouch for you and say, yes, they're coming. Yes, I've been discussing with them. Just make sure that you have all of your bases covered when you go through the port of entry. And again, Chicago might be convenient to South Dakota for port of entry, but I would avoid it. I would, look for a different place to go as your initial stop in the U.S.
Right. Okay, so John, one last question before I let you go. Any last feedback or any last suggestion for the F1 students, who might be worried about their deportation at the moment?
Yeah, so I would say you have to be your biggest advocate. You have to be assertive, and you have to look out for your future. So, when it comes to picking a university or a college for a program, make sure they're legit. Make sure they're reputable. They're offering real courses of study, and it's not just a degree mill. When we're talking about post-employment on OPT, make sure that they're following the rules. The employer's following the rules. Watch out for people that are asking to, receive money for you to work for them. Avoid those types of situations, and make sure. There are worse things than being unemployed and having to return back home because you don't have a job. And that worst thing is never being able to come back into the U.S. again if they find you have committed immigration fraud. So, be very, very careful with your choices on F1, and you've got to protect yourself that way.
Right. Thank you so much again, John, for coming and doing the show. It was, again, a great episode. And to our lovely viewers, I would like to say that if you want to get in touch with John, so you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. You can email him at support@wasden.law. Is that right, John?
Correct, yes.
Yeah. And you can also visit his website, which is wasden.law. So you can also check that out. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my number, which is +1 732 707 9151. My email is rajni at higheritpeople.com. And our website is www.higheritpeople.com. Remember, we sponsor H1B visas and other work visas based on job availability and regulations. All right. With that, thank you so much again, John. Hoping to see you next week with another great episode and great topic.
It's good being with you. Thank you.
Thank you so much. And to our lovely viewers, thank you so much again for turning in such huge numbers and continuously posting your questions, asking your questions. It really means a lot. If you like the episode, don't forget to like it, share it, and also comment down below. And yes, keep watching and keep subscribing to Immigration and Jobs Talk Show. We have 2 more webinars coming up at 12 and 2, so don't forget to check that out. And for now, I will have to take your leave too, and I'll be meeting with you soon. But yes, for now, I'm Rajni Bharara signing off. You guys take care and keep on
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.
Good morning, good afternoon, good evening, everyone. Welcome to Immigration and Jobs Talk Show. I'm your host, Pradhan, and I'm really very thrilled to have you join us today across YouTube, LinkedIn, Facebook. And thank you for tuning in, by the way, folks. So, I totally encourage you to participate. But before we start off today's session, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, definitely, I encourage you to participate in the conversation, friends, wherever you're watching us from. Join us by commenting in the comments as comment section, and feel free to ask your questions or share your thoughts throughout the webinar. And if you have any questions or experience to share, even you may feel free. So, we love to hear from our audience. That's what I need you to know. And thank you once again for joining. And today on Immigration and Jobs Talk Show, on this very webinar, we have a very special guest once again. This is Justin Rivera joining us. I think this will be the third time joining us for another webinar. Well, thank you so much, Justin, for joining us once again. It's really such a pleasure to have you here.
Mm-hmm. Thank you so much for having me. It's always nice to be on.
Thank you, thank you. And for folks out there who are maybe seeing Justin for the first time here on Immigration and Jobs Talk Show, let me tell you that Justin Rivera is an esteemed employment-based immigration law attorney with Wasden Law. And Justin is not only a defender of H1B visa applicants, but is also uh, dedicated community advocate. So it's really such a pleasure to have you once again with us, Justin.
Thanks.
And once again, we are going to be speaking about the H1B cap lottery. I mean, last session we spoke about the second lottery, the announcements, and some of you got selected. But today's session, I think, is going to be more for those of you all who couldn't get selected in this second lottery. And what next then? Not just in the second lottery, but in this whole lottery. So thank you so much, Justin. What can folks out there expect from us this session?
Yeah, I think we'll touch a little bit on the issues. Sorry, wife calling. I think we'll touch a little bit on what do you do if you've been selected from an employer and employee perspective, and then what to do in circumstances where you weren't selected, kind of what your options are. And then I think maybe some more general topics of just kind of discussing a little bit more regarding some of the recent FAQs that have come out for the H1B visa.
True. Absolutely. So we'll dive into what options are available if you were not selected in the lottery, and probably how to navigate your career and your immigration journey to the United States. So without
Mhm.
further ado, I think we'll just dive into our questions directly since Justin is here for a short while only. So Justin, can you elaborate on the recent USCIS announcement regarding the second H1B lottery for the fiscal year 2025 cap, and what are the key details that petitioners should be aware of?
Yeah, so it's closed. That second lottery has been run. Everyone who's been selected, the petitioner, which is going to be your employer, has been notified. So at this point, more likely than not, if you haven't heard from your employer, then your case was likely not selected. What this means is that selected individuals, they have 90 days to file their H1Bs with USCIS.
Mhm.
You need to file within that window. Like the last lottery, there's kind of a general statement that USCIS is not going to provide any exceptions for people who file late. So you do want to get that filing in. Now, that being said, um, last lottery, they did provide a small extension for filings based on some technical difficulties that had occurred. So they did give a little bit longer window, but I would not bank on that this time. Definitely try and file your cases early. The reason why you really want to file early or well before that deadline is cases can be rejected, and there have been instances of proper rejection and improper rejection. There's a litany of reasons why a case could be rejected, maybe a lack of signatures in specific areas, lack of correct fees, maybe somehow the case was sent to the wrong location, and then worst of all, an improper rejection by the by USCIS. So in that circumstance, you're probably not going to see that packet that's been rejected for probably a week, maybe longer, depending on mailing, where you are, where it was sent. So that's why I would definitely say, be aware of your deadline, but I would say try to make sure that your case is submitted at least 2 weeks before that deadline if you're able to do so.
There you go, friends. You know what to do. And 2 weeks, I mean, try to have some time in hand so that at least if you have to rework on something, you still have some time and not
Right.
going to submit at the nick of time. And even if you have to make any changes, you just don't have time anymore for that.
Mhm.
So thank you, Justin, for taking that up. Moving on now, I think I got the second question. So next is, what specific criteria must registrations meet to qualify for selection in the second lottery? But since it's already done, it's closed. Are there any
Mhm.
particular factors that could influence a registration's eligibility?
So for this round, we were looking at regular cap only. So everybody that that's been selected was out of that grouping, that regular cap. So you weren't in a situation where having an advanced degree, U.S. master's degree or higher, is going to put you at an advantage. So kind of a quick understanding of how the normal lottery works is the normal lottery, you have the initial lottery run, and then you have the advanced degree lottery run. And the reason why that's so advantageous for people with advanced degrees is you basically get a second lottery run that's going to be just for you and other people with the US master's degree criteria met. And it's run after the first. So you've already had people taken out of the pot that have master's degrees. So it gives you an advantage when you're being selected. That wasn't the case here. So in this circumstance, you're looking at everyone in that regular cap being sorry about that. You have
It's all right.
everyone coming in at an equal playing field. Everyone's coming in at the same level. Now, that being said, I do want to point something out that's kind of nice to have this time around. There's only a regular cap. You have to select which cap you are filing under at the time that you file. A pitfall that I definitely advise making sure is taken care of is making sure that you select the right cap. That's kind of a point of no return. If you select the wrong cap when you file, you're going to be in trouble. You're going to have issues where you're going to see an RFE asking for justification why you filed in the wrong cap. This time, it's all regular cap. Everybody's selecting the same box. You don't have to look at the selection notice to make a determination. It's already said right there for you. It's just going to be regular cap across the board.
Thank you. Thank you. I'm sure, Justin, I think you're in a hurry, right?
Yeah,
Is there an
I'm
emergency?
not too much of a hurry. I'm okay. I just my wife's asking me stuff.
Okay, that's fine then. All right. Thank you. Thank you for being patient. And folks out there, we are here. So thank you, Nishant, for your questions. Stay with us. We will take them up. For now, Justin, if you could just tell us, what steps should applicants take immediately after learning that they have been or not been selected in the second lottery, in the second H1B lottery? So first, let's go with if they have been selected.
So people who have been selected, I think what you're looking at here is you need to move forward in tandem with your employer to make sure that you're filing as quickly as possible while ensuring that the proper documentation is included in your petition. So obviously you need that certified LCA. That takes 7 days to certify. Your employer needs to comply with the posting and notice requirements in that time frame. You're going to need to file with the I-129 form with the correct requisite signatures. Big thing to remember on signatures. I know it's a small thing to think about, but you are now allowed to use a copy of a handwritten signature. So if time is of the essence and you're in a circumstance where you don't want to mail forms back and forth, the client is completely capable of printing, signing, scanning, and returning a copy of the document signed. And you can use that as an alternative. Now, I will say, it's a preference of a law firm. Maybe some law firms like to use the more traditional paper route because they have a system in place. But I'm more of the belief that if you're given an easier way to do something, you should do that. So the signatures, the offer letter, you need the description of employment. Maybe if you're working at a third party, you might need evidence of that consulting engagement, via, contracts with the vendor or client, letters, maybe, if those are available. I think the biggest focus is going to be, what does USCIS have the ability to look at? And that's going to be, does the position qualify as a specialty occupation? Has the position been placed in the right SOC code, the right occupational category? An example of that would be, let's say someone's a software developer and you're filing an H1B for a software developer, and for whatever reason, they use the SOC code for a computer systems analyst. You have to really get down to what the person's doing, the job duties that are being performed, to make the determination of where the position qualifies. An attorney is going to be able to take care of that for you. But in order to do that, you have to give the attorney as detailed a description as possible of what the position is. You're going to be including that in a support letter, a document that's going to be signed by the client explaining the position. And the other big thing to remember is the beneficiary's qualifications. Obviously, you have to show how you're qualified for the specialty occupation position. To do that, if you have a non-US degree, a foreign degree, you must submit an evaluation. Not an evaluation, a translation, a certified English translation. I think an evaluation should also be done as well. Just knock it out. Do the eval with the translation, show that it's consummate to a US degree, makes everything a lot easier for you. The other thing is looking at the type of degree that's being used to qualify someone for the position and making sure that there is that nexus. There needs to be a connectivity between what the person's doing and their field of study. If there is not a nexus that's clearly identifiable, then you're getting into, do we need to do, there's different phrases for this, combo eval, an education plus experience eval. That's where you're going to be looking at taking work experience, professional work experience, combining it with the education to show that the person has a hybrid of the two that's equivalent to a degree in an applicable field. So again, those are really kind of the big issues to look at if whether or not that's going to line up. You can always file and see if the case gets an RFE to kind of save money if you don't want to do the evals. But I think that you should definitely just go ahead and present the strongest case you have up front, especially for this one. This is the first H1B. This is going to be giving someone cap exempt status moving forward. That would be my general recommendation. And then I believe you had asked, kind of on the flip side of that, about people who were not selected.
Yes. That's my second part. I mean, what if people were not selected in this lottery? What do they do? What's their next step?
So I think John and I had talked about this a little bit on Wednesday, if I remember right. Gosh, the week goes by fast.
I know, right?
We had spoken about this a little bit previously, and we had talked about going to looking for H1B cap exempt employers. So there are entities that are able to file H1Bs without an individual that has gone through the lottery. So an example of that's going to be nonprofit higher institutions, nonprofits that are working in tandem with a higher institution, and then nonprofits or U.S. government research organizations. So these are all different employers that they don't have to have the employee have gone through the lottery in order to hire them on an H1B. So I would definitely look at that. Another option that I think is often talked about is if you're on an F1 and you're running out of time. I think the most common issue is your STEM OPT, or maybe you're on OPT and your degree didn't qualify for STEM. The issue of maxing out on that time for work authorization. I think you have the option of moving up a degree level. So if maybe you have a bachelor's degree and you haven't pursued that master's, moving up to a master's. If you're from a master's, moving up to a PhD. So moving up a degree level, and then maybe thinking about pursuing CPT. I definitely would generally advise trying, if possible, to stay away from doing CPT at the same degree level that you've already completed OPT at. Those second master's ideals, where people, they already have a degree from school X and they go to school Y. And they're at the same degree level. I definitely in the past have seen pushback from USCIS regarding maintenance of F1 status when someone does that. So I would be careful for that. But if you are able to move up a degree level, I think that that's a good option. You have the spouse option, which we've talked about before, which is not applicable to everyone. But if you have a partner that's on H1B, perhaps you move over to H4. You have an L1 partner, you move over to L2, you get that employment incident to status, and you're authorized to work. Other options that I kind of just had thought about, because we had talked about this a bit on Wednesday, the L1.
Mm-hmm.
So the L1 would definitely be something to consider if you are someone who's been registered in the lottery outside the United States and you haven't been selected. Now, you have to have that full year working abroad with a foreign employer, and the foreign employer has to have a qualifying relationship with the U.S. entity in order for you to be sponsored. Now, there's other qualifications. An L1A is for a manager, and L1B is for specialized knowledge. But at the outset, I look at first, is there a qualifying relationship between your current foreign employer and maybe the U.S. company that tried to sponsor you for that H1B that you weren't selected on? Right.
Mm-hmm.
So if that's the case, and you've got that 1 year of continuous employment within the past 3 years, I would try to explore the option of looking for an L1. The specialized knowledge route that's going to be, based on what kind of intimate understanding you have of your organization and how it's applicable to moving over to work in the U.S. The manager is a little bit, L1A manager is a little, I don't want to say more hardline. Basically, my way to say it for this is the L1A manager is pretty like clear cut. Are you managing people? Like, are you managing individuals? Are you managing professional employees? There's also the option of a functional manager, which I'm not going to get into detail about. If you think about that as an option, schedule a consultation with an attorney so that you can really get into the nitty gritty of that. But that's an option too. And then I also would say the TN visa for people who have Canadian or Mexican nationality or passports. That's another option that you can explore too for work authorization. For the teams, for the Canadians, it's actually a pretty clear cut deal. They can actually apply right at the port of entry for TN status. They actually don't even have to go through the consulate. Whereas, unfortunately, if Mexico is the route you're going by, you are going to have to at least first schedule that appointment at the consulate. But that's another option based on, your country of origin or your nationality. And that's pretty much all I can think of off the top of my head. We can get into details more later if we want about the E1 and E2, but I think those are even more nuanced options that require further analysis.
So true. And thank you so much, Justin, really for touching up again. And folks out there, I would really like to tell you at this moment that you should definitely check out our channel, Immigration and Jobs Talk Show, because we've had Justin and also Jonathan Wasden join us earlier, and we've discussed about the second lottery, what are the options. And even actually, Justin, we had an episode earlier, though it wasn't so clear because of our internet issues, technical issues, but we did discuss, and definitely check them out as well. These webinars are very, very informative, and you might not want to miss out on them. All right.
Yeah.
So, right, Justin, we spoke about very important things last time. Yeah. So now my next question for you is like, how critical is it for selected applicants to file their H1B petitions promptly? And what are the potential risks or delays or inaccuracies in the filing process? Are there any common pitfalls that they should avoid or can avoid?
Yeah. I mean, obviously, kind of as we touched on, it's very important that you file as expeditiously, as quickly as possible to make sure that you're filing within that window and that your case is received by USCIS properly. The things to look out for are going to be rejections, obviously. So that's an instance where, for whatever reason, the case is rejected by USCIS. That's why I advise you try to file early. I know you have that 90-day window, but I would really say cut 2 weeks off that window and say this is your definitive deadline for filing, just in the event that you deal with a rejection. Other things that I would probably look to avoid, your LCA needs to be correct. And what I mean by that is your LCA should properly reflect the actual work locations where you're going to be performing services. So if you are someone who is working at, a client location, then that address needs to be included on your LCA. If you're working at home, that address needs to be included on the LCA. It is important to make sure that your labor condition application is accurate, not only for when your case is being processed by USCIS, but later on down the road when you're looking into potential compliance issues with FD&S. So for those who don't know, FD&S has the ability to investigate any petitions that have been approved by USCIS. This means that at any point, they could visit a work site and request information on what the employee's been doing, call a supervisor, things of that nature. So you want to make sure all of that information is accurately reflected. The last two would definitely be, make sure that it's actually great to go back and kind of talk on this for a second. When you are selecting the SOC code, making sure that the person's the right position type, another important thing to consider is the wage. How much you're paying the individual and whether or not that wage is compliant. So if you're paying, somebody to do work where they're managing a large group of people or maybe a large number of projects, and you say that it's an entry-level position because you want to pay the level 1 wage, that's probably a red flag to USCIS because they're looking at the nature of what the person's doing and they're saying, how is this an entry-level position? If this person is, a large-scale manager, they should probably be at a higher wage level based on that, maybe a level 3 or a level 4. So that's another thing to consider because that's definitely something that USCIS can come back on. I remember specifically I believe it was the first year of the Trump administration, there was just a colossal influx of RFEs and related to the level 1 wage. Specifically that basically, all of these companies were just saying all these positions were entry level and then not bothering to do a real detailed analysis of what the people were doing in these positions. So you have to be able to defend that, you have to be able to defend what it is that you're putting in the petition. So the way that I like to look at it is this. Every petition that I'm reviewing and submitting to USCIS, my thought process is always, what can the officer attack? What is it that's missing or deficient from this petition that would give them a justification to issue an RFE? And what can I do to make sure that that's not the case? I mean, the simple matter is sometimes there's not document X available. It's not there. Or, you've already filed the LCA and you're kind of, you need to get the case done because you're running out of time and you do a second look and you think, oh, maybe the wage level's on. You still have to put the case out and get it filed. But I would definitely say make sure you do your due diligence. And that really comes back to starting early. I mean, we know now who's been selected. You have plenty of time. You have about 3 months to get these
3 months, 90 days, right?
Right. So you really need to make sure that what you're doing is presenting the strongest petition possible.
So it's the correct time, friends, to go out there. If you don't have an attorney yet, go get one and do everything right. And just like Justin has mentioned, how can you be attacked and make sure that you will not be attacked. So make sure that you don't get an RFE also for that matter.
Yeah, and I mean these are incredibly important filings. I mean, as we've learned from looking at the data from this year's lottery, it looks like there's a negative trend towards selection rate, meaning that the probability of you being selected in the lottery is trending downward right now. It's becoming more difficult for people to be selected based on the changes that have been made over the last couple of years, combined probably with the negative impacts of the economy that are creating a less willingness for people to file. John and I had talked about this last week. These increased fees. What is the impact of these increased fees on the probability of companies continuing to want to file for new H1Bs? I'm not professing that I know the future, but it's logical to conclude that, like John said, as the amount something costs goes up, the demand for it is going to go down. So those of you who have been selected this year, I mean, this is incredibly pivotal for you. You really, really, really need to do everything possible to ensure that you're able to get that case approved this year.
Yes. Make it count, friends. I mean, nobody just gets lucky in a lottery, so make it count. And also another thing is, if you should definitely go follow Wasden Immigration Litigation on LinkedIn for more updates on anything related to immigration. All right. So thank you so much, Justin, for taking that up. And yes, I think we should definitely move on to our audience out there. So Sam Dilton says, hi, Justin. And he has a question. Is it possible to apply for an O1 visa if I have extraordinary abilities in my field? Or if I have STEM education, wanted to check the options after being not selected in the lottery?
Okay. Yeah. So I think we've seen this question come up a couple times in regards to the O1. So the O1 can be a viable option for someone that is able to show extraordinary ability. It's a high bar, okay? That's a higher bar than there is for an H1B. It's a higher bar than there is for an L1. It's simply a much higher bar. Extraordinary ability is things like, you know, international acclaim, awards, research papers. You've judged competitions. You've worked
Hmm.
with distinguished companies. It's a very, very high bar. The factors are available on USCIS's website if you want to look at them. I will say that people in AI, because of recent changes made in the Biden administration, people who are working in AI now have a better chance filing for an O1 because the Biden administration has made it known this is something that they want. They want to retain international talent that is proficient at AI. So I would definitely say if that's the specific field that you're in, you
Hmm.
might want to look into speaking with an attorney about whether or not you qualify. Maybe you need to
Qualifying, yeah.
strategize. You need to look in and say, what actually am I missing and what do I need to do in order to eventually qualify for an O1 and begin taking those steps. I definitely
Hmm.
think that it's not easy to be a kid that goes straight out of college to an O1. I don't think that
Got it.
it's easy because you have to produce a lot of justified documentation to show that you qualify. Now, that being said, I've seen it happen. I've actually seen a case recently where someone got an O1 for their interactive work with artificial intelligence, and they had just come out of
Wow.
school. They had judged competitions while they were in school. They were very
Wow.
distinguished in their field. They had, written papers. They had worked for big, cutting edge AI company, and they were moving over to work for a new startup company that was going to be sponsoring them. And they were able to get an O1 approved. So it can be done, but you have to work with an attorney. I nothing short of insane to try to file an O1 on your own. They are so
Okay.
document intensive and they have to comply so specifically with the rigorous requirements of USCIS that I would definitely say, make sure you do that. Make sure you work with an attorney that has
Right.
good experience doing O1s as well.
That's great. That's great. Thank you so much, Justin. But just in case, I mean, Sam, not to, I mean, discourage you or anything, but just in case if Sam doesn't qualify for an O1, what other option does he have?
Well, I mean, if he's on the F1 and he's hopefully taken advantage, obviously, of his OPT and that STEM OPT. We've talked about a little bit about the options that people have moving up a degree level if they have the ability to do so. So
Hmm.
moving up from that bachelor's to master's, that master's to a PhD if they have the ability to do so. And then you're probably looking at maybe working with a cap exempt employer as well. That could even be twofold if you're trying to build your docket up for an O1. Maybe you can go work with a research, a government research organization that is going to allow you to produce work product that can later be used to justify the qualifications for an O1. So
Okay.
I would probably explore those options and see if there's anything that's available to you.
I was thinking you'll say P3 or something because when I think about O1, it's mostly like artists and extraordinary people who are really world famous and stuff like that.
Mhm.
So, but
It's
yeah,
it's surprising, but that is true. The O1 is that very high threshold, but I've definitely seen people get O1s that no one has heard of unless they're working within that industry. My favorite
true.
case that I've done for an O1 was someone who extraordinary ability in marketing. Someone that had worked on a
Oh,
bunch of very interesting campaigns for some big clients.
wow.
Can't say their names, obviously, but really big. And it was actually very cool to work on because in the moment I actually
Hmm.
learned, oh, well, that's who made that
Mm.
commercial. That's the commercial for, or, company A that you see on
Oh,
TV all the time or on the internet all the time. This person's the one who put everything in place. They came up with the idea. They helped hire.
wow.
Yeah. So what I mean by that to say is that, yes, the O1 is for distinguished and talented individuals, but it's really going to be in the field that you're looking at. So just because you're someone that doesn't have a Nobel Prize, that's I think the easiest go-to. You have a Nobel Prize, or you're an O1 because you won an Olympic medal. Like, yeah, those are going to be pretty clear-cut O1s. But there are ways to qualify for an O1 outside of those kind of clear-cut options.
Okay, thank you. Thank you so much. That was very well explained, and I'm sure, Sam, you have more clarity on how to go about this now. Moving on, let's take up this next one. This is from Nishant asking, my OPT stem is expiring December 21st, 2024. I am on a full time with a banking client. They
Mhm.
have confirmed that I was not shortlisted. What are my options? And I don't want to move to CPT.
I mean, you're kind of putting yourself in a situation if you're taking CPT off the table, but it's understandable. I would say you have to. My first thing would be going up a degree level if you can. Would be the first thought process if you're trying to maintain work authorization, because that's probably going to be the easiest option for you. Outside of that, you kind of have to look at what's this person's nationality. Do they have the opportunity to maybe try for a TN as opposed to an H1B? Since they're not going to be able to qualify for that. You're not going to be able to stay with that banking client if you're trying to move to a cap exempt H, because they're not going to qualify, I'm guessing. So really, I think what you're looking at is going up a degree level. And even if you don't want to do CPT, that's probably how you're going to maintain your work authorization. Because the only other real option for you is maybe seeing if you are qualifying for a TN. Maybe explore the E1 or E2 options. But if you're a student just coming out of school, I don't know if you're going to be able to meet those thresholds. So yeah, I'm sorry. I know you probably don't want to do CPT, but that might be your best pick if you're trying to stay with that client. The only other option, like just spitballing off the top of my head, would maybe be, are you open to working outside of the US for a year? And maybe, if the company has a foreign affiliate, can you go to Canada and work in Canada for a year? You're still staying in North America. You can work with that foreign affiliate for a year, and then maybe they can explore the option of doing an L1 for you. Or maybe you're working at a company in Mexico. So that's it. That's kind of all I got for you. Sorry you weren't picked, and it's probably not the answer you want, but it's the answer I have.
Thank you, and all the best, Nishant. Look for it and try and maybe give CPT a chance as well. Moving on, this is Pedo Drew. Hi, my H1B has not picked in the second lottery. Can we expect the lottery this year? And what is the current job market in the US? Can we expect any changes in the next year?
Okay, so first off, we've disclaimered this already about legal advice, but to further disclaimer, I'm not like a CNN analyst or something that has the ability to predict the economy. All I really know about is what happens with my retirement at this point. So yeah, I think it's very hard to be predictive of the job market. I mean, international things are going to impact that. As you can see, there's turmoil overseas in multiple areas where there's active conflict.
Right.
We don't know what's going to happen with that. We have no idea who's going to win the election. That's going to be another thing that could be outcome determinative for the economy and the job market. Can we expect a third lottery this year, though? I think we may have touched on this a little bit previously. The problem with a third lottery is time. I just feel it's very difficult to think that USCIS is going to have time. This current filing window runs all the way up until November. I would assume they wait until it's pretty close to closing, if not closing, if they were going to make any sort of determination. And at that point, what do you do with a third lottery? I mean, are you picking people and telling them that they can file from November to March? Because then you're literally running into registration for next year. And so you
Right.
do have to
And
think, Yeah,
It's like we'll have
USCIS.
the holiday period in between, like December,
Right.
January. I don't think people will work
Right.
at
You're
all.
dealing with office closures. This is a government entity. To think that they're going to be putting in overtime for this is ridiculous.
Yes.
So no, I cannot realistically see there being a third lottery, but I will say the exact same thing I said last time. I hope I'm wrong. I would love to be incorrect and for there to be a third lottery, but I just looking at the factors don't think that that's going to happen. So
Right.
that's my input on that. And then about the job market, I have no idea, guys. I don't know. I have no idea. I mean, you've seen recent layoffs in the tech industry. We actually just saw layoffs in healthcare to an extent. There's some hospitals down here in Texas that actually cut 5% of their staffs. I'm hoping there's not a recession because that never benefits anybody. I mean, that just makes everything more difficult for everyone. But we'll have to see what happens. We'll have to keep our fingers crossed and hope that things
Yes.
trend upwards.
True, true. And Peruju, I think, can we expect changes? Yes, we can always expect changes because that's the only thing that's constant. And
It's
let's hope for the
change.
best,
Yeah.
Peruju. Yes. All right, let's move on now to the next question we have. Let's take up Madhu. Nishant is continuing to say, my job
Yeah. So
required to stay in the
yeah,
US.
which I understand that takes off the L option for you. So it's just not, available to you. I'm sorry. So even though you're adverse to the idea of CPT, I do think if you're moving up a degree level that you're going to be in better shape. I would try not to engage in like a second master's or something like that.
Mhm. All right, I think we'll just take a quick break now, if that's fine, folks out there. You keep commenting, we'll take up your questions. And once again, I would like to say that please follow Wasden Immigration Litigation on LinkedIn for more immigration updates. And also don't forget to subscribe to Immigration and Jobs Talk Show on YouTube, Facebook, LinkedIn, and we would be happy to take up your questions as well. So also feel free to contact Justin, and his details are on the screen. All right, so you can contact Justin and definitely check out their website as well, wasden.law. And you can note down his phone number. His phone number is 844-592-7336. And you can mail him at support@wasden.law. Thank you so much. Let's go for a short break.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hey, sorry guys, I don't have any audio, so I'm not able to hear.
Control
The
stepping
question.
in. You have no audio.
Sorry, but
Control stepping in. You have no audio.
all right. I hope you can
Now
hear
you
me,
are.
folks. Can you hear me?
Now good.
Now we got you.
So, yes, I think it's not a smooth webinar.
Bansal
We
out.
don't have any technical difficulties. But thank you so much letting me know. I hope I'm audible. And I'm very happy to welcome all you folks back to Immigration and Jobs Talk Show. We are streaming live on YouTube, LinkedIn, and Facebook. And thank you so much for all your questions so far. And wherever you're watching us, you can keep commenting because Justin is here to take up your answers. And today we're discussing of if you didn't get selected in the H1B cap lottery, what's next? What can you do? So I think let's take up more questions from the audience. That's fine. Let's take up Madhu. This is on YouTube. Madhu is asking, my application was shortlisted in the second lottery, but my L1B max out period is August 18, 2024. What are my options if I don't want to travel out of the country? That's like 9 days from now.
Yeah, I mean, file a change of status as quickly as possible. Just file a change of status to H1B, but the problem is your age can't take effect until 10/1. So even if you file prior to that timeline, you're going to have a dead period from when your current L1 maxes until the start date on that H1B. You will be in POSA-BAG, a period of stay authorized by the Attorney General. What that basically means is you've timely filed a valid change of status petition that gives you authorization to remain legally in the United States during its adjudication, but you're not going to be able to begin working until 10/1 because that's the threshold. That's the first date that you can actually be on H1B status for the fiscal year.
Okay. All the best, Madhu. And I'm sure, I hope you are able to make it on time.
Yeah, I
All
mean,
right.
the
So,
alternative to that is you consular process, and I know you don't want to leave, but you leave the United States, you wait till the H gets approved, you file for, you schedule a visa appointment abroad, and you go attend the visa interview, get your visa stamp, and come in. You should be able to, top of my head, I think it's like 90 days before the H kicks in that you can schedule a visa appointment. Please don't quote me on that. It could be 60. But you can go to the visa appointment before the start date on the H, and then I believe you can enter the United States up to 10 days prior to the start date of that validity period. So I know you don't want to leave, but you could leave for maybe a month and then come back in right before your H kicks and start working. So I don't think it'd be that big of a deal. The alternative is you hang out here for a little bit, and then you kind of wait and see what happens.
okay. Thank you. Thank you for taking that up for Madhu, Justin.
Mm-hmm.
Now, this next question on the screen is from RK on YouTube. Are J visa options for tech workers and are the impact on future H1B and green card?
Okay, so yeah, I don't want to get too into the weeds with this. To be honest, if you're using a J visa or you've used, if you're on a J visa and you're looking at H1B, going into the lottery change status H1B, there are additional extra considerations that come in. There actually are even specific questions about the J visa contained within the I-129 because there are special requirements associated with that visa. But the thing about those requirements is they actually can even be tied to the country that the person comes from and or the work that the person is doing. So I would definitely say if you are using a J, you're going to need a little bit more extra work on your case than somebody who's moving from like an F or maybe an H4 where it's going to be more straightforward. So yeah, it plays a role definitely in the process. And so I would definitely make sure that you're working with an experienced attorney on that to make sure that they are able to properly determine your eligibility prior to filing.
Okay. Thank you so much for that, Justin. And well, there you go, RK. I hope you got your answer. Okay, moving on now. This one is from Rish. Since I wasn't selected in the lottery, I'm considering enrolling in another degree program to maintain my F1 status. Are there any risks of this strategy?
So
That's it.
the problem with this for me becomes enrolling for another degree program at the same degree level after you have utilized 12 months of OPT. The reason for that is USCIS seems to have taken the holding that if you utilize those 12 months of OPT at, let's say, the master's degree level, and then you go and apply for a second master's because you've maxed out your time and you want to engage in CPT. USCIS seems to have taken the holding that you're not supposed to be allowed to do that, or that it's a violation of F1 status to do that. So I would definitely say that in that situation where you're making that determination, always try to go up a degree level, because if you don't go up a degree level, then you're going to be in a circumstance where if you end up getting to change status, where you get to go from file a change status from F1 to H1B, you could end up with a request for evidence showing that you have failed to maintain status. And that means that you could end up in a situation where your case gets approved without an I-94. And so in that circumstance where your case gets approved without an I-94, you are forced to go abroad, meaning you're not able to remain in the United States in order to activate that H1B. It's not going to change status for you on 10-1, and it's going to require you to go to the consulate for a visa interview. Now, where things get even more problematic in that circumstance is if you're attending a visa interview and you're found to have had a violation of your F1 status. That's possibly a question that's going to come up at the consulate. If that question comes up at the consulate and you don't answer truthfully, then you could be found inadmissible, meaning that they won't give you the visa stamp. They won't allow you to come into the United States. So all of that can be a direct effect of choosing to remain at the same degree level or go up a degree level. Basically, I would definitely say that's the risk associated. I would probably stay away from the second master's. I'm sorry, I'm starting to get close to wrap up time.
Sure.
So I would definitely say when you're looking at a second master's, just make sure that you realize that there is a possible penalty if you've utilized all that OPT time already at the same degree level.
Thank you. Thank you for taking that up. And I think this will give us to this last question, all right, from Drive. Hey, Justin, love your energy. I have a question actually. My current visa status allows me to stay in the US, but not to work. What are my legal options if I want to continue working without violating my status?
It's an interesting question. I mean, I think that'd be status, based. I mean, for example, what's the underlying non-immigrant status that you're currently on? So, if you're on an H4, you have the option of acquiring an EAD in the event that your spouse has that approved I-140. But if you're on, maybe say like a B2, a visitor visa or something like that, that doesn't permit work authorization, you have to change status to another non-immigrant status that carries with it work authorization. Yeah, I mean, don't ever perform unauthorized work. That would be the best advice I can give anyone. Don't perform unauthorized work because you may think that you're getting away with it and not realize that the government is going to look at your entire record when you go to adjust status, if that's something you plan on doing in the future. And I cannot tell you, unfortunately, how many pitfalls I have seen where you're in a circumstance where, gosh forbid, you're adjusting status, you file the 485, and you get hit with, an accusation of a status violation or some sort of issue. Now, there are obviously ways you can overcome those certain issues. I'm not going to go into the nuances of that specifically, but the best thing you can do is present, a squeaky clean immigration record when you're going to file. So yeah, I mean, you have to move to another non-immigrant status. That's going to permit you work authorization. And if not, you have to continue to just live in the United States and not work. But again, it really does kind of depend on what your underlying status is.
All right. All right. So thank you so much, Justin. Is that it? Should we wrap up, or do you still have time for one more question, maybe?
I do apologize, but I'm pretty short on time. I did, if you guys wanted to, I did want to maybe see if we could touch on the updates that had gone on with USCIS just real quick, because I thought it was very interesting that they had actually, for the whole time I've been practicing, H1B ownership of a business has been something that people wonder about. it's tough when you're tied to, just one employer, and you can only work for that employer, and you're not capable, you're not able to start your own business.
Right. I
They've
had a
come back.
question, so it's there on the screen. I couldn't reach up
Oh,
to there, but there you go.
no
Yeah, go
worries.
on.
So I just wanted to touch base on that because it was something I had been looking at over the past couple of days that I thought was really interesting. Before, passive investment in ownership was basically the only route that you could go. So what that means is you could have ownership in a business, but you couldn't actively work in the business. It had to be passive investment only.
Yes.
Now it looks like you can have a controlling interest, and potentially qualify for an H1B with the employer that you own. They're calling this beneficiary owner, which I think is an interesting
Interesting.
phrase. Something I'd never heard
Very
before.
interesting.
But yeah, beneficiary
Yeah.
owner. The idea that you are the owner, basically your company sponsors you for an H1B. So
Yeah.
I thought
How
that's
cool is that?
interesting. It's in its infancy. It's new. Right now there is regulation pending on the performance of non-specialty occupation work. So because I think you're going to get into a lot of weeds here with, beneficiary owner, are you performing specialty occupation work? How are you qualifying? What's the SOC code you're using? What wage are you being paid? I don't think you can be an entry level owner, or can you? I don't know. So these are all like new and exciting things that I think are awesome. We love to hammer the agency when they do stuff wrong. So I do want to at least give them credit when they do something right. And I think that this is an awesome idea that's going to help innovation, and it's going to give H1B workers, particularly the people that are stuck in this backlog, it's going to give them opportunities to hopefully, explore their entrepreneurial abilities. Because I definitely think the best entrepreneurs in the world are typically immigrants. So giving them this opportunity is going to be colossal. I think it's great. We'll learn more about it, and maybe I can tell you guys updates as I learn them.
Sure, me too, me too. I'm looking for more updates, and maybe when we meet up next time, Justin will sure catch up more on this and maybe
Yeah.
have our folks more clarified with this new thing that's there now.
Mm-hmm.
Yeah. Thank you. Thank you so much, Justin. I won't hold you up much, but thank you so much for
No worries.
doing this. It was really lovely having you. I mean, for all your actionable advice as well, for all these folks who joined us with their questions and all these insights you had for us, these alternative visa options also, and the deep understanding we got today. So thank you so much once again on behalf of Immigration and Jobs Talk Show, and looking forward for another webinar maybe in the coming week.
Yeah, absolutely. Looking forward to speaking to you again. Thank you very much for your time.
Thank you, Justin. You too. Bye-bye. Have a
Bye.
great day. Have a happy weekend. Yeah.
You too.
Thank you, friends. You too, for joining us. It was really lovely having you join us with your questions. And as we wrap up today's session, really thank you all for your active participation and for making this a vibrant discussion. So a huge thank you once again to none other than Justin Rivera for sharing such invaluable insights with us. And remember, even if the H1B lottery didn't work out this time, there's always paths forward, friends. So don't lose hope. Always stay positive and keep working hard. And we're here to guide you in every step of the way. So anything immigration related, feel free to contact us as well. And my details are on the screen. You can call me or WhatsApp me on this number, 408-335-6444. You can even email me, nipa@higheritpeople.com. And definitely to get to know more about us, check out our website, www.higheritpeople.com. Also, you can contact me if you're looking for project placements, H4, EADs, green cards, anything related to immigration. If you have any questions, feel free to drop me a mail or a message. Thank you so much, friends, for joining us today. And in case you're watching this webinar after the stream has ended, you can keep commenting your questions because we have our experts who will be more than happy to reach out to you with answers. So thank you. This is Nipasa Pradhan signing off for now from Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com. Good morning, good afternoon, good evening, everyone. Thank you so much for joining me wherever you're joining me from, whichever time zone. And welcome to Immigration and Jobs Talk Show. I'm Napasa Pradhan. I'll be your host for you today for an hour from now. And I have a very important disclaimer before we move on with today's topic of discussion and our whole webinar. So, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, welcome back to Immigration and Jobs Talk Show. And today we are streaming live right now on YouTube, LinkedIn, Facebook, and Twitter. Very happy to have you all join us. And remember that this is also going to be a very participative webinar. So whatever thoughts you have or comments you have, questions maybe, you are free to definitely ask your questions in the comments. We'll be very happy to answer them because we'll also have our expert, our guest for today, who's going to join us, and definitely he's going to make this session a very interesting one. So stay with us, all right? None other than attorney Chand Parvathaneni, managing attorney at the law firm of Sim Parvathaneni and Brown, based in Dallas, Texas, with extensive expertise in immigration law. Attorney Chand Parvathaneni is here to share his expertise on a crucial topic for many international students and professionals. And so you can see today's topic is here on screen. But without further ado, please help me welcome back Chand. How are you doing, Chand? Thank you so much for joining us today as well. And we're very happy to have you back.
Hello, Nipasa. Thank you for inviting me. And yeah, hopefully we'll have a very productive discussion today. And then we'll take up audience questions and then see what are the new changes in H1Bs and compliance issues and everything surrounding immigration.
For sure, for sure. We are definitely going to do that. But before we move into the topic, friends, we also have what is happening recently. Chand, we were talking just before we started this discussion. So, in light of the recent news involving the arrest of Indian students in a major prostitution racket in Denton, Texas, what are the potential immigration consequences for those individuals who are facing charges such as solicitation of prostitution and even and evading arrest? Could you provide insight into how such legal issues might impact their visa status or future immigration prospects as well? Because since we are always talking about immigration, could you please shed some light into this very recent case as well, and also maybe give out some tips to immigrants out there how to be careful?
Sure. And I think so a lot of students, they are coming here to study. And one of the requirements is they go to school and they follow the law 100%. I mean, there is no lenience, there is no leeway. and majority of the people do it. But unfortunately, once in a while, we do see the students. They get involved. They have brushes with the law, and they get in trouble. And so lately, I mean, in the last 1 year, 2 years, I have seen an uptick in RFEs. Somebody applies for their OPT, STEM OPT, or they apply from F1 to H1, and then we see an RFE saying, you have been arrested in the past because of this so and so reasons. So the bottom line is any kind of an arrest could cause a major impact to your immigration process, even if it's a small arrest. And so from that viewpoint, I think what has happened in the last 2 days in the news that has come out is there were a bunch of people arrested in Texas, in Denton County. And this is for solicitation of people for sexual work. So it is not, I mean, these students, they were not really doing any human trafficking. They were not involved in any sex racket. They were not really like doing all those things. All they did is solicit a prostitute. So basically, what they did is they solicited somebody and thought they can get some sexual work out of them. Even solicitation is a crime. It doesn't have to be uh, human trafficking. It does not have to be sex racketing, all those kinds of stuff. In Texas, what has happened is until 2021, if somebody goes and tries to meet up with a prostitute, just a solicitation, it used to be a misdemeanor B. So it was not really a felony. It used to be a misdemeanor. And what that meant is solicitation, which is not the actual prostitution, but just going and asking somebody for some sexual favors for money. Money is involved. It was not that big of a crime. But starting 2021, there was a new law passed in Texas, and this is specific to Texas. So even something simple like solicitation is considered a huge crime. It's actually a felony now. And when we talk about felonies, felonies have a huge immigration impact. If somebody has a felony on the record, they probably will not be able to get through anything with immigration. They will not probably get green cards. They might not get visas. Misdemeanors, one-time misdemeanor, if it's a small crime, depending on the crime, maybe. But if it's a felony, it's always a given that they probably will never have an approval from USCIS. They probably will not get visas and so on. And what that means for all of us, normally, why do people get arrested? If somebody gets drunk and drives, the police catches them, it's an immediate arrest. So DUI is a very, very serious offense. They get arrested. If somebody goes to Walmart and steals something, maybe even something as cheap as $5, it's an immediate arrest. And we had this happen. And I personally dealt with a lot of cases in Denton County where people got arrested, stealing in Walmart. People got arrested for DUI. And just like a month back, I had a case where the wife called the cops and said the husband physically abused her. And and she just called the cops, and she was actually stating that she was not physically abused, but she was in a fear that her husband might abuse her. Even for that, the husband got arrested. So anytime you have an arrest, and then I also had a case in Denton County where this boyfriend girlfriend, they ran into an argument, and somebody saw this argument. They called the cops. The cops came and arrested this person because according to the eyewitness, there was some altercation and probably even some physical abuse happening. So we are seeing more and more cases where people are getting arrested, and any arrest will flag up. I mean, so all these cases that I've been talking about where somebody got arrested, we immediately in a month, we saw Department of State contact these people and say your visa got cancelled. So even a small arrest for something like a DUI, something like a husband and a wife fight where it rose to the level of physical abuse, which is like a big no-no. You can't abuse your spouse. So anytime there is an arrest, your visa more than likely will get cancelled. And not only that, depending on the nature of the crime, you might not even be eligible for getting a future visa. So the bottom line is any arrest is bad. And out of all these arrests, if something is a misdemeanor, maybe you will have a chance to argue. But if it is a felony, for sure, your immigration is going to be jeopardized. And the message for all is be cautious. Do not get involved with anything that is illegal. And again, if you have any arrest, 99% of the time, you will see that raised in an RFE in your future filings. Okay. So just be aware. And a lot of people got arrested, and it was a whole bunch of people. I was actually surprised because we do know that in Dallas County, in Denton County, in Texas, These kind of raids are happening all the time. So I do see people get arrested, but I've never seen so many. I mean, out of the people that the information that they released, I mean, almost majority were Indians and Indian students. So it was kind of surprising. And what that means is this is a lesson for everybody who's complying with the laws. It's a message that you have to be more cautious. Don't think anything is a simple crime. Crime is a crime. It'll impact your immigration process. So always follow the law.
Yes. Very, very well put. Thank you so much, Chand. And definitely, friends, I hope you noted that down. And also, Chand, if you could maybe just give us the real difference between a felony and a misdemeanor, so that folks out there could also be more clear about it.
Sure. And so the way the criminal law works in the United States is it's a state law. So the criminal law that we have in Texas, it is probably different from what they have in New Jersey. Every crime
Yes.
will have like a penalty, whether it's a jail time or whether it is a monetary penalty and so on. And every state has different laws. For example, in Texas, solicitation of prostitution is a felony, and what that means is you can be put in jail for as long as 2 years. You can be penalized $10,000. That is pretty much what is the current statute in Texas. For the same crime in New Jersey, for example, the penalties are different. For example, consuming marijuana, weed in California is completely legal. You cannot be arrested for that. Whereas in
Yes.
Texas, it is illegal. So the state law is pretty important. And from an immigration standpoint, people definitely have to understand what is a misdemeanor and what's a felony. A felony, so normally in Texas, the lowest crime is a misdemeanor C. Then it is misdemeanor B. Then it is misdemeanor A. Then it becomes felony. And the highest class of felony is capital murder, where in Texas, you can get a death sentence, a death penalty. So, from
Okay.
an immigration standpoint, any crime that has a jail sentence of more than 1 year is typically a crime where you more than likely will have a problem with immigration. And felonies are typically crimes that typically more than likely will have a jail sentence of more than 1 year. But again, misdemeanors are the lower level crimes. The felonies are higher level crimes, and even in felonies, normally we have a distinction. The highest felony, and then the highest felony in Texas is basically 99 years of jail sentence or death penalty if it's a murder case. So anytime you hear the word felony, it typically means it's a crime that is like a little bit severe, something like assault, where there is violence involved, or something bigger. If you just go and steal something in Walmart for $5, it's still a crime, but it is not a felony. But if it is something like where you go and beat somebody and the person is like almost battling for his life, more than likely a felony, more than likely a high degree of felony.
Yes. Thank you so much for making that clear for us in such simple language, Chand. And I'm sure folks out there, this was beneficial. And thank you for, making it clear like we should really stay away from all sorts of fraudulent activities, harmful, I mean, things which are not ethical for that matter. So let's definitely stay safe with that. And thank you so much, Chant, for shedding some light on this recent case that is going on. So, folks, at this moment, I'll also want to say that please don't forget to subscribe to our channel, Immigration and Jobs Talk Show, to get to know more about this case, because we'll definitely be covering as it unfolds. All right. So, uh, by the way, does that fall under a category of attempt to murder?
Yeah. So anytime you have attempt to murder, or even sometimes people solicit somebody to murder somebody else, criminal solicitation for murder. So these are typically always felony crimes, because murder is like the highest crime. And whenever you have murder and attempt to murder or solicitation to murder somebody, they always are felonies and they're highest level of crimes. And the police typically, they give very high priority to those kind of crimes, to solve those crimes, to put people
Yes.
behind the bars. So anytime you hear the word murder, attempt to murder, sometimes it is even manslaughter. So manslaughter is lower than murder, but still it is like somebody is dying. So these are all typically felony crimes. And what exactly the kind of a jail sentence you can get for that kind of a felony, it completely changes from one state to another state in US, because criminal
Okay.
law is typically under the state law.
State
So you might see some minor variations. Like in Texas, death penalty is valid. In some other states, death penalty is probably not legal.
Mhm. Right.
And in Texas, typically, if it is a capital murder, they give death sentence. Anything that is not a capital murder typically will not go to that level, and it's probably a high jail sentence.
Right, right. And what about sorry, solication? Also fall under category of attempt to murder case?
Solicitation. Yeah,
Solicitation,
I
yes.
mean, solicitation. Solicitation is like going and approaching somebody uh, to basically say, "Hey, will you go and murder somebody if I give you some money?" That is solicitation. So basically, you are
Okay.
soliciting somebody. You are approaching somebody with an intent to do something criminal. So
Mm-hmm.
solicitation, like what happened in Denton in the last 2 days, was solicitation for prostitution. So they were approaching somebody for the crime of prostitution. So you can see
Yes.
the same kind of solicitation for murder, where somebody goes and approaches somebody and says, "Hey, I'm going to pay you some money to murder somebody." That is a different kind of solicitation.
Mm-hmm. Okay, okay. Thank you so much, Chan, for making this very much clear. And at this moment, I'll just like to say hi to our folks out there who are commenting. Thank you so much for your questions and comments. We are definitely going to get to each one of these questions of yours. But quickly, Abiodun is saying hello, everyone. So hello to you too. And Deepika Rao, thank you so much for joining. Akbar, we also have Vishnu Vardhan. Thank you so much for joining us. We will take up your questions. Just stay with us for now. All right. So, without further ado, let's get to our topic for today. The topic is, what are the challenges in transitioning from F1 to H1B? So, we will definitely talk about the challenges we face and how maybe what solutions we have today. And Chand, thank you so much for joining us for this topic. Maybe we can tell the friends out there what can they expect from us in this under this topic today in today's episode.
Sure. So I think the biggest challenge is make sure you're following the rules, and that is the biggest
Mhm.
challenge. So that means no crimes while you're on F1. No, not. I mean, I would say like try not even get a speeding ticket. That's how
Okay.
good your record should be. That being said, always, I mean, there are some things that are probably not in your hand, like speeding. Sometimes accidental speeding once in your lifetime. But overall, I mean, the challenges are the big challenges you see are making sure you're maintaining your status, making sure you're doing what you're supposed to do, and then everybody's goal is once you graduate, your career. You're studying so hard, you're getting a degree, an
Mhm.
American degree, to have a good career. So I think the biggest thing, the biggest challenge is finding the right career, the right occupation, the right company to work with that aligns with your goals. So overall, what we will discuss is the legal aspects that you should keep in mind to make sure you have a seamless transition from F1 to a H1B, because your goal is end of the day you want to have a good career, you want to follow the rules, and do something good in your life that will also benefit the society, where you can use your education to benefit both your family and also the society. So we will talk about all the legal challenges that you might see, and the precautions that you are supposed to take to make sure that you don't see any kind of things that you cannot avoid. Things like bad RFEs, where they will say you did something bad, you did not work during your OPT, uh, or something of that sort. So we will talk about all the legal aspects that revolve around moving from F1 to H1B.
Definitely, we will. So it's a very critical process, for many individuals, especially those who are navigating their career paths, in the United States. So understanding the hurdles and it can really make a big difference. So today Chand is here to help us with that. And so I got this first question for you, Chand, right now, that's coming up. Maybe before we get really deep into the topic, you can just give us the base, just in simple words, to folks out there, what is an F1 visa and what is an H1B visa?
So the both the visas, they are non-immigrant visas. So non-immigrant visas mean you have a temporary purpose. So you go, you finish up your job, and I mean finish up your what you're supposed to do under the terms of that visa, and then you're done. So that's a non-immigrant visa. It's not a permanent visa. It is given for a duration. And when we talk about an F1 visa, the F1 visa in simplest terms is it's a visa given to international students, and their only intention is to study full time, and they want to study full time in either a university, a college, or a school, and they're living in the United States. They are going to one of these educational institutions and they're studying. That's all it means. So F1 is for international people, but who want to be students and study in US. So that is what is an F1 visa. H1B visa, again, it's a non-immigrant visa, but it is a visa for those people who want to come to US and work. And these people want to work in highly specialized fields like technology, engineering, or medicine. It is not any kind of work. It is a specialized work and a specialized field where you at least have a bachelor's degree. So that is what is an H1B visa, a work visa in a highly specialized field. And normally you get this H1B visa for 3 years max each time. So each time you are eligible, you typically get it for 3 years. And there is a duration, which is why it is called a non-immigrant visa, because it is not a permanent visa.
All right. Thank you so much, Chand, for getting our ground ready for today's topic. All right. So moving on, I have this next question, and if you could provide a complete timeline, outlining the process from F1 visa to an H1B visa, including any challenges faced, such as STEM OPT denial or an H1B transfer, also.
Sure. So in terms of the timeline from F1 visa to OPT and to an H1, so it's a process that is spread out over a couple of years. So the study program. So people are typically doing either their bachelor's or their master's, or some people do their PhD. So people have to account for the time period that they're doing their studies. And once their studies are over, typically what happens is there is this like very nice feature in United States called optional practical training. So most of the students, what they do is they transition to this OPT, this uh, thing where they are still technically under student status, F1 visa, but they're not students. They're actually working in the industry. So that is what typically people are supposed to do. They are supposed to finish their studies, and then they're supposed to get this practical training. So practical training is where they can just get some training done, where they shadow somebody at the company and get some training done, or they can actually work, earn money, and learn in their course of study. So that is what somebody is supposed to do. Basically, they're supposed to utilize their OPT program and get some training done. And what that means for everybody is you have to start really planning early for your OPT. And there are strict guidelines. So you actually have to physically apply. It is not automatic. You have to apply. You have to go to USCIS, make a 765 application, pay the fees, and there is a process for that. You have to work with your school DSO, get the I-20, and apply before the deadline, and get your OPT. So get your OPT, and there are strict rules on what you're supposed to do. You're supposed to make sure you're at least getting training for 20 hours or more. You do that part, and once you're doing that part, uh, finish your OPT and look for good career options, because what happens is as you get your training, as you increase your skills, the industry skills, you will get more and more good offers. So look for companies that are legitimate, look for companies that are in your line, and try to get a job offer from them. And while you're doing that, you secure H1B sponsorship, because what needs to happen is your OPT is limited. So you get OPT for 1 year, and if you're lucky and in the STEM field, you get 2 more years. So if you're in STEM field, you get 3 years of OPT. And once you're done with that, you eventually have to find a H1B sponsor. So your goal during the OPT and STEM OPT is to find the right employer, because you'll find a lot of employers out there, and some employers are probably even shady. There are a lot of these consulting companies who are small companies, sometimes probably even large companies who are not probably following the rules. So always during your OPT, you have enough time. Research your companies, target your employers. Don't just randomly take any H1B sponsorship, because we had cases where people just randomly went to this any employer, and these employers did multiple filings, multiple registration issues, and a lot of students, they were impacted. So target your employers, do a lot of research, and make sure the people you're working with, the employers who are giving you the job offer and saying that they're going to sponsor your H1B, they are legitimate people, they're legitimate companies. You have enough time, there is no hurry. So take your time, do that research, and then make sure the company applies for your H1B. Okay, so that is basically the final thing that you're supposed to do. Ensure that you get your OPT properly done, your STEM OPT properly done, and don't get a denial for your OPT or STEM OPT. And eventually have the company sponsor your H1. And if the company is legitimate, more than likely your case will get approved. Because most of the time, what happens is if you're on F1, you are getting a solid US education. And when the US CIS officers, they see that you graduated, you got all this education done in US, they are inclined to approve your case unless the company is bad or company is shady. So your bottom line is you already have that US education. Make sure you work with a legitimate company, and then majority of the time the case will get approved if the company is legitimate.
All right. Thank you so much. And also, since I feel like it is kind of timely, let's take up this question quickly from Facebook from KP Karupu asking, what about the difference between CPT and OPT?
So OPT is optional practical training. So the word OPT means you typically finished your degree program, you graduated, and then after graduation, you're going and getting this practical training. So practical training basically means you're going out in the industry and you're working. You're working in the industry, and most of the time you're getting paid. So that is so OPT is basically limited to those times where you graduated and getting this training, this work authorization after your graduation. CPT, on the other hand, again, it is practical training. It is actually you're working in the industry. You're probably getting paid. The only difference is it is curriculum practical training. So you probably have not graduated yet. You're still studying. You're still attending classes full time. And while you're attending classes, you're going off campus and working in the field of your study. So CPT means you are still a student attending classes full time. You have to attend classes full time, and then you're working and making money. OPT means you finished your graduation. You're not attending classes. All you're doing is only working. So that is the difference. One is where you're still attending classes full time. The other is where
Mhm.
you finished your graduation.
All right. Thank you so much. And KP, thank you for your question. I hope that is very much clear. All right, moving on now. Chand, I have this next question for you, and that is, what are the top five tips for successfully transitioning from an F1 student visa to OPT and ultimately to an H1B visa?
Sure. I think the main thing is again applying for OPT, graduating at the right time because you do have to graduate. You do have to graduate with good GPA because GPA is sometimes a lot of good companies actually look at your GPA. So your first and foremost thing should be make sure you graduate well. You don't have any academic probations. You don't have any low grades. That is very important. Make sure you're taking right coursework because a lot of schools they have the core curriculum and then they have electives. So always look for electives that are in highly demanding fields. For example, for H1B, most of the cases that nowadays that I see are for data engineers, data scientists, AI. So that is where I see a lot of demand. When I see a lot of my H1B cases where what we are filing at a law firm, I see a lot of these BI engineers, data scientists. That is where I see a lot of focus. So definitely try to get electives done in those high demand areas because that way you can market yourself to the companies. That is very important. So good coursework. And once you're done with that, the OPT. So the OPT is the next big thing. And the big tip for OPT is start conversations with your school DSO well ahead of time. I just saw a denial today where somebody sent me a denial and said if you can fight it. And the denial was so you get so when you are applying for the OPT, you have very strict deadlines. So you have to apply within a certain timeline, and then you have to get an I-20 that is going to have your school DSO's recommendation, and then within 30 days of that recommendation, you have to apply for the OPT. And in this case, what happened is this young person, talked to the school DSO. He got the I-20, but then he did not apply within 30 days. He applied on 33rd day. And USCIS gave that and said, on technicality, this case has to be denied because you failed to meet the 30-day time period after your I-20 was issued. So very important tip is don't wait until the last minute. Know the rules about OPT, the initial OPT. Know when you're required to apply, the duration you're supposed to meet. Get the I-20 from your school. Be ready to apply within the time frame. Very important. If you miss the timeline, you're going to be in serious trouble with OPT. And the same thing with STEM OPT. The third thing is don't forget your STEM OPT. A lot of people who are doing STEM fields, science, technology, engineering, math, you also get additionally 2 more years. Okay, so the third tip is don't forget your STEM OPT. Again, STEM OPT again has deadlines. You do have to apply well ahead of time. You can't wait until your OPT expires. You have to get again the I-20 recommendation. You have to get the 983. So there are some requirements. So make sure you go through that and apply for STEM OPT timely. That is very important. And while you're on STEM OPT, very important thing to note is employment, pay, the wages. While you're in initial OPT, you can just do training. So even unpaid training is fine. But in STEM OPT, you don't have a choice. You have to get paid. So you have to find not only training, but you have to find paid work. So you have to find productive work, not just training. That is very important. A lot of people miss it. We get that RFE during H1B. So make sure during STEM OPT you are getting paid, and know your unemployment limits. So there are unemployment limits. So the tip is, for OPT you can have 90 days of unemployment. For the entire OPT plus STEM OPT you can have 150 days of unemployment. So make sure you are actually looking at your unemployment days. You are figuring it out. At the time of your H1B, they will look at your unemployment. So make sure you don't, no matter what, you don't exceed your allowed unemployment dates. This is very important. And once this is all done, you find a good sponsor, and the sponsor is applying for your H1B. At that point of time, there is something called cap gap, and there is also something about traveling after your H1B is filed. So make sure once your H1B is filed, to successfully transition to H1B, you look at cap gap if it is applicable to you. If you have any travel plans, make sure you talk to your employer or to the attorney. Don't travel without telling them if your H1B has already been filed. Very important. You have a change of status request filed and you travel, the change of status is going to get denied. So be very, very careful about traveling after your H1B is filed. So I think overall, I think if you take care of these things, I think you'll have a seamless transition to H1B, because most of the time people, I think, they are not aware of the rules. They're not aware of the deadlines. So they forget about cap gap. They forget about travel requirements. They forget about getting paid during their STEM OPT. It's not just basic training. It is more than training. It is showing productive work and getting paid. So overall, I think if they take care of all these issues, they know that these are issues and do some research, I think they will have successful transition to H1B.
All right. Very important to keep all these rules in mind and never to miss out on dates. It's always important to make sure that the dates are correct, and not just uh, the dates that you should file, but also keeping in mind the dates of each form, because even the forms have dates issue. I mean, dates of issue, right, Chand? What about that?
Right, right. And this is another thing I see a lot of people missing. So the
Yes.
765, sometimes people, you can do online filing, but sometimes people also do paper filing. And sometimes
Yes.
they use the wrong edition. And these editions keep
Right.
changing. So people also, when they're filing their 765s, especially if they're doing the paper filing, be very, very cognizant of the edition dates. If you mess up the edition dates, or you mess up the fees that you're supposed to pay, you'll get a denial. And then by the time you're able to react back, sometimes the deadlines are passed. The USS will come back and say you passed the deadline. Now you can't have an OPT approved. So very, very important. Edition dates are super important, and the deadlines are super important.
Thank you, Chand. Thank you for taking that up. Well, I will take up this next question now I have for you. Can someone on an F2 visa change their status to H1B? Specifically, are they allowed to search for a job while on an F2 visa? And if they secure employment, can they transition to an H1B?
Sure. So F2 visa is basically for the spouses of the students. So students are on F1. So F2 is the spouses. And a lot of times the spouses are also well qualified. They have a good degree in India, for example. They have a computer science degree from India, but they came in as spouse. And since they're on their spouses, F2 spouses cannot work. So they have to stay without working. But sometimes they get a good job offer. And yes, the F2 person can change to H1B. It is allowed. And the way it works is they find an employer, again, just like anybody else. And that employer has to go through the lottery because they're on F2. So, uh, I mean, if they went through the lottery in the past, they don't have to go through the lottery. But if this is the first time that they want to get on H1B, that employer has to go through the lottery and then apply for H1B. So just like any other regular H1B, what happens is that employer will say, this person is on F2 and we want to change their status from F2 to H1B. So you can do a change of status filing from F2 to H1B, and F2 people can search for a job, can look for a job. There is nothing wrong with that. The only thing is they cannot really start the job unless the H1B is approved. So if they find a good employer, they can look for an employer. If they find an employer, that employer can sponsor their H1, And the only thing to keep in mind is wait until that H1B is approved. And once the H1B is approved, they're good to start.
All right. Thank you so much, Chand. And well, the conversation is getting really interesting, but I think it's kind of time to take a short break, but I'll quickly say hi to Sanket, Dennis. Thank you for your questions. Kavita, also, we will take up your questions for sure. Please stay with us. And also, Dennis Bang now. Thank you so much. We will take up your questions. Also, if you want to contact Attorney Chand directly, you can always write to him. It's always good to consult an expert and get your cases scrutinized because each case is very individualistic. And so, yes, you can find the details on the screen scrolling. And definitely to get to know more about Attorney Chand, go visit his website, spblawfirm.com. You can call him on his number 817-523-8247. You can even mail him law@spblawfirm.com. And we'll just go for a short break now. Friends, don't go anywhere because right after the break, we will talk more about the challenges in transitioning from F1 to H1B on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higherightpeople.com or visit our website www.higherightpeople.com.
Welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we are discussing about what are the challenges in transitioning from an F1 visa to H1B visa. And it is a very critical process for many individuals navigating their career paths. So, and helping us out today is none other than Attorney Chand Parvathaneni. And it's been really good so far, so good. Chand, we've already covered much ground on this topic. And I think folks out there are also very curious because they have a lot of questions I can see. I think we should take a few of them if that's fine.
Sure. Yeah.
All right. So let's quickly take this one from Vishnu Vardhan. Hello, Chand. I need your help in my case. Thank you, Vishnu, for your questions. I'm working for MNC company in India and having H1B I-797B approved petition, which is filed in 2022. My current employer is not sending me for stamping and travel since 1 year. I wanted to resign from my current company and do visa transfer to some other company as I have my I-797B and planning to travel United States. My concern here is will it be possible? And is there any chance to revoke my H1B by my current employer? And number three is, will revocation impact my transfer process? And how much time will it take for employer revoking?
Sure. So the good thing is you have a H1B approval in 2022. And what that means is you went through the lottery in 2022 and you got an approval. And that makes you cap exempt. So you are cap exempt for the purposes of H1B. So another employer, if you have another employer who has given you a job offer, they can sponsor your H1B and they can do a transfer. So basically, they just have to show proof that you got an approval in the past. You went through the lottery. So you do have your 2022 approval. And they can use that to file a new petition for you under cap exemption. And since this case has been approved for a long time and has not been revoked by USCIS, you are eligible for a transfer. It does not matter that this other company will revoke your H1B. You should still be eligible for cap exemption based on the fact that you went through a lottery in the past and got an approval. So if you have a good employer who's willing to sponsor your H1B, I think you should explore that option, and you should be eligible. At least from a cap exemption perspective, you don't have to go through a lottery. You are eligible for a transfer. So, I mean, good luck in your process, and hopefully you have a very good employer. And I don't see any problems in your case. And even if the other employer decides to revoke your case, I don't think it should impact you because you are cap exempt.
Great. All the best, Vishnu Vardhan. Sounds like it's a good scene for you. So all the very best. Let us know if you make it. All right. All right. So this next question is from Abiodun. Hello, everyone. Hello to you too, Abio. Moving on, let's take up this one from Deepika Rao. I'm currently on an F1 visa and want to transition to H1B. Can you explain the cap gap rules and how they impact my status?
So cap gap is, I mean, it's going to come into picture when your F1 status is about to end, but then you have a H1B filing that has been done for you. So to give an example, what happens is, for example, you go through the lottery process in March, and your H1B is picked up in the lottery. But say your OPT is expiring in the month of, say, for example, April, for example. So April, your OPT expires, so your student status is expiring, but then your H1B has been selected in the lottery. And when H1B is selected in the lottery, the earliest they can ask for approval is October 1st. So they cannot file a H1B for you before October 1st. But your student status is expiring. So in those cases, cap gap means there is a gap between the time your F1 status expires and the time when they can ask for your H1B. So this gap gap can be fixed by doing something called cap gap. So cap gap is a feature where if your H1B is filed with USCIS, if your H1B is pending with USCIS, you are allowed to stay back in the country until your H1B is approved. And depending on when your OPT card, your EAD is expiring, your employment can be extended automatically. Even if your OPT, STEM OPT expires, for example, in April, and they do a H1B filing for you, the time after your OPT EAD card expires, you can get extension of your employment until September 30th. So basically, they are filling up that gap because you have a H1B that is in process. So cap gap is a feature where you can extend your status even after your student status expires if you meet certain conditions, and the primary condition is you have a pending H1B.
Okay. Thank you so much. And Deepika, thank you for your question. I hope you've got your answer. Let's take up this next one. This is from Dennis. Any update on EB3 in October or prediction or possibility of direction?
Sure. And I think I'll talk about India because India is a country that is severely backlogged for EB3. So EB3 refers to the green cards. So green cards under employment third category. And October, the reason October is very special is because October is the time when the new numbers. So the fiscal year for USCIS starts on October 1st. So starting October 1st, USCIS will have 140,000 green cards that they can issue under employment-based categories. Every year, October 1st, it gets reset and the numbers come back again. So the general consensus is October is a time when big movement is possible. And theoretically, historically, every year we see good jumps in October. And that being said, I think a lot of countries went back, rest of the world went back. And those people, I think, will again see good movement. I think it will move back up in October. But when it comes to India, India is stuck in 2012 right now. And if you see what has been happening in the last 6-7 months in the visa bulletins, India is not really moving ahead at all. It has been stuck in 2012 for such a long time. October, I definitely think that we will see forward movement. This month, we did not see any movement at all in September bulletin. October, I think you'll definitely see some forward movement. Will it be drastic where it is like 1-2 years? Definitely not. But I think you'll see a few months of jump. Definitely, you're going to see a forward movement, a few months movement. I don't think it'll go more than a year for sure. It'll be definitely, I think my opinion is it's going to be less than a year Probably a few months is what I think you can expect in the month of October. And then we'll have to see how the rest of the world demand is, because the rest of the world demand will predict what could happen to the India dates in the future.
Right, right, right. All right. Before we take up more from to, okay, let's take this one from Kavita. I was previously on F1 and transitioned to H1B, but my H1B petition was revoked due to a company merger. Can I revert back to F1 status, or do I need to leave the US and reapply for a new H1B?
So, looks like you did get your H1B approved, and if the H1B petition was revoked after October 1st, say you got your approval, and after October 1st your H1B got revoked, you are cap exempt, and what that means is you can find another employer and probably be able to do a H1B transfer. But we had some cases last year where the big companies, they got an approval because you can file H1B from April, May, and June time periods, and people get an approval, but that approval is only valid from October 1st. And in your case, if this H1B was revoked before October 1st, you cannot really use that H1B for cap exemption. Only after October 1st, if your H1B is revoked, you will still be okay. You can go and look for another H1B sponsor. You can use cap exemption. So what you would need to do and research is, when exactly did your H1B get revoked? Was it after you started H1B or before your H1B October 1st date? And based on
Mhm.
that, you may or may not be eligible for cap exemption. But if you're eligible for cap exemption, you can just simply find a new employer and try to work on H1B.
All right, Kavita, all the best. And yes, now I think let's take up this next question. This is from Nikhil. Okay, let's take this one first before Nikhil's question. Nikhil, just stay with us. This is Sanket. Can you please tell me about New Zealand visa? I do not have a job offer. Okay, that's the
I'm
question.
not much sure about countries other than US, but again, I don't know anything special about New Zealand. But Australia, so people, a lot of Indians, what happens is they go to Australia, they work, they get citizenship in Australia. So anytime somebody is a citizen of Australia, they have a
Mhm.
separate class of non-immigrant work visas called E3 visas. So if somebody is a citizen of, goes to work in Australia, becomes a citizen of Australia, they have this special feature called E3 visas, where they can use that to come to US and work in the United States. But as far as New Zealand is concerned, I'm not sure how the New Zealand rules work. But if you're working in New Zealand and want to come to US, you can definitely use H1B, but you would need a job offer and you would need a company in US to sponsor your work visa to come to US.
All right. Thank you, Sanket, for your question. And if that was what you're looking for, I hope you got your answer. But if you have more questions, you can always keep commenting. Thank you. All right, now this next one. Yes, Nikhil on YouTube is asking, Hey Chand, I'm Nikhil. I have a master's degree in computer science and I am currently working for a DOL program called Job Corps. Do I have any chance for filing for a green card? I really appreciate.
Sure. So in the employment-based categories, typically you need a job offer for majority of the cases. So EB2, EB3, you always need a job offer. And what that means is you need to have an employer, and that employer should be filing your petition, your I-140 petition. So whoever your employer is, they would have to file your whole green card process and do the filing done. However, depending on the kind of work you're doing, if it is in the national interest, because you said it's a dual, it's a federal program, and if you can argue that your work is in the interest of the nation, there is something called EB2NIW, National Interest Waiver. So you can definitely try to explore and see if the kind of work you're doing is in the national interest, which I think potentially it could be. And then you can explore EB2 NIW. So this EB2 NIW, it's this green card filing. It's this immigrant I-140 petition where you self-sponsor yourself. But you do have to prove that whatever work you're doing, it's in the interest of the nation, and that's why you need a waiver. So other people, they have to go through the process, the perm process, the labor process, where the company has to do the filing. So you would have to argue that in the interest of the nation, you qualify for that waiver, national interest waiver, EB2 NIW, and then see what USCIS does. So I think we need to look more into what your program, what your job role is, and what your qualifications are. But definitely explore EB2 NIW because that's a feature where you can just do the sponsorship yourself without even relying on an employer.
Okay. Thank you so much, Nikhil. I hope you got your answer. And if you have more questions, we're still here for a little more time. So quickly tell us if you need more answers. All right. We also had some more questions, Chand, like from our last episode. Sorry I couldn't be here, but, the show was great and we had a lot of participation. We had questions from a few of our audience, and we'll take up two today as well. So definitely we will. But quickly, we will take up right now this one from Amitabh. I am an F1 student who completed my degree and am now on the 60-day grace period. My employer filed an H1B petition for me, but it's still pending. If the H1B petition is approved, but my OPT has expired, can I still travel internationally and re enter the US on H1B status? Or do I need to wait for the H1B approval and then leave and re enter the US?
So again, this is a good question, and I think because travel anytime you have your H1B in process, it's something that you really have to consider and take some legal opinion. Number one, and number two, I see that you're within the grace period, and looks like your H1B has already been applied. So you are a classic example of cap gap. So you should talk to your school, and you might be eligible for cap gap because looks like your H1B has been filed before your OPT expired, and then you're also within the grace period. So anytime your H1B is applied before your grace period, you should be able to stay back in the country till your H1B is adjudicated. And if your H1B has been filed before your OPT has been expired, what happens is you get an automatic extension of your OPT till September 30th. So you might even be able to work. So go to your school DSO, show them proof that your H1B has been filed, show them the receipt, and talk to them about cap gap and see if you are a candidate for cap gap. And normally they look at the rules, they will see when your H1B has been applied, and then they will see when your grace period has started, when your OPT has expired, and they will tell you if you're eligible for cap gap. So definitely talk to your school about cap gap. You might be eligible. They might be able to issue a new I-20 as one thing. And the other thing is, say for personal reasons you want to go out of the country, if you travel out of the country. If you do travel out of the country and your H1B was filed with change of status, what will happen is your H1B can still be approved, but your change of status, that will be denied. And what that means to you from a practical standpoint is you have to wait outside until you get your H1B approval. Once you get your H1B approval, you go for stamping, and then you get a H1B visa, and then you enter back into the country. So talk to your school DSO. If you're eligible for cap gap, take cap gap and stay back in the country. But if you have to depart from the country, just understand that you would have to wait until you get visa stamping done and come back. Okay. So either way, I think your H1B should not be impacted. If you're eligible for cap gap, you can basically, even after your grace period, you can stay back in the country. If you're not eligible for cap gap and your school refuses to give you an I-20, travel out of the country, be prepared to go for stamping, and then come back into the country.
Okay. All right. All the best, Amitabh. Thank you for your question. And now, Chand, I was telling you about the questions from our last show. So let's take up this one. This is from Mr. 260319885. What is prediction for EB1 India in October 2024?
So EB1 right now in September bulletin, if you see, the date has moved back to November. So it is November 2022. And last couple of months, EB1 has also been pretty bad. India is, February. China is November. India is February 2022. And what that means is anybody in EB1 category before February 2022 can get a green card now. So after February 2022, even if you have an I-140 approved with EB1, you cannot get a green card. So more than 2 years plus of wait time. What will happen in October? I definitely think the dates will move up because October EB1 typically moves a little bit faster. EB2, EB3, I don't think India will move that drastically. But EB1, I definitely think you can probably see at least a couple of months to close to a year. There is a good possibility. I mean, my guess is probably at least a year is what I assume. Because right now we are looking at more than 2 years plus backlog because the priority date is stuck in February 2022. So Uh, Definitely. My guess is you can expect close to a year. And that being said, what I always do is look at the second chart, the date of filing chart. And in September bulletin, the date of filing chart is not that attractive. If you look at the chart one and chart two, they're very close. Both are in February 2022. So it some people interpret that as saying that, hey, the dates might not move very far ahead because even the second chart is pretty backlogged. But because it is October, because we know that another 40,000 green cards can be given under EB1 category. So it is 40,000 for EB1, and out of which 7% is for India. So, which means that there is still a good potential. And I would say a couple of months to a year is probably what we can expect in October for EB1 India.
Still, some movement is still better than nothing. So I think that'll still be good. Thank you so much, Chant, for the prediction, and let's hope for the best. Okay, now this next one. Yes, this is also from our. This is from G1 F1. So the question is, how about countries that have not been oversubscribed? Would the retrogression still affect them? I think this retrogression is supposed to be by country. Those that have been oversubscribed should be listed, and those that have no should also be listed so that we can know what expectations we are to have from our embassy.
Sure. So, I mean, again, in September bulletin, it was kind of shocking because EB3, which is rest of the world, EB3 for rest of the world, we saw like the dates go back. They went back almost to 2020. And EB3 rest of the world is typically not that backlogged, but it did go back. It was heavily retrogressed back to 2020. But my guess is rest of the world will definitely come back up in October. Rest of the world typically doesn't see that kind of huge backlog. So retrogression, I think, is still going to impact countries like India, China, the oversubscribed countries, but not really rest of the world. Rest of the world, I do think that you will see some forward jump in October. Probably a good jump in October.
Good jump. All right. Thank you for your question, G1. I hope you got your answer. And thank you, Chand. All right. So let's move on now quickly back to our audiences right now who are looking for more questions. And Nikhil, by the way, whose question we took up earlier, says thanks also. So thank you, Nikhil, for your question as well. Now let's take up Sakshi. As a consultant working on F1 OPT, I have been assigned to a client project at a third party worksite. My employer filed an H1B petition for me, but the petition lists my employer's office address, not the client site where I'll be working. If the H1B petition is approved, will I need an H1B amendment or a new labor condition application, LCA, to work at the client site? And another question is, and what documentation will be required to ensure compliance with USCIS regulations and DOL requirements?
Sure. So for everybody out here who has an H1B filing in process or about to be done, remember your rights. Your right is that LCA copy has to be given to you. So every employer has to give the copy of the LCA underlying your H1B filing to you. It's not an option for the employers. They have to give it to you. So make sure you do have the copy of the LCA in your hand. Take a look at the LCA. LCA will have something called the worksite address. So look at the LCA, look at the worksite address. Once the H1B is approved, you can only work as per the terms of this LCA. So if the LCA says you're supposed to work at so and so location, you have to work at that location. Or at least you have to be within the commutable distance, at least in the same metropolitan statistical area, the same metro area of that LCA. So if your company has a H1B filing done, for you to work as a software developer, say, for example, in client Verizon in Dallas area as a software developer, and tomorrow your project can change. But if you're again working in Dallas area, maybe for another client, but still in the same occupation, you don't really require an amendment. So the bottom line is take a look at your LCA, look at the worksite address. And in your case, if your employer is putting the right location, you're good. But tomorrow, if your employer says, no, you have to work at a different location, which is not in the same metro area. Suppose if it's Dallas, a different project in Dallas area is okay. But if they say, no, you have to work in Austin at our headquarters, for example, you have to have an amendment filing done. Without an amendment filing done, you cannot just relocate. So the crux is you can only work from that city where, or that metro area where you're allowed to work. Use the LCA to determine whether you're working at the right location or not. If not, you're not in compliance. You're not in compliance with the H1B regulations unless an amendment is filed. So always a good idea for all of you to take a look at your LCA. If there's any discrepancy, bring it to the employer. Say, hey, the rules say that an amendment is required. Okay, and document it. Okay, so that way, if they accidentally overlooked something, you can make sure that you did point it out to them and got the filing done. And if not in compliance with the LCA, you're gonna have trouble when you go for stamping down the line, maybe at a USA site visit and so on. So it's good at least you notice this discrepancy. So just check with your employer and see what happened, and maybe they have a different project in mind from October. So check with them and make sure you are working only at the locations as stated in your LCA.
Very important. Thank you so much, Chand, for taking that up for Sakshi. And Sakshi, thank you for your question as well. Let's move on now to this next question. This is from Jagadish Kumar. Hey Chand, I'm Jagdish. Any update on pilot project? What is a pilot project, and
I
where
think
have
it's
you
yeah, I think the only pilot project I was aware is earlier this year they had a pilot project for H1B visas. So basically, stateside H1B visas where people don't really have to go to India to get stamping. So it was a pilot project where they said they will only let some people get H1Bs stateside, basically within US, without traveling out of the country. And they're going to use the data from that project to kind of open it up to more wider audience. And I've seen this in February. Initially, a lot of people were successful. Whoever were allowed to apply, they were successful because they had some criteria. They said only if you meet this certain criteria, you can apply, you can be a part of that pilot project. And the way I saw it was the pilot project was definitely successful because I did see a lot of people get the H1B visas in that pilot project where it's a pilot test run where they're trying to see how it works. But now we are in the middle of an election year. We are in the middle of an administration change. So I don't know whether they will open up that pilot project, make it more wider, and let everybody use that process where they can get H1B visa while they're in US without traveling to India. So we don't have more news about it in the recent times, but they have data. So I think it was a successful pilot test run, and we have to see because they will also look at their administrative burden and what kind of challenges they had on the administrative side. And I think down the line we will know whether it's going to be opened up for more people or whether they will shut it down. At this point of time, we don't know what's going to happen. Definitely, the administration will change after the elections. So I think a lot will depend on the priorities of the new government, new administration, new president.
Definitely, definitely. And come November, we are definitely going to have a lot more changes. But before that, we also have October, which is going to be a new fiscal year for us. And I think we are all looking forward for big changes this October. And let's take up the last question for today, Chand. And this is from RK on YouTube asking, how do you think high NIW approvals have impacted EB2 row? They historically haven't been backlog, and we see that the category has been backlog over the past 2 years, which previously never happened.
Sure. I think definitely high NIW approvals will impact EB to rest of the world also to some extent. The reason is there is a fixed limit. USCIS cannot exceed the 40,000 EB2 green cards. So under EB2, we again have 40,000 green cards. 7% can come to each country. And when we have NIWs, so what happens is we have NIWs, so we have other countries. So some people probably have priority dates well in the past. So the demand, as we are seeing more NIW approvals, it means that there is more demand on the EB2 side. And again, NIWs can be from different countries, but always you have more approvals, which means more demand. And whenever there is more demand, EB2 or ROW is going to get impacted because DOS, Department of State, USCIS, they're indicating that they are seeing demand from rest of the world. So more approvals, more people getting into the system. is going to impact the priority dates, because there is only 40,000 green cards that can be issued under EB2, and there is not much spillover. This current year, from their disclosure, they're saying that only they had about 20,000 spillover from the other categories. So 140,000 is set in law. So no matter what, 140,000 is allowed to be given for all the employment-based categories. On top of it, they had 20,000 extra green cards, so they had 160,000 green cards. There was not a lot of spillover. So not having a lot of spillover like they had in the previous years, I think also impacted rest of the world. That was one reason, and definitely I think a lot of demand. And when you say a lot of EB2 NIW approvals, it definitely means that there is a lot of demand from everywhere.
Yes. Definitely, definitely. RK, thank you for your question. Really good to have you participate as well. And Chand, also very enthusiastically, you answered so many questions from the audience today and also our questions. Thank you so much, Chand, for today.
Thank you, Nipasa.
But I think, there's a lot more to talk about this topic. And I think we should surely continue with this topic in the coming week also, if possible. But also before we leave,
Sure.
Chand, if you give our audience an end note just to wrap up this discussion for today.
Sure. And I think a lot of audience today are probably students, because students are trying to transition to H1B. I think this was a great platform, because I think because of your platform, I think we're making people aware of the kind of arrests that are happening. So we want people to be aware. I mean, the reason I think we need to bring up these kind of things is not to shame some people who have done the crime. That's not the goal at all. The goal is to show that, hey, look, a small crime could totally jeopardize your career. So that awareness has to be raised in the society. And I think it's times like these where you go back and reflect and say, hey, the small people think it's a small thing, a small crime, but now their entire career is jeopardized. So definitely, I think it's a message to everybody out there to follow the law 100%. It's not like you follow the law 99% of the time and 1% make a small mistake. No, it's like 0% mistakes, especially when somebody's an immigrant coming to US. The burden is even more to make sure that there is 100% compliance. And that's the goal. And I think the forums like this, like talk shows like this, I think it's an opportunity for everybody to kind of regroup and say, hey, this is very important. And you can never, ever forget the importance of following the law.
So true, Chand, and thank you so much for encouraging us with your words as well. We will keep doing our thing. We love doing this. So friends, you too, don't forget to love us. Just show your love by liking, sharing, commenting, and definitely participating as well. So thank you so much once again, Chand, for doing this, and I hope to see you again in the coming week.
Yeah, thank you, Nipasa.
Thank you. Thank you. And folks out there, thank you so much. It's been lovely having you once again. So don't forget to contact Attorney Chand. His details are on the screen. You can call him at 817-523-8247. You can mail him at law@spblawfirm.com and go visit spblawfirm.com to get to know more about Chand and SPB Law Firm, definitely. So thank you once again. And it's always best to consult an attorney because every case is different. So you might as well. Also, if you're looking for project placement, career opportunities, for or maybe looking for sponsorship for H1B, E3, OPT, TN, visas, anything about immigration at all, you can definitely contact me as well. My details are on the screen. My phone number is 408-335-6444, and that's where you can even WhatsApp me. You can even email me, nipa@highrightypeople.com, and definitely to get to know more about us, go check us out at www.highrightypeople.com. Thank you so much, friends, and this is Nipasa Pradhan signing off for now, but don't forget to subscribe to Immigration and Jobs Talk Show. Bye-bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website.
Welcome everyone to Immigration and Jobs Talk Show, and I'm very happy to have you all join us today. I'm Napasa Pradhan and I'm going to be your host for this session. And before we move ahead, I have this important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, it's really very fantastic to have all of you join us today. We are streaming live right now on YouTube, LinkedIn, and Facebook. And I'm very excited to tell you that this could also be a very participative session. All you have to do is type in whatever questions you have in the comment section, and we'll be very, very happy to take them up in this session later, for sure. And today we are going to dive into this very important discussion on this topic. Can product managers and software engineers qualify for the EB1A visa? And it's a topic that is especially relevant for highly skilled professionals out there in the tech industry. And of course, I am very, very excited today because we are going to have one of our very special guests back with us, joining us after months, really. I think we met last before summer. So please help me welcome attorney Prashant Dubey once again back here on Immigration and Jobs Talk Show. Prashant, really happy to see you after a real long time, and really good to have you here. Thank you for joining us.
Yeah, no, thank you. Thank you to the Higher IT team for welcoming me back, right? And having me on another episode, another webinar. Thank you, Napasa, Zayed. Thank you for all the technical work you do in the background. I'm sure I'm going to have one technical difficulty at least. Otherwise, it would not be a webinar where I have participated. So if I pivot to my phone, don't be surprised at some point. But glad to be back.
Very glad to have you back with us, Prashant. And so, yes, today's topic, what can folks out there expect from us today?
Yeah. So today, one of the reasons why I think this webinar specifically around the EB1A is highly relevant, right? I know we've done a series of webinars before on this topic specifically, and it was very high level, right? Can folks in IT qualify for the EB1A, for example? And we talked about the EB1A process, application requirements, how people qualify. And I think this is a really good opportunity to start double clicking on very specific profiles, right? So, for example, for today, we're going to be discussing how product managers, how software engineers specifically qualify. And I know behind the scenes we were discussing, doing an episode for like cybersecurity folks, data engineers, that sort of thing. And over the last several months, one of the reasons why I kind of disappeared from these webinars is because this part of my practice has really started to scale. And the reason was pretty straightforward. So since October 2022, EB1As have become a very hot topic, right? Ever since the retrogressions and priority dates happened. And I was working with one or two clients at a time over the last couple of years to help them get their EB1As approved. What happened earlier this year around the May, June timeframe, one of my clients who got his EB1A approved, he works at Meta. He went and posted internally in a Meta forum about his success with our firm, and then things just kind of exploded from there, right? So over the last, I would say 5 or 6 months, I've probably done twice as many EB1As as I did in my first, my last couple of years, where I've noticed this become a trend. Lots of consultations, calls. And so it's a really interesting time, at least for me, and I think the EB1A community, because there's a lot of best practices that I feel like I'm now uncovering as I'm doing this at a much larger scale, and with many, many more types of clients and different profiles and different case studies that I can bring to the table today, right? And of course, there have been some changes as of October in how USCIS is going to be looking at the EB1 criteria, and we can get into that. And then, of course, I know there's a lot of anxiety around, the presidential election and the recent results,
Right.
and we can talk about that too.
I was just coming to that, and I think before we head on to today's topic, maybe you could tell us how Donald Trump being elected the 47th U.S. president is going to affect even this category of visas, and it'll be
Yeah.
great your point of view on this as well, Prashant.
Yeah. So there's a couple things to that. One is just like my personal experience, right? So like the very first EB1A I ever filed was for a dentist. And it was during the height of the Trump administration about 4.5 years ago, right? And he got approved just fine, right? I think when it comes to the next administration, what I saw previously between 2016 and 2020 was that there was impact for EB2 and EB3 candidates, right? Even H1B candidates. Reason being that there are different areas of that process where they can really influence what's happening, right? And what I mean by that is in EB2 and EB3, you have things like the prevailing wage determination, right? So they can slow that down. You have things like the recruitment process, right, which can really come back and hurt you, let's say at the I-140 stage. They have the perm application itself, in which they can increase their audits, right? And those are the types of things that we saw the Trump administration do previously, right? When it comes to EB1As and EB2 NIWs, I think any administration has a very keen interest in keeping the best and brightest people here in the US, right? And if you look at his rhetoric, it is all about, potentially changing rules, regulations as it relates to maybe asylum seekers, people illegally entering the country, right? But when it comes to these merit-based applications or these merit-based benefits like the EB1A, like the EB2 NIW, he really that's not a part of his rhetoric, right? I don't expect there to be a whole lot of impact for my EB1A and EB2 NIW clients, because this is a self-petition, right? These applications go directly to USCIS. You have nothing to do with the Department of Labor, so there's nothing they can influence there. It's just you and the officer and the case you present, in front of them, right? So I'd say from that perspective, I hope people aren't as anxious as maybe they might be coming off for EB1As and EB2 NIWs.
But definitely, I think everyone is anxious, especially immigrants out there, like what's going to happen. Some are really maybe even taking up actions before things get worse for them.
Yeah.
I mean, that's what their thought process is, I guess. So a lot of things are happening. I think people are still processing the whole information, Prashant.
Yeah, and I'm seeing it too, right? Like I've got clients who are like, can you take my case now? And I'm like, the earliest I can take it is at least January, right? Like I'm working with a cohort of people, that sort of thing. And I'm seeing a sense of urgency where people want to try and apply right away. And like our timelines are just not matching up, right? And that's okay. But I am seeing that sense of urgency where people are worried. But I think it might be a little overdone.
For sure. But let's head on to today's topic, and I got some questions prepared. So, Prashant, if you could just tell us, how might product managers and software engineers qualify for the EB1A visa? And this requires evidence for extraordinary ability in their fields, and what impact might Trump's previous stance on merit-based immigration have on their chances?
Yeah, I think that second piece I kind of covered in the first response, right? I think based on his rhetoric, whether it was the previous, from 2016 to 2020, or let's say 2024 or 2025 and, moving forward, I don't see an impact on merit-based applications, right? Especially not EB1As and not EB2NIWs. Again, any administration has a very high interest in keeping the best and brightest here in the US. Now, when it comes to qualifying, right, for the EB1A, for example, for product managers and software engineers, let's take the product manager profile first, right? Product managers are very interesting individuals because they sit at the intersection of IT and business, right? So one advantage that product managers have is that they can very easily and often, do very easily communicate the business outcomes that are driving their projects, right? The KPIs associated with it. What is the organizational impact? What kind of impact is my work having on the industry, right? And when you sit at that intersection, it's really important for at least two of the criteria: critical and leading role for a distinguished organization. Second one is original business contributions, right? Because we want to be able to prove that the work that somebody's doing is important at an organizational level, right? We want to be able to prove that the work that they're doing is innovative and also influential in the industry. So I think for those criteria, right off the bat, product managers are really well situated to satisfy those requirements. I recently had a product manager that I worked with. He's at Meta. He works specifically with networking technologies. Okay. And for him, we argued on 4 criteria: critical and leading role, original business contributions, judging the work of others, and then salary, right? And I often see for product managers, those are the 4 criteria that they are satisfying, that they are hitting, right? Most commonly. There might be others like memberships, awards, authorship, depending on the makeup of the profile. But at a baseline, those are the 4 that I typically see come across my desk, right? And, it's important, I would say, for critical and leading role to raise your projects that you've worked on to an organizational level, right? What was the organizational impact? What was the dollar amount impact? How much cost savings did you achieve? How many manual labor hours did you reduce, for example, right? And then for original business contributions, one of the things I want people to think about is raising it to an industry level. So not only, what you worked on was innovative, but how was it adapted maybe by other organizations, other companies out in the field, right? And for that, one of the best ways to showcase it is expert opinion letters. So recently, one of my new best practices is to kind of urge my clients, go and find 1 or 2 individuals out in the industry who are experts in their field. And an expert can mean many different things to many different USCIS officers. For some officers, an expert is somebody who has a Google Scholar profile with over 1,000 citations. We'll find that individual. They might already be in your network. They might already be in your chain of command. An expert can also be somebody who is a thought leader, right? They pop up frequently in news media for, comments about what is happening in the industry. And what I'm finding is, as my practice has scaled over the last 5 to 6 months, the individuals that, the 1 or 2 individuals that, received an RFE for whom I filed versus the individuals who had comparable profiles, right, that we filed and got approved, that was the difference. Those 1 to 2 letters of recommendations from renowned industry experts is what pushed those approvals over the edge, even though the profiles were similar, right? Didn't matter if it was a product manager, didn't matter if it was a software engineer, but that is something I'm seeing is really helping to set people apart, is having those strong letters of recommendations for your original business contributions criteria. For software engineers, it's very similar, right? We still need to prove that your work is critical at an organizational level. We still need to prove that the work you're doing and it's innovative, right? And you can do that in separate ways. Some clients of mine, they have patents. Some of them have papers, research papers or conference papers associated with those projects. Some of them have open source work, right, that they can point to and say, hey, the work I've done is laying the foundation for other developers to build on top of it, right? I sometimes have clients who come in who have done code reviews, right? Technical reviews out in the industry. I've had clients who will maybe go to freecodecamp.org and they will write blog posts about best practices, for example, in C++ programming, right? So there's different ways that you can come at the criteria that are kind of outside the box of just your traditional research academic PhD background. So that was kind of the TLDR of that that answer.
Thank you so much, Prashant. I mean, that was pretty detailed and what we really need. Thank you so much for walking us through all these highlights that we really need to keep in mind. And at this moment, Prashant, we've got some friends who've joined us and who are commenting. So I'll just quickly say hi to them. It's My Channel says, good morning, Prashant. And then we have Kavya's questions. We have Amarjeet. Folks out there, please stay with us. We are going to touch up on your questions very, very soon. And yeah, thank you so much. Okay, Amarjeet. No, okay. Let's head on with our questions. I have one more question for you, Prashant, and that is, what level of professional achievement or recognition is generally required for software engineers and product managers to be considered for EB1A eligibility?
Yeah. And this is kind of a sliding scales question, right? And what I mean by that is in terms of what qualifies somebody from a recognition perspective can mean many, many different things, right? Recognition can be somebody that has multiple papers and research articles published. It can be somebody that has multiple conference papers, multiple blog posts. It can be somebody that has a very robust GitHub repository, for example, somebody that is very much involved in the Android developer community, for example. And recognition can also be thought leadership. And I like to call thought leadership basically like your speaking engagements, right? I do have clients who are invited to speak to DroidCon, right? Or they are invited to speak to at AWS reInvent, these really big industry conferences. Cisco Live is another one of them, right? So recognition can take many different forms. Recognition can also be, how is your work being adapted in the industry? So if you don't have patents, that's fine. But if you have somebody that is talking about how they've taken, your technical work learnings from you and adapted it in their own workplace or in their own organization, all of a sudden that becomes very impactful, right? But I always recommend, like, if you want to get recognition in the field, think about in your industry, what podcasts can you be a part of, right? And for product managers, there are multiple podcasts. There's some at the product school. There's one called Exponent. There's a podcast that's done by an individual over at University of Washington. You can participate in those sorts of avenues, if you're a product manager, to really get your thought leadership and your recognition out there, right? And that will help you from a final merits perspective. If you're typically, what I see my developers, what they've done is they're typically speaking at these industry conferences or even academic conferences about the work that they've done, right? And that will help you build your thought leadership, right? And the type of conference you present at is going to depend on your profile. For example, I had an Android developer who presented at DroidCon, right? I had a machine learning engineering manager from Pinterest who presented at AWS reInvent because he built their machine learning platform in partnership with AWS, right? So it made sense that he was presenting there. In addition to that, he had about 3 or 4 other conference speaking engagements within his industry, within his specific line of work, right? So this is going to be very relevant and kind of particular to the makeup of what your EB1A profile is and the story that you're trying to tell, right? It doesn't make sense to go and present in a conference that's about graphics technologies, for example, if you don't work in that space, right? Or if you're a data engineering doing AI/ML work on recommendation systems, right? Has to be very relevant. You have to find those opportunities that make sense for your story.
Definitely, without any doubt. Thank you so much, Prashant. And, I would really like to take it's my channel's question for now. So let's go for it. Two design patents, one IEEE paper publication, reviewed or judged three technical papers. Can I still qualify in the expert category, or what is your suggestion to make this profile more stronger? And what are
Yeah.
the areas that I can add?
Yeah. So I think with the design patents, right, we would need to learn, hey, do you have any citations associated with them, right? That's going to be important. Same with your IEEE paper. If you have two patents and one paper, but you have 50, 60, 70, 100 citations, that shows that it's very impactful work, right? So your next step should be the people that have cited your work, cited your patent, cited your papers, identify the individuals that are, really renowned. And what I mean by that, are they academic experts? Is somebody there who has, cited your paper that has over 1,000 citations on Google Scholar, or has a lot of media attention, for example, for the work he's done? And can you potentially get a letter of recommendation signed from that individual, right? I think reviewing and judging three technical papers, that's fine. I would always urge you to do more, right? Because, I'm seeing my clients and they're reviewing 30, 40, 50 conference papers, right? So if you think about it, that is who you're going up against, right? So I would say do as much as you can when it comes to the technical review work in as many prestigious conferences as possible. And you can very easily find the prestige of a conference by going to research.com, right? And searching, for example, within the field of computer science, what the ranking is. If they're not even on research.com, you should seriously consider whether it's worth pursuing that opportunity. In addition to that, one more thing I want to mention, don't be disheartened by the fact that you only have a couple of patents, right? Because I had a CRM engineer from Salesforce, one patent, 4 citations. That was it, right? But what we went and did was we drafted a letter of recommendation from an individual that cited to his patent, that talked about how they took inspiration from his patent and the work that he did, right? So if you can get a letter of recommendation like that, obviously the patent proves that your work is original. We also need to prove that it's influential, right? And so that letter helped us show that his one patent was influential in the industry, and he did end up getting the EB1A approval. So not somebody that had a robust patent or research background, but somebody who was able to prove that the one thing he did in the way of a patent was influential. Somebody did take inspiration from it, right? So just something to think about in terms of how you build your profile moving forward.
Yes, very much. Thank you so much for highlighting that, Prashant. And I think it's very important to make your profile stronger and as attractive as possible, I think. So thank you
Yeah.
for that tip, Prashant. And thank you, It's My Channel, for participating. Please keep commenting if you have any further questions. And now I think we should take up another question, and this is from Kavya. Kavya is saying, my contributions are mostly collaborative, working as part of a team rather than leading solo efforts. Can I still qualify for EB1A? And does the process amount for team-based achievements, or do I need to show individual recognition? And there's
Yeah,
another
good
question,
question.
but okay, we'll take that later.
Yeah, good question. So no one is a one-man army, right? Like none of my clients have ever operated in a vacuum, right? Like you're either a software developer or a data engineer or a cybersecurity person or a product manager, but you're not everything, right? And so you have to keep in mind that what we tried to highlight in an EB1A is your specific contributions, your specific technical tasks, your specific original contributions or innovative contributions, right? If you're an author on a paper, you might be a co-author, right? But that doesn't mean that you didn't contribute to it just because you were in a team-based or collaborative environment. 99% of the time, that is absolutely the case, right? And that's okay. But what we like to extract by way of letters of recommendations is your specific contribution to that project, right? And my job is to make it seem like you did everything, right? As your attorney, as somebody that's going to represent you, right? I'm not here to talk about what your team did, right? I'm here to talk about the impact you had, your specific technical contributions, and then connecting it to an organizational level impact, connecting it to any news publications, any media, anything of that sort that has, like the project you've worked on, if it's gotten that attention, then we leverage those as exhibits, right? And I'll give you an example here. I work with many clients from Meta's AR/VR team, right? Meta's Reality Labs team. You can find a lot of news publications out there about how, Mark Zuckerberg has basically created like a 10-year roadmap or a 5-year roadmap for the Reality Labs team, how it's important to Meta's organizational goals and strategies, right? So automatically we know that if you're working on a project for AR/VR at Meta, it is organizationally important. It is important at a CEO level, right? And we've got news publications to prove that. If you are working specifically, let's say, within the wearable devices vertical of Reality Labs, right? I've had a client who does that. There's news publications out there, right, about the innovative nature of the wearable devices strategy that Meta has, right? So we automatically, can connect it to something that's newsworthy, talking about the fact that your work is innovative and also influential because it's going to impact the millions of customers that are buying the Quest headsets, right? So again, none of this happens in vacuum, right? But our job, my job, is to extract the specific details related to your specific contributions, connect them to those higher level organizational goals, connect them to those news publications that are talking about how this work is important at an industry level, right? So that's what I would say. Anybody can really qualify for the EB1A. We just need to highlight your specific contributions.
Right. And what about this last part of the question that she had, that Kavya had? How can I highlight my role and impact within a collaborative setting? Any tips?
Yeah. So what I do is I always send my clients a worksheet, right? So like we get on a consultation call, I learn a little bit about you. I either say you're ready to move forward or you have more work to do, right? I'm going to be very transparent about that because the last thing I want is a bad customer experience, right? I don't want you to think you qualify for something you very clearly don't, right? And in that worksheet, I extract those details, right? What were your specific contributions? What were your specific technical tasks? What was the organizational outcome that you were trying to achieve? And we draft letters of recommendations around that, right? Letters of recommendations can come from your managers. They can come from members of cross-functional teams. They can come from peers. If you work with end clients, right? So for example, I've had some clients who are management consultants, let's say at one of the big SI firms. You might get a letter from one of your end clients talking about the work that you've done and how it was impactful, right? So that's how we come at it. In addition to that, I find that my clients are very good at leveraging their performance reviews, right? So if we are talking about a specific project that you've worked on, more often than not, your work on that project is also being captured in a performance review. So we can add that as a layer of an exhibit stating, hey, here's this LOR saying what this person specifically did, how they are furthering these organizational or industry-wide outcomes. And oh, by the way, here's a performance review talking about, in addition, like all the stellar work that they did for this project, right? That becomes another objective piece of evidence.
Thank you so much, Prashant, for the detailed explanation for Kavya. And Kavya, I hope you've gotten all your answers. And we have It's My Channel back again saying, perfect. Thank you so much. And we have Dan Nandan saying his explanation is very clear and sounds like a radio personality for sure. I mean, really, Prashant, for sure. Very, very clear in how you explain. And now we have another question from It's My Channel asking, I would like to ask one more question on the memberships. Do you have any suggestions other than the IEEE or BCS?
Yeah. So here's the thing about memberships. If you don't have a research background, in the sense that if you're not doing journal papers, conference papers, you're not doing blog posts, you're not reviewing conference papers or journal publications, IEEE really doesn't make sense, right? And neither does IET. IET is another technology kind of research organization. And both IEEE and IET only make sense for people if they have that research profile. Otherwise, it just looks like a check the box exercise. And when I see that with a client, I tell them, like, I'm not going to use this as a membership. You need to go do some review work, right? You need to go do some authorship. And that way your membership is going to look good, right? In terms of professional organizations, BCS is obviously the one that I see come across my desk most often. There are others, Royal Society of Arts being one of them. There's one called Sigma G or Sigma Chi, right? XI, that I also see my clients leverage. What I'll say is this: memberships is oftentimes one of the most difficult criteria. Membership and awards is two of the most difficult criteria to satisfy, right? So if you're going after it, just make sure that the organization you're going after fits your profile. If you don't have a research profile, don't do IEEE, don't do IET. If you have a professional profile and BCS might be taking too long, go and explore the Sigma Chi, go and explore, for example, Forbes Technology Council or Royal Society of Arts. That those will help you satisfy the membership requirements. And then high level, one of the things I want to say about memberships is USCIS really cares about the organization's bylaws. Okay. Bylaws are extremely important. Don't go and join an organization that has not memorialized their process into some sort of governance document or some form of bylaws that says this is the criteria that you need to satisfy the membership, right? These are the outstanding contributions we require of our members. In addition, take it one step further. Make sure the bylaws also discuss who qualifies to make those decisions about membership, right? That's very important. Some USCIS officers like to see those details. Where in the bylaws does it say this is the selection criteria? Where in the bylaws does it say these are the people that are going to be making those decisions, and these are the qualifications required for the membership committee, so to speak? And then the third one, what are the qualifications of that membership committee, right? So that information also then needs to be publicly available. So you want to be very careful with memberships because there's many pitfalls there, right? It's not just enough to go and get it. You need to be able to support your membership with bylaws and governance documents and all of those different pieces of information.
Thank you so much, Prashant, for taking that up. And we have some more questions. Let's take up Nirvana's question now. This is next on YouTube. Nirvana is asking, when talking of high salary criteria, how much we are talking of? Does officers go with what is mentioned in the LCA?
Okay. Level 1 to 4 wage means nothing to me in EB1A, and I think it means nothing to a USCIS officer, right? I have had clients who will try to argue with me that you should, include my salary criteria as criteria number 6 or 7, because it's a level 3 or a level 4 wage. It means nothing, right? There's no point of reference, right? And what I mean by that is there is better data out there. Bureau of Labor Statistics specifically talks about what the 90th percentile of software developers product managers who can be qualified in the SOC code of marketing managers or IT project managers, depending on your role. Data scientists, for example, all of the statistics are available on government wage databases, right? So Bureau of Labor Statistics, Career One Stop, ONET. I always start there. If you are not in the 90th percentile in one of those three, salary is a no-go, right? Because on the USCIS policy manual for salary, those are the three that they list right off the bat. Like, this is the starting point, right? In addition to that, we provide commercial wage data. Glassdoor, Indeed, ZipRecruiter, Levels, PayScale, Salary.com, right? Those further substantiate the fact that from a commercial perspective, this person's in the top 10%, right? And they also have those sorts of point of references like top 10%. ZipRecruiter actually takes it a step further and can even get as granular, I think, as like top 3%, which is great. Now, the third layer of exhibits we provide for salary, and this is something I had to learn over the last 5 to 6 months, because I was only doing that level 1 and level 2, which was the government wage data, the commercial wage data. I've now turned it up a notch with the level 3 wage data in the sense, and I use level 3 very interchangeably here. I don't mean level 3 as like the LCA, but I use level 3 as in a third tier of exhibits that we're providing is related to professional organizations, right? So, for example, there are staffing agencies out there that are well reputed. Robert Half, for example, ranked as a top 5 staffing agency by Forbes. Mondo, ranked as one of the best IT search firms in the country. These organizations, they provide wage data based on their placements, right? So now I've been starting to provide professional organizational wage data as well to further substantiate the salary criteria. I don't care what's on the LCA, right? Like, baseline, you got to start with the government wage database first.
Thank you so much for that, Prashant. And yeah, and Nirvana is saying one more. I see a lot of PR agencies. Is it lawful to take help from them?
I laugh at this one because don't work with the PR agencies. I apologize to all the PR agencies out there, but the problem is they will get you posted on USA Today. They will get you posted on Tech Times. They'll get you posted on Tech Bullion, right? MSN, Benzinga, et cetera, et cetera. The problem is, after every article or at the beginning of every article, they put a disclaimer that's there that says, this is not the opinion of USA Today. And that's a problem, right? Because all of a sudden, we're arguing on the publications about you criteria, and it automatically gets discredited by the fact that USA Today is saying, hey, I didn't put this out into the world, right? Like somebody else did. You're going to have a world of a problem, very incremental value, right? So do not pay PR agencies to get you posted somewhere because it will backfire, right? Like, those disclaimers are only going to hurt you, and they're everywhere, right? So save your money, spend your time elsewhere.
Okay. And what about, what he asked earlier? How much total criteria should be enough? Well, that is a question. And does too many of them pose threat for RFE as well?
Yeah. So, here's my best practice, right? I like to go in with a minimum of 4, right? I never go in with just 3. I learned pretty early on going in with just 3 puts you at a disadvantage, because if USCIS RFE is one of them, right, you don't have much background, right? If you go in with at least 4, and let's say 3 of them are very strong, right, and one of them is 50-50 or a little weak, you still have a good chance of approval, right? 4 and above, your chances of approval, from what I've seen, go up significantly, right? In terms of having too many criteria, what I would say is, if you can comfortably argue on 6 or 7 because you qualify for them, do it, right? If you can put forth a reasonable argument for 6 or 7 criteria, that's totally, but don't try to do something underhanded, right? So for example, don't try to make criteria number 6 or 7 salary when the government wage database clearly says you're not in the 90th percentile, right? Don't try to slip something past an officer from a criteria perspective, which is going to discredit the rest of your application, because then they're going to start thinking, oh, they're trying to convince me of something that like very clearly they don't qualify for. What else are they trying to convince me of? Right. So I think the most I ever argued on was 7. And I even told the client, like, look, 2 of them are pretty weak, 5 of them are very strong, right? And I think those are the 5 that are going to carry you at the end of the day, right? And they probably did, because he ended up getting the approval. And you don't know which criteria you end up satisfying when it's an approval, but you know, I know pretty early on in terms of like which one's actually gonna resonate with USCIS and which ones are not, right? Argue for as many as you possibly can, as long as it's within reason, right? And as long as you can put forth a good argument.
Mm-hmm. Right. Thank you so much, Prashant. And those were really insightful tips and advices. Also, thank you so much, Nirvana. I hope that you've gotten most of all your questions answered. And if you have any more doubt, you can keep commenting. Well, It's My Channel also said that that's a long list, but thank you, Prashant, he says. Anyway, I have a few more questions, Prashant. I think I'll share my screen for now so that we can take them up. I was telling you about some of our Facebook groups, so this will be easier. All right. So let's go with this first one. This is an anonymous participant asking, has anyone here worked with, I'm looking for filing my EB1A petition and would like some thought. Okay, not this, this one. Is the interview backlog different for EB2NIW and EB1A? Does anyone have any idea of which dates are scheduled for EB1A interviews at the Islamabad Embassy or Abu Dhabi Embassy?
Yeah. So what I can say, like at least speaking from the perspective for individuals within the US, because that tends to be 99% of my clientele, you don't have an interview for the EB1A or the EB2NIW, the EB2 or EB3, right? The only time I've ever seen employment-based petitions get an interview is if, let's say, somebody changes a job, for example, right? And the USCIS officer would like to verify that they are continuing to, let's say, work for that new employer, right? But none of my EB1A or EB2NIW clients have ever gotten an interview from within the US. Now, if you do consular processing and you're doing your interview from abroad, yes, the entire process of consular processing involves a visa interview with a visa officer, right? So it's slightly harder, I would say, when you're doing it from abroad. But in terms of specific timelines for those 2 embassies, would not be able to tell you.
All right. Thank you, Prashant, for taking that up. Now I have this next question. This is, please help on where to publish articles for EB1A, or let me know which journals are eligible. Thanks in advance.
Yeah. So this is dependent on a couple different things. One is just your overall profile, right? Are you a software developer that's working within the Android ecosystem? Are you a data engineer working with AI/ML, right? Are you a developer working with AR/VR technologies, right? And graphics technologies? Are you a UX designer, right? Because the answer is going to change with each of those profiles, right? I recently had a data engineer who got approved for the EB1A just this week, actually. The articles he came to me with was published in an electrical engineering journal. And when we were working on his analysis and all of his exhibits, he called it out. He said, hey, you missed this article. And I was like, I'm not going to include it. It's an electrical engineering journal, right? It has nothing to do with data engineering and the work you've done, right? and it breaks the continuity of your story. So what I would suggest is if you go to the IEEE website, right? IEEE has a list of conferences that they sponsor. Research those conferences, right? Type in the conference name, type in the word ranking. Research.com will tell you its ranking if it's ranked. Those are the types of conferences or journals that you want to be publishing in, right? The ones that are known, they're reputable, they have a peer review process, for example, right? That is what I would suggest. Now, let's say you feel the journal writing process, the conference paper writing process is very tedious. I've had clients tell me that. Totally fine. There are other avenues out there to satisfy the authorship criteria. For example, freecodecamp.org. Free Code Camp is a nonprofit organization, right? And they teach people how to code for free. And in order to even qualify to be a blog writer on Free Code Camp, you have to go through a vetting process. I think they only accept 30% of their applications. But the great thing about it is if you go to their LinkedIn page, 60, 70,000 people claim that they learned coding from Free Code Camp. And they will also help promote your blog posts, right? And your technical articles. That is another way to satisfy the authorship criteria, right? Doesn't have to be journals, doesn't have to be conference papers. You can get creative with it. I've had clients from Pinterest, from Meta, from Amazon, where these organizations have channels to publish technical blogs, right? And I've had clients participate in those technical blog process, and they're able to show me that, hey, these blogs are getting viewership, right? They reach out to those marketing teams internally, they find the viewership statistics, and we provide that as an exhibit to show that, hey, this person is authoring scholarly articles. It's just not in the traditional sense, right? But it is for individuals that might be, the intended audience is a data engineer, cybersecurity professional, whatever that might be, right? Another way to think about it is trade publications. So I have had folks in cybersecurity who do co-authorship with the Cloud Security Alliance, for example, right? So there's different ways to think than your traditional, journal papers, conference papers. But if that's the route you go, just be sure that those conference papers, those journals, those conferences and journals are like reputed, they're ranked on like research.com, for example.
Awesome. Thank you so much, Prashant, for giving us that insight. And now we have Vibhor asking, my company is 1 year old in Washington. Can I apply for L1A visa via road through Canada and I'm a Canadian citizen? I think the answer is yes. Once I get L1A approved, question is, can EB1C be processed quickly by paying money? And can I get green card within a year? Do you want to take this up? It's not EB1A.
I can answer the question totally fine. So with regards to EB1C and the EB1 categories, right? One of the things you want to keep in mind is the priority dates right now, I believe, are in 2022, right? So if you are coming on an L1A, right, as an executive, you can absolutely apply for your EB1C 1 year, let's say, after you enter the country, and you continue to maintain your managerial, executive capacity and executive duties, right? Really whenever your company is ready to apply for it. So as long as in the previous 3 years, for one of those years you were employed abroad, let's say in Canada, you come back as an executive to the US, your company can apply for an EB1C for you. Okay. Now, if your priority date, let's say, is January 1st, 2025, just hypothetically speaking, right? If it's January 1st, 2025, in the EB1 category, you are probably not going to be eligible to get your green card within 1 year because your priority date is not, 2022 and before that, right? Or whatever it might be in the future. Chances are, if you get a priority date that is 2025, for example, you might be waiting 2 or 3 years before you can even apply for your 485 applications and get your green card, right? It's just how the priority dates work. In EB1 category right now, they are not current.
Thank you so much, Prashant, for taking that up. And I have one more question from one of our previous shows with you, EB1A, building a profile to qualify for EB1A category. And we had Arjun asking, saying that it was a very good session, and he had one question. How about the applicant had suitable criteria for EB1A 15 years ago, but now he is into different job sector and current situation is not suitable for the criteria? Can this still be a valid case for EB1A petition?
Yeah. So the thing about it is USCIS wants to see it over a sustained period of time, right? If you did something 15 years ago, let's say a whole lot of research, right? A whole lot of reviewing the work of others, but then there's a 15-year gap. One of the things that some very hardline USCIS officers like to see is that the work you did was over a sustained period of time, right? So critical and leading role over a sustained period of time, judging the work of others over a sustained period of time. If there's a significant gap like that of 15 years, I think that's going to be challenging for an EB1A, right? Unless, your authorship and judging the work of others criteria, which I'm just going to assume happened 15 years ago, right? For purposes of this question, if you have 3 or 4 other strong criteria and those 2 are kind of weak because they happened a decade and a half ago, I think you'll probably be okay. But if you only have 3 or 4 criteria and those are 2 of them, you're going to have a problem, right? I don't think that EB1A application would get approved.
Thank you so much, Prashant, for taking that up. And we had more questions, but I think we're good for now. I think I've taken up most of them. So we'll move back to our questions, Prashant, now. And I have this next question for you. So my next question is, what role does professional networking and peer testimonials play in an EB1A application? And are there any best practices for product managers and software engineers to secure strong endorsements? You've already highlighted some of how these testimonials or recommendations play a very important role. So if you could just tell us more about the endorsement part.
Yeah, absolutely. So I think there's a few different ways, right? So one way that I use endorsements is sometimes my clients have LinkedIn recommendations, right? 10, 15, 20 LinkedIn recommendations. And I leverage that from a final merits perspective, right? So I'll give you an example. I have had clients who have participated in those thought leadership engagements, right? So they've been invited to speak at conferences, or maybe they've been invited to speak on podcasts. In addition to that, I highlight the fact that, hey, not only are they getting this industry recognition through these speaking engagements, but they're also recognized by their peers. Look at these LinkedIn recommendations accumulated, right? So I would say if you don't already have them, start thinking about, asking people for LinkedIn recommendations, right? Specifically related to the work you've done, specifically related to the capacity in which you interacted with them, right? It can only help you, certainly will not hurt you, okay? Another thing is, I would say, folks tend to burn bridges very quickly, right? So you leave a job, you kind of forget about your previous manager, you forget about your previous colleagues, and that's natural. It happens. One of the best individuals, one of my best clients that I've seen really do this well, he built relationships over the last decade. And he was able to go back to his manager, a couple of colleagues from his time when he was an intern at Meta from 2013, when Meta was called Facebook, right? He was able to go back to that time and get letters of recommendations from people from 2013. And it's because his relationship building and maintaining skills were just exceptional, right? So you want to make sure that you are doing them so that when the time is right, when the time comes, people that you have networked with, the people that you have worked with are willing to sign off on those letter of recommendations for you, as opposed to saying, like, why are you coming back to me 10 years later, right? Build and maintain relationships, right? If there are think tanks, if there are organizations in your industry that attract the type of professional you are, get involved, volunteer, build those relationships, make sure they get to know you and you get to know them, right? Because at the end of the day, if you can build one or two of those relationships like that from renowned experts in the field, right? Those people that have the media publication, the media attention, the people that have the Google Scholar profiles that are very reputable and very much recognized, those become very powerful LORs for you. So build relationships, maintain relationships, at least for individuals that you identify can help you with your EB1A application later on.
For sure. Thank you so much, Prashant. And do you have any success stories or anything along these lines that you would like to share with us before we leave today?
Yeah. So I send out a monthly newsletter, and in that newsletter, I like to highlight. Nowadays, it's basically just all taken up by EB1A. But I like to highlight in those newsletters, some of the success stories that I've been seeing. And of course, it encourages other people, right? They see other people's profiles who are going through the EB1A process and they become encouraged themselves, for example, right? So I will share a couple of those success stories from this month. So this month, we've gotten 3 new approvals. Those have not gone out in my November newsletter because my newsletter goes out at the end of the month. One of them is a data engineer, right? And one of the things that he did in terms of satisfying criteria for awards, he had the Business Mint Awards and the Global Recognition Awards. I don't think that's one of the reasons why he got his EB1A, though. We also argued on critical and leading role. So he had implemented certain projects, for example, in the state of California, as it related to their electric metering system and modernizing that system, right? So not only was that project important for the organization that he worked for and that he was contracted out for, but it was also innovative and influential, right? Because it was impacting millions of customers in California. Mm-hmm. He had judging the work of others, right? So he had done conference paper reviews, journal reviews, in data engineering related conferences and publications. He also had authorship, right? So he had worked on papers that had accumulated over 170 citations over the last couple of years, right? Salary was not one that we argued on for him, right? So based on that profile, he got approved. I had a client from Meta who got approved this month. He is a AI ML engineer, and this individual was very notable in the sense that he had about 10 patents, I believe, 10 or 13 patents that had been cited over 100 times in the industry. He also had a couple of conference papers that kind of memorialized the work he was doing at Meta. And so for him, critical and leading role, yes, right? We were able to prove that the work he was doing was important at an organizational level, right? Because if you think about it, everything within Meta, is the engine behind it is recommendation systems. So the next reel that you see, the next post that you see, it's all recommendation systems. His patents helped with original business contributions. The letters of recommendations that we drafted for him were from professionals in the industry that had over 1,000 citations each, right? And we had 3 or 4 letters like that. He had salary, he had judging the work of others, he had authorship because of those conference papers, and also original scholarly contributions because those conference papers were well cited. So we argued on about 5 criteria for him, and he also went through the process just fine, right? So I think, to kind of like tie a neat little bow on it, you don't have to have a PhD. You don't need to be an academic to get an EB1A, right? And that individual who I just told you the story about, who had like the 10 or 13 patents, In our consultation call, he was like, I don't think I qualify. And I was like, no, I think you do. Right? Like, I think you've been told that this is what a certain profile should be for the EB1A. I think you've been told that 100 citations don't qualify, right? But in fact, it does if we, build everything carefully, if we demonstrate your industry impact carefully, we demonstrate your organizational impact carefully, I think you're going to get this. And he did, right? So there's a lot of misconceptions out there about who qualifies for the EB1A, right? And it's really important to know that anyone can build a profile towards an EB1A. Might take you a little bit of time, but you can do it.
Thank you so much, Prashant. That was really very insightful, and thank you for sharing your. I mean, on the other hand, it's also your success story. Your client success story is also your success story. So
Right.
definitely, it was really good to hear about that. So yeah, lovely having you, by the way. It's been a while, and it was such a great and insightful discussion today we had on the topic can productive managers and software engineers qualify for EB1A? And it was great having your tips today. Prashant, do you have any end note before we wrap up? I mean, it was already great, but anything else you want to leave our audience with?
Yeah. I would say, my parting thought is, or thoughts. One, Nipasa, I told you we would only get through like 4 of our questions because I take 5
It's
minutes
true.
to answer like each of them. But I'm glad we were able to answer more questions from the audience. I think the audience definitely found value from that. So thank you, audience, for asking. Thank you to the higher IT team, right, for hosting me and making this a possibility. And also for anybody out there that's looking to explore the EB1A. I don't care if it's you coming to me or to another attorney, right? But don't be discouraged by the fact that you don't have a certain background or you don't have a PhD or you're not an academic, you're not a researcher, because I would say 50% of my clients are not, and they are still getting the EB1A. It just takes some time. It just takes the appropriate amount of preparation. And that's okay because the EB1A, it's a marathon and it's not a race, right? You are going to save yourself decades of GC processing time if you can qualify yourself for this category.
For sure. Thank you so much, Prashant, really. And we highly recommend getting in touch with a qualified immigration attorney, and why not attorney Prashant Dubey as well. And you've got his email address, and his address is sorry. How to subscribe for the newsletter is there a URL? It's my channel is asking before we go. Yes.
No, but that gives me an idea. I think I should automate the subscription process because right now I just manually enter everybody's email into the newsletter, and it like builds up my audience. So that gave me a great idea. Just email me, please, right? And
Yes.
I will make sure you get my November newsletter and all my newsletters moving forward.
Perfect. And you can email Prashant Dubey. His email address is info@dubeylawoffice.com. You can check out the spelling on the screen and note it down. Thank you so much, Prashant. Really lovely. And since we couldn't cover up most of our questions, we would really love you to join again. And even if not EB1A, we can have many other topics to discuss. If that'll be fine. I'm hoping to have you visit us regularly again.
Yes, that's the idea. Thank you for having me.
Perfect. Thank you so much. Have a great day. Have a great weekend, Prashant.
All right, see you. Bye.
Bye-bye. Thank you, friends. Thank you so much. And before we close, just a quick reminder that if you found today's episode helpful, please do not forget to like, share, and also subscribe to us. We are Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, Twitter. We're also there on Instagram. Check us out, and it'll be really lovely to have you join us. And your support helps us bring more expert discussions like these. So hit that bell icon as well so that whenever we have webinars like these, you are notified and you can join us. And in case you have more questions on this topic, You can keep commenting because we would love to get back to you. And of course, stay tuned to our channel, Immigration and Jobs Talk Show, because we have more webinars coming up today. In fact, in just an hour. And also at 4 p.m., we have Daily Immigration Dose, which I join with my co-host, Samriddhi, and it's going to be a great discussion today as well. We just started yesterday. I hope you enjoyed it, and I hope to see you later. So thank you so much for joining us today. Bye-bye for now. It's Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
And because now that you have mentioned Trump, I wouldn't want to miss this chance.
It's fanciful thinking, like much of Trump's diatribes these days.
Until they are removed out of our country and back to the country from which they came.
DHS has a lot of room to maneuver within that space. Was guided by a case called Chevron, and the Chevron case said if the statute is clear, the government has to follow the clear language of the statute. H4s are stealing U.S. worker jobs. Now, they lost, and it's not surprising to anybody who understands administrative law why they lost.
Hello and welcome to another compelling episode of the Immigration and Jobs Talk Show. I am Rajni Bharara, your host. And before I move ahead, I would quickly like to read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to another compelling episode of Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and today we are diving into a subject that could reshape the landscape for H1B visa holders and their families in the United States. If you or someone you know is navigating the complexities of US immigration, especially within the tech sector or other high-skilled industries, this episode is something that you won't want to miss. Recently, the US Court of Appeals made a groundbreaking ruling that upholds the right of H1B visa holders' spouses to work in the United States, a decision that has garnered widespread attention and sparked significant discussion. But what does this ruling truly mean for H1B families, American workers, and the broader immigration landscape? To help us unpack these crucial questions, we are thrilled to have with us today one of the foremost experts in immigration litigation, Jonathan Wasden. Jonathan has been at the forefront of landmark cases that have shaped the future of US immigration policy, particularly around H1B visas. We'll be exploring not only the implications of this recent ruling, but also diving into the broader context of the H1B litigation and how his firm is leading the charge in defending the rights of visa holders and their families. So without any further ado, let's welcome Jonathan Wasden to Immigration and Jobs Talk Show. Okay, so John, welcome to the show. We are again thrilled to have you back with us today. So how are you doing?
Good. How are you doing?
I'm doing well, fine too. Thank you so much for asking. So, John, now, I would directly like to jump into the questions. And firstly, I would like to know the basic understanding of the ruling. So, my very first question to you is, can you briefly explain the significance of the recent US Court of Appeals ruling that upheld the right of H1B visa holders' spouses to work in the United States? What do you have to say?
Yeah, so that case was brought by a rabidly anti-immigration group. And it was premised on the idea that H4s are stealing US worker jobs. Now, they lost, and it's not surprising to anybody who understands administrative law why they lost. The structure of the Immigration and Nationality Act gives a blank check to DHS to determine which aliens, as the term that it uses, are eligible for employment authorization. And because that language is so broadly drafted, DHS has a lot of room to maneuver within that space. And the structure in place at the time was guided by a case called Chevron. And the Chevron case said, if the statute is clear, the government has to follow the clear language of the statute. If the statute is unambiguous or doesn't anticipate all the issues, or is ambiguous rather, and doesn't anticipate all of the issues, then the agency's reasonable interpretation of the statute is going to be binding. And in this case, the statute was wide open. It didn't explicitly say H4s, but it gave DHS wide discretion to grant the employment authorization to various people. And the court rightly said, it's not unreasonable to say that H4s can work, especially in light of the fact that just about in every other industrialized country in the world, when you get an employment-based visa, your spouse automatically gets the right to work. And so it wasn't unreasonable in the court's view for DHS to come up with this regulation allowing H4s to work.
Thank you so much for answering the question, John. And John, how does this ruling fit into the broader context of US immigration law? And how has there been a precedent for similar cases?
So I think it actually built on a prior precedent that dealt with OPT and CPT authorization. The same group tried to attack the ability of students to work during their post-graduation or educational visa. So, when you look at that, those are dealing with the almost identical issue, which is what is DHS's power to grant authorization for employment? And it's pretty broad. They have a lot of authority to pick and choose who they want to give employment authorization to. In terms of its overall impact on immigration law, probably not that much, because as you look at immigration law, each individual visa category and each individual benefit category has its own statutory language. And the broader that language is drafted, the more power the government's going to have to make rules and regulations to fill in gaps. The more in-depth Congress legislates on an issue, the less freedom that the agency is going to have to create regulations. So, if you look at the H1B program in particular, the statute governing the H1B, there's two different provisions in the code. It's this section that's delegated to DHS is very general and very brief and just says that they determine specialty occupation. Then the meat of that H1B statute is actually in a different section that goes to the Department of Labor. And the Department of Labor's authorities and the rules for the H1B program are really in that section. And they're expansively drafted out and they're very carefully thought out. And every permutation has been considered in those statutory sections. And so, the government's ability to make rules under that section are severely limited because Congress has covered so many of the bases. So I guess the takeaway is in a visa category, say like an L1 or an EB1C, where the law is very vague, the agency is going to have a lot of discretion on how they determine the outcome of a particular case or a regulation. The more specific the statute is, the less latitude they're going to be given.
And also, I would like to know, John, given your extensive experience in immigration litigation, particularly with H1B cases, how do you see this ruling impacting the strategies and defenses you may employ in future cases?
So again, this case was decided under the old Chevron structure. And Chevron was a case that said, if a statute is ambiguous, the government's reasonable interpretation must be deferred to by the courts. That's been done away with now, and now the court is given the authority to determine on its own, without deference to the government, whether or not a regulation or a final agency action complies with the statute. and whether or not it's reasonable. So the whole landscape of administrative law has been altered as a result of that new decision called Loper-Bright. I think this case, the Save Jobs case, would have been decided the same way, regardless of if it was Chevron or Loper-Bright, because the statute very clearly gives DHS a wide variety with no limitations on who can work. And I don't really see any court ruling otherwise, regardless of the analytical framework that they're employing. So, that case would have turned out the same. So in future cases, it remains to be seen how Loper-Bright is going to impact us. I think it's going to, the court and the judge that has the case is going to matter a whole lot more under Loper-Bright than it did ever before under Chevron, because it's the meaning of the law is in the eye of the beholder in each case. And right now, that's up to each individual district court judge in the country that has a case land on their desk. So it'll be interesting to watch it develop, because I think there's the very high likelihood that different courts around the country are going to have different answers to the same questions. And how they resolve those differences is going to be fascinating to watch. And it's going to end up, again, with a new Supreme Court decision explaining how to do administrative law.
Thank you again, John, for answering this very important question. Now, I would like to talk about a little bit about impact on the technology sector. So, major tech companies have strongly supported the rule allowing the H1B spouses to work, right? So, how critical is this ruling for tech giants like Google, Amazon, and Microsoft?
Yeah, so for those companies, I think the tech industry in general is benefited, but also the medical industries and education are also benefiting from the H4 right now. There's a crazy number of doctors, dentists, nurses, professors that are all working on the H4 right now, not just in tech companies. So I think the economy overall benefits greatly from the H4. The interesting thing to me is the argument against the H4 is that it's taking US workers' jobs. The H4 has no restrictions on it, right? You can work at McDonald's if you want to, or you can work as the CEO of Apple if you wanted to, theoretically. And so without those restrictions and without all the rules governing wages that H1Bs have, what we see is oftentimes the H4s are making far more in salary because they can negotiate on their own than their H1 spouses. And so that tells me that in the economy, there is a high demand for their skills. And that high demand for their skills is because we don't have enough workers coming out of US colleges and universities that are qualified for those jobs. And because we are lacking people that can do the jobs, people that are on an H4 that it can become more and more valuable and necessary to the economy.
Absolutely, absolutely. But John, as you mentioned, not just tech sector, but other sectors are also significantly benefiting from this decision. So could this ruling potentially influence hiring practices in other industries as well?
Yeah, I think so. I think, for a while there during the Trump administration, the H4 was a red flag. You didn't want to deal with it because they were intentionally screwing around with the adjudication process and forcing people out of employment authorization. That's a situation that has been resolved now. And so, H4s are back into a predictable employee model. And I think they're going to be more and more sought after the more certain their future becomes. And I think this decision made their decision far more certain and far more clear. And that just gives employers and corporations the comfort and security they need to hire people in that situation.
Okay. So, John, also in your practice, have you seen a trend of companies reaching out for legal assistance following such rulings? And how do you advise them to navigate the complexities of these evolving regulations?
So during, like I referenced earlier, during the Trump administration, when they were intentionally messing around with L2s and H4s and their ability to work, we had a lot of people coming to us. And so we filed a series of cases, and we had two class action cases actually on those issues. And the government settled those cases because they were going to lose. And they changed the way they do things for both L2s and H4s. The L2s were given employment authorization incident to status, meaning they can just work if they have an approved L2. They don't need an EAD. The H4s, certain H4s were given auto extension of their EAD, and the remaining population of H4s were returned back to concurrent processing of their H4 and EAD, along with the primary spouse's H1B. So, those victories a few years ago have, really impacted, the employer's comfort and security in hiring H4s and L2s. The uncertainty of whether or not you're going to have this person here in a few months because of USCIS's incompetent processing times is no longer there. And so, people are far more comfortable hiring H4s and L2s. But, since that time, I don't think there's a whole lot of concern that, employers have had in terms of litigation. This case, the Save Jobs case, was, the plaintiff in that case was an activist group that is anti-immigration, and the defendant was the U.S. government. And they litigated the case, very well and quite easily. And there really wasn't any involvement from private industry in it, because I think it was a foregone conclusion that the plaintiffs were going to lose and the government would win.
And because now that you have mentioned Trump, I wouldn't want to miss this chance. Recently, when I think Trump was giving a speech, he said actually that if he comes to the office, there's going to be a deportation of around 50 to 60 million immigrants. So what's your take on that?
Yeah, the logistics of that kind of blow your mind if you think about what it actually would take. So, Trump says a lot of things. Very few of them are based in fact. And I think this is one that is just so wildly crazy that it's appealing to his base that are anti-immigration and xenophobic, but in reality, it could never happen. Because the Constitution gives everybody certain due process rights. And even if it didn't have due process rights, rounding up 50 million people and getting them out of their country to their home country is a logistical nightmare. And it's not something that could be done just with the sign of an executive order. So it's fanciful thinking, like much of Trump's diatribes these days.
Under my administration, anyone who illegally crosses the border will be detained until they are removed out of our country and back to the country from which they came.
So after you've answered this question, I would like to know a little bit about Wasden Immigration Litigation's role in immigration law. So John, your firm Wasden Immigration Litigation has made a significant impact in the field of immigration law. So can you share some landmark cases that have shaped your approach to litigation, particularly those involving the H1B program?
Yeah, so the first case we did was challenging a Department of Homeland Security rule that prohibited OPT and CPT students from working for consulting companies. And so they did this rule change without following the law. They just posted it on a website and buried it in there, didn't let anybody know. And so we sued on that, and within 2 weeks, the government reversed course, changed the rules on their website, and the issue went away. The next issue that we started facing was these H1Bs that were getting one-day approvals, or approvals that were granted after the notices, or prior to the notices being sent out. So it was already expired upon delivery of the 797. And it was just causing a lot of disruption. And it was based on a new policy memo that required that you have to have a contract for a specific project at the time you file the H1B. And so basically what they're saying is you have to have a guaranteed work assignment for the duration of the 3 years and prove that you have that for 3 years in order to get your visa. And the other issue that was popping up started in 2010, which was the Neufeld memo, the employer-employee relationship test, which was explicitly targeting, staffing and consulting companies. So we filed suit on that, and both of those issues were resolved. The Neufeld memo was invalidated by the court, and it said the law is clear. This is how you determine a employer-employee relationship. Your convoluted test is, not based in the law, and therefore it has to go. And in terms of the guaranteed specific project assignment, the court sided with us and said, the law has in here a provision that says that an employer can place an employee in non-productive status for lack of work. And because it has that provision that explicitly allows the employee to not work, your requirement to have proof of a project for 3 years is against the statute. And so all of those things got wiped out. And in almost overnight, what we saw was, H1B processing times for the form I-129 went from upwards of a year down to a week, and that's without premium processing. So it really did streamline the system, and it made things much easier and much more comprehensible for the public.
Okay. Also, but John, how does your firm differentiate itself in handling high stakes immigration cases, especially when dealing with challenges like, the ones posed in this ruling?
Yeah, so we're kind of in a limited space, really. Most of the large firms doing administrative litigation don't know immigration. And, if you're going to hire one of those firms, you're going to end up spending them a ridiculous amount of money just to make them smart enough on immigration to do the case. And then on the flip side, you've got the immigration law firms, and the immigration law firms are typically so used to just doing what the government wants just to get an approval that they don't really break it down and analyze and challenge, the basic ability of the government to make rules or make decisions. And so, a lot of times they just lack the creativity to do it because their mindset is so focused on what do we need to tell our clients to do to get an approval, as opposed to what should the law be. And so there's not a whole lot of people in this space doing this. So it's, it's a small market. There's not a lot of differentiation to be done, I guess, because of it's just such a niche. What's funny though is when I left the government, I worked at DOJ, and then I went to USCIS. And when I left the government, I wanted to, start a practice that was exclusively litigation and not do petition filing. And I talked to, dozens of large immigration firms, and they all said the same thing, which is, oh, you can never make a practice of that because nobody's going to have an interest in litigation. And so I started my own thing, and within a month or two proved them quite wrong. But it just shows you that most immigration firms are just not thinking the right way about how to solve these issues. They're just focused on, following their business model, getting things processed, getting things approved, and not making significant structural changes to the law.
Okay. Okay. All right. Thank you so much again for answering the question, John. I again would like to talk about Wasden immigration litigation, but in a while. So now I would like to discuss with you about the legal challenges and the Chevron deference. So, John, the legal challenge from Save Jobs USA argued that the 2015 rule displaced American workers. So, why did the court dismiss this argument, and how did the concept of Chevron deference play a role in this decision?
Yeah, so Chevron just says that if the law is unambiguous, you have to follow the clear language of the law. But if it is ambiguous, if it's not explicitly clear, then the government can create a regulation to fill in the gap. And it's going to be upheld as long as it's reasonable. And the courts were required to defer to the government's decision unless it was, explicitly violating the statute. So in the Save Jobs case, the law was very broadly defined, giving the government lots of space to fill in those gaps. And, the court looked at it and said, okay, there's a lot of room here for them to move and make decisions and rulings. They went through the process, they created the rule, and we can't say that it violates the statute, and we can't say that it is, unreasonable. Therefore, the government wins. The Chevron case, again, like we discussed earlier, is no longer in play. It's been invalidated by the court. It's been overruled. I think this case, the Save Jobs case, would have the same result regardless if it was Chevron or its successor, Loper Bright. It's just such a no-brainer that the government can do this, that it, is somewhat surprising that they actually put together a frivolous lawsuit to challenge it.
Okay. And John, also, how has Wasden immigration litigation prepared for potential shifts in legal precedents, especially the changing interpretations of Chevron deference? And what should clients be aware of in these uncertain times?
So right now, what we're focused on is consolidating a lot of the wins that we've had in court and building on those. And really the focus that we're looking at right now is forcing DHS, which is the parent agency of USCIS, to follow the law. And one of those areas that we're really focusing on is getting them to play by the rules when it comes to penalizing or sanctioning people for immigration fraud. They have a tendency to do that in secret, not tell you, wait for you to leave the country. And only when you go for a visa stamp or only when you go to the port of entry to re-enter do you find out that they've ended the fraud finding against you, and you have no chance to defend yourself then. So we're trying to get the focus back on to DHS to say, you have obligations under the law to give notice before you do this, to give an opportunity to respond before you do this, and to give a written decision explaining why you did this so that we can challenge it in court if we disagree. And we're slowly moving the needle on that and holding them responsible. And I think as more courts see it, they'll side with us on that. And what was your second question? Sorry.
So I also wanted you to also advise, what should clients be aware of in these uncertain times?
So I think you should always keep an eye on what should the law be, not what is expected by USCIS. If you're focusing on what USCIS wants, then you're just giving in on the core issue of what the law should be. So focus on what makes sense, what it looks like the law says, and when USCIS is doing something that is at odds with that, don't just roll over and give them what they ask for. Push back and fight. because that's the only way that you'll force them to maintain sanity in the system. What we saw for decades in the H1B program especially was companies and law firms just rolling over and not pushing back on what the law should be. And it led to USCIS making increasingly arbitrary policies and rules because they knew they would never get challenged. In fact, when I worked in the government, I would highlight certain issues that I thought were vulnerable in litigation. And they would say, we don't have to worry about that because nobody's going to sue us. So changing that mindset within the agency makes them a lot more cautious, makes them work a lot harder before they make policies and rules to make sure that if they do get sued, they won't be ruled against by the court. So by being aggressive, by pushing for what you think the law should be, you make the government more responsible and you make them more cautious. And I think the industry, and the country as a whole benefit from the government being more cautious before they do things and actually thinking through their decisions before they pull the trigger.
Wow. Okay. That's a really good advice. But John, does the law and USCIS, does they not go hand in hand? Are they two different?
Very much so. And in fact, USCIS's history in following the law has been very spotty, checkered, maybe gray. So just because USCIS says something doesn't mean it's accurate, doesn't mean that's what the law says.
Wow.
A lot of their, especially when you read their decision letters, a lot of their conclusions are completely not based in law or mischaracterizing the law. And so, just because they have a policy or they have a adjudication trend doesn't mean it's backed up by the law. If they always were backed up by the law, I would not have a job. So the fact that I exist means there's plenty of places where they're screwing up and they're cutting corners.
Wow, that's a big revelation, I would say. All right, thank you so much again for answering the question, John. Now, I would like to talk about, DHS's authority a bit. So, John, how far reaching is DHS's power when it comes to shaping immigration policy?
So it really depends on which visa category we're talking about.
Okay.
So, some visa categories are very broadly defined in the statute. They're so broad that you don't really know what the standards are. When that happens, say like in an EB1C, the International Executive or Manager visa, or its analog, the L1, there's very few standards in the statute that let you know what is required to get an approval. So USCIS has filled in those gaps through policy and through some regulation and some decisions, some binding decisions. The ability to challenge those decisions in court when they deny an EB1C or an L1, it's very difficult because, my job is easiest when we can point to a clear rule that the government's violated or that they're contradicting, or point to a process that they failed to comply with when making a decision, and then we win. But when there's really no rules to apply, there's nothing for us to point to and say you're doing it wrong. And those broadly defined visa categories are tough. Now, when you look at the Immigration Nationality Act that Congress created, you have some sections that are very short, and then you have some that are very long, where they just go through and they analyze every possible situation, or they explicitly create tests for how to qualify for the benefit. In those visa categories, USCIS's and DHS's ability to make rules and policy are very, very limited because Congress thought through all of the issues already. So, it just really depends on the visa category you're looking at. I think the H1B is a thankfully, a very well thought out program by Congress with a lot of rules that Congress has put into the law. And that really does limit USCIS's ability to mess with people. And that is as long as you're aggressive and you push back against USCIS. If you don't push back, if you don't fight them, they can do whatever they want.
Okay. But also, John, do you think there could be any legislative pushback against DHS's broad authority in the future, particularly from groups advocating for stricter immigration controls?
So, again, the new Loper-Bright decision that came out that overruled Chevron, it'll be curious to see how that plays out, because that makes every district court judge in the country the decider on what the law says and what the law means. And that creates the possibility that you could have a judge in Texas ruling, for an anti-immigration group on one hand, and a judge in Seattle ruling the exact opposite way on the same issue. And so, how that resolves and how that gets ironed out is going to be interesting to see. I think, as lawyers, we say anytime there's new law, there's new work. I think the Loper-Bright, post-Chevron era is going to create a lot of litigation and a lot of work for lawyers that are in the administrative law space like me.
Wow. Okay. And again, John, thank you so much for answering the question. Now, I would like to talk about the impact of this ruling on H1B visa holders and their families, because again, this is something very important. So, John, from a very practical standpoint, how does this ruling impact H1B visa holders and their families, and what changes might they expect in terms of work opportunities and their overall experience living in the US?
So I think the good thing is it gives them a little bit more security. Okay. Now, you look at what a court's going to do now is look at the language of the law, but also look at the purpose of the law. And for the H1Bs, the purpose of the law was to increase the number of highly educated, specialty occupation workers in the United States, because we were not creating enough of them domestically to fulfill the needs of the economy. And so coming into the case, a lot of factors are already on your side if the government denies your petition, your visa. So, the law typically is going to be on your side a lot of times. And then even when the law is not exactly clear, the purpose of the statute is going to be on your side. What the government is looking to do by denying your visa petition is exclude a highly qualified, highly educated specialty occupation worker from the workforce. And that really does go against the whole purpose of the H1B. So it gives courts a lot more ability to be reasonable and come up with decisions that don't slavishly defer to the government's arbitrary decisions. And I think, that helps. Now, I say that, but it's important to remember, the government can screw up your life with the stroke of a pen, and that will take seconds. To fix it is going to take you a long time. So if the government does a stupid ruling or a stupid decision like they are prone to do, it takes months to fix that. And so that's frustrating, but at least there's, a light at the end of the tunnel, because the law has altered things to make it more favorable for you to challenge those stupid decisions.
Absolutely. So are there any potential pitfalls or complications that H1B families should be aware of, even within this ruling, in their favor?
So I don't think there's any pitfalls that are out there. I think more than anything, it should concern the government that every single judge in the country now gets to look at the law fresh on its own. Because the government is a big, unwieldy beast that doesn't move very quickly, and it doesn't really have the ability to adapt very well. And USCIS in particular cannot function by looking at how, Texas views the law versus Washington State versus New York, and they can't come up with different policies and procedures for each of those different locations. And I think that what that's going to do is it's going to make them far more careful in how they create rules, just so that they create consistency across the country. Because if they start getting rules invalidated in one location but not in another, it's going to be a real nightmare for them. And they're just not going to be able to function. So I'm hoping that it'll force them to be a little bit more reasonable in the way they create regulations and make decisions.
Okay. So, John, an additional question. So, in your experience, what are some of the most common legal challenges faced by H1B families, and how does your firm assist in navigating these issues?
So, one of the more disturbing trends that we see is USCIS penalizing workers for errors or, program violations of the employer. And what's frustrating about that is you, as the H1B worker, have no control over anything during the petition process. USCIS, in fact, explicitly says that you have no role in this process. So you don't sign anything, you don't, give declarations to anything or the accuracy. Now, if the employer does something like not pay the full wage, that's the employer's obligation to do. It's not your obligation to get paid the full wage, right? Because that's out of your control. But what USCIS is doing now is they're revoking visas, denying visas, and saying you're out of status if you're not getting paid the full wage. That is such a clear violation of the law that they typically cave in on that when they get sued. But the fact that they're doing it is frustrating. And I think, you have to be very careful. Anytime you see an employee getting penalized for something the employer did, that's a huge red flag. That's something that, you really need to be aggressive and push back on and not just assume that the government did it right because they didn't.
Okay, and let's also talk about, a little bit about the potential repercussions on American workers. So, John, critics of this ruling, like Safe Jobs USA, they argue that it harms American workers. So, what's your perspective on this claim? And does the data support the idea that American jobs are being displaced by foreign workers and their spouses?
See, the argument in Save Jobs that they're stealing jobs from U.S. workers is kind of a symptom of the greater problem. They don't understand math. And the American economy in general is just not producing enough people that understand math and can do critical thinking. So if you look at the graduation diplomas that are coming out of U.S. colleges, very few of them are going into the STEM programs, the jobs that we need to make the economy function at a high level. Far too many U.S. kids go to school, waste time and money to get degrees in things that don't matter and don't make them employable. And so if we want to stay on top of the game, we need people who are highly educated to fill those jobs. And if we're not doing it domestically, we're going to have to import. And so if we want to stay on the top of the world economy, we have to attract smart people. So it's frustrating to see, people that should be smart enough to look at the data and say, we don't have enough of these people graduating, therefore we need to import, smart workers. Instead, they're just basically racist and they just want to exclude anybody that's, not from a Northern European white country. So it really has nothing, in my opinion, to do with jobs. It has everything to do with, their nationalist take on what immigration policy should be like. They really want to keep it just to those Northern European countries if they could.
Okay. So if the American workers are thinking like that, and if the claim, of job displacement lacks strong evidence, So, John, what can be done to address the concerns of American workers who feel threatened by the presence of H1B workers and their spouses in the job market?
So, if you look at the difference between, like, say, the EB2 and the EB3 visa categories that have labor market tests,
Okay.
those categories were created back in the 50s and 60s when there was a real concern about protecting U.S. worker jobs. And so they instituted the labor market test. And it's a product of history that we're kind of stuck with. When they created the H1B, Congress looked at all the data. This was all the way back in 1989 and 90. They looked at all the data and they realized, we got a problem. We don't have enough people. And so they eliminated the labor market test from the H1B program because they realized it wasn't necessary, because we just didn't have the numbers that we needed domestically for those jobs. So the reality is, I don't think most H1B workers have to worry about that. It's only when they go to the EB2 and EB3 categories for their I-140s and 485s that they start having to worry about some of these arcane and convoluted rules dealing with the labor market tests.
Okay. And John, also, how does Wasden immigration litigation approach these delicate situations where the interest of American workers and foreign visa holders collide? And what legal strategies do you employ to balance these competing concerns?
To be completely honest, I haven't seen a legitimate case where a U.S. worker has been harmed by an H-1B worker. I see a lot of people who are what we call bottom feeders that file lawsuits and file claims against companies for immigration violations just so they can get settlements out of the companies. Litigation, unfortunately, is very expensive. And so companies do the math and they say, just to get rid of this case, we'll give them a check. And it saves on attorney fees. And so you have a lot of these people that are filing claims with the government of discrimination just to get those checks, but there's really no discrimination in the system. It's all frivolous lawsuits claiming that otherwise. So, I just really don't see U.S. workers being harmed. Okay. I look at all of my friends that have, STEM degrees, and they work in the IT industry. They came out of college and they were worth gold because, they were an American kid that had one of those rare degrees. And they move up very rapidly within those companies because there's so few people like them. There's just not any harm that they face from other smart, skilled, talented people coming into the economy and working. So I'm not worried about U.S. workers being harmed by highly educated people coming into the marketplace.
Wow, great. Thank you so much again for answering the question, John. Also, now, let's talk about global talent competition a bit. So, this ruling is also seen as a way to make the US more attractive to global talent. So, in your opinion, how does the US currently stand in the global competition for top tier talent? And what role does immigration policy play in this?
Yeah, so I think, obviously our industry is probably the most attractive in the world. Mm-hmm. But the problem that we have is structural, in that every other industrialized country, when you get a visa to work, your spouse also gets authorization to work.
Right.
And in the US, it's not the case. And so it's a huge disadvantage because, especially in the Indian community, you have two married people, both of which tend to be equally highly educated and ambitious and intelligent, and one of them doesn't want to just give up the hope at a career because their spouse has a visa. And so it's very easy for them to shop around and find countries where they can both work and they can both pursue a career. I think in the future, if the US wants to stay competitive, they're going to have to make some changes to the way they deal with spouses and make spouses, more flexible and more attractive to come to the US.
Okay, okay. But do you think, because of this ruling, is there also a possibility of having a lot of scams? Because, just to get green cards, people also marry people living in the US. You must have seen cases like that, right, John? Right, John. So, do you think more cases like that coming after this ruling?
I don't think so. I've been on quite a few cases dealing with marriage fraud, both within the government and outside the government. And I will say that marriage-based visas get probably more scrutiny than any other category out there. And the amount of inquiry they go into for a marriage-based visa is really impressive, actually. And the amount of data that they research on the individuals and cross-reference information, it's very impressive. There are some serious structural safeguards in place to prevent marriage fraud. Mm-hmm. And if you do commit marriage fraud, you are forever banned from the US, and you have no chance of ever getting a waiver or anything. And so I think the likelihood of marriage fraud popping up as a very frequent thing is very, very unlikely.
Okay. Thank you so much again for answering the question, John. And also, do you think are there other countries also that have more favorable policies for attracting skilled workers and their families? And if so, what lessons could the US learn from them?
So I would say Germany. Not only do they have amazing beer, but they have very good immigration policy. I would say the Canadians as well. Mm-hmm. They look at the workers coming in as, valued guests, right? Mm-hmm. They're providing something that the country needs, and they don't, treat them as basically criminals that have to be inspected and scrutinized and suspicious of. And unfortunately, the way the U.S. immigration agencies have been trending is to view every single, applicant for a benefit as somehow, looking to commit fraud. And so their initial step in just about every application is, this is fraudulent. How is it fraudulent? As opposed to, all right, this is a very highly educated person. They fit their criteria. Let's let them in. And so there has to be a mindset change within the government from everybody's committing fraud to, okay, we need these categories of people. Are they qualified? And that's a cultural problem that USCIS has, and hopefully in a new administration they put leadership in there that will clear that cultural problem out. But right now that's what we're stuck with.
Okay. Again, okay. Thank you so much, John. And let's talk about future of H1B visa program a bit. So, given the ongoing debates around the H1B visa program, so what do you think is the future of this program? And are there any upcoming changes or challenges that applicants should be aware of?
So the biggest thing on the horizon, I would say, is there's the modernization of the H1B regulation. Mm-hmm. USCIS proposed a new regulation dealing with H1Bs, and they took comments from the public, and they were supposed to release the final rule in June. That's been since postponed until December. I would not be surprised if it gets postponed again in light of the Loper-Bright decision that overruled Chevron, because the things that they proposed to do in the new regulation, some of them explicitly contradict the statute and are dead on arrival when they get sued. But some of them are just really unreasonable and stupid and counterproductive to the purpose of the H1B program. So if they go forward with all of those proposals, it's going to be something that gives attorneys like me a lot of ammunition to fight, because they're just they're acting very crazy. And so I think that modernization rule with all those limitations on the H1B program might be watered down quite a bit in the final release, I'm hoping. So other than that, besides that modernization rule, USCIS has always created more rules through adjudication trends than they have through regulation. So, you start seeing new templates of decisions and new templates of RFEs and NOIDs and NOIRs. And that's the product of internal rulemaking in the agency that's kind of done in secret. You don't really know what the rules are until you start seeing them ask for information and asking you to prove things in the adjudication process. That's always a moving target. It's hard to say where that's going to go. But I think right now, one of the things that we're seeing them really focus on is maintenance of status and whether or not, you can extend status or change status based on whether or not you maintain status. And the way they're interpreting maintenance of status, quite frankly, is unhinged. And it's causing people a lot of problems, people who have done really nothing wrong. And it's causing a lot of issues. So I think that's one of the potential harms that we're facing right now in the adjudication trends.
Okay. And how does Wasden immigration litigation position itself in the face of these changes? And what should H1B applicants consider when seeking legal representation, especially, with the increasing complexities of immigration law?
Yeah, so when you're in the petition process, it's important to keep in mind what the law is and what the law actually requires. And when you see them, coming up with a new adjudication trend or a new theory of ways to change and alter the rules, it's important to push back on that and say, no, this is what the law requires. This is what we provided. We're eligible for the petition to be granted. And when you're in the litigation stage post-decision, it's important not to just take whatever USCIS said as true, because you're going into court and the court's going to decide what is true and what's not. And so, you have to look at every aspect of the decision and poke holes in it and say, this is wrong here, this is wrong there. And don't just say, oops, USCIS said no, so I guess I can't get it. You've got to think creatively and, hold the government accountable.
Okay. Thank you so much again for that great advice, John. And now, advice for affected families. So, John, also, what advice would you give to the H1B visa holders and their spouses who are directly impacted by this ruling? And how should they navigate the complexities of their work permits and immigration status?
Yeah, so the H4 is a great thing, and it's just getting better because its future is far more certain and predictable at this point. Anybody that can get an H4, I would highly recommend getting the EAD, just because it gives you so many benefits and so much flexibility, and it doesn't have any other restrictions that the H1B has. And it honestly makes you more employable than the H1 does, because the H1B has so many limitations. So it's a good time to be an H4, and I think it's something that everybody should try and get if they can.
Mm-hmm. Okay. And one last question before I let you go, John. How does your firm assist clients in not just understanding, but also leveraging such rulings to their advantage? Could you share any success stories or maybe examples where your firm made a significant difference for an H1B family?
It's a long list, frankly. So a lot of our cases recently, like I had mentioned earlier, have been focusing on the employee being held accountable for the employer's mistake or error. And we've been litigating these cases quite a bit. And most of these cases, when it hits the U.S. Attorney's Office, the U.S. Attorney is defending the government in court. They look at it and they realize what USCIS is doing is crazy, because, the way we present the arguments. And they lean on USCIS to fix things. and then we get a retraction of the denial and a new approval notice. And so those cases are rewarding because you're really dealing with somebody who's done nothing wrong, but is facing all the penalties and all the consequences. And so, unfortunately, that's a growing business area for us. I wish it weren't the case because it puts people in a lot of stress and a lot of uncertainty for something that they didn't do wrong. But it's rewarding when we get those good outcomes for them.
Okay. All right. Thank you so much, John. It was a great episode. Thank you so much again for being here. I always love doing these shows with you. Your answers are always so insightful and so in-depth. So thank you so much again for a great episode.
Thanks for having me.
Thank you so much. And guys, if, I hope the session was helpful to you as well. And if you want to reach out to Jonathan Wasden, you can give him a call at 844-592-7336. I would like to repeat the number, 844-592-7336. His email is john@wasden.law and his website is wasden.law. So don't forget to write an email to him, and also don't forget to check his website out. Thank you so much again, John. It was a great episode. Hoping to see you next week.
Thank you. Take care.
You too.
Hello, viewers. Thank you so much for joining us today. This is Immigration and Jobs Talk Show, and I am Nipasa Pradhan. I'm going to be your host for today's session, and it's going to be a wonderful one. So before we dive into today's topic and I introduce you to our special guest, I really wanted to wish you a very good morning, good afternoon, good evening, wherever you have joined us from, whatever time zone you have joined us from. Thank you so much for doing this. And there's an important disclaimer I need to read out. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, thank you for joining us today here at Immigration and Jobs Talk Show. We are streaming live on YouTube, LinkedIn, and Facebook. So feel free to drop your questions if you have any, in the comment section, wherever you're watching us from. And we'll try to get as many as we can in this session today. But before we go on to today's topic, today we have a very special guest with us, someone who is a prominent figure in the field of immigration law. And she is Sophie Alcorn. She's the founder of Alcorn Immigration Law and has been recognized as the top 10 immigration attorney in the state of California. She's also the host of the Sophie Alcorn podcast and the author of the best-selling book, Ask Sophie, The Founder's Guide to Visas and Green Cards, currently based out of San Francisco Bay Area. It's such a pleasure and an honor to have you with us, Sophie. Thank you so much for joining us
Hi,
today.
Nipasa. It's so wonderful to be back. Thank you so much for having me. There's a lot of exciting updates, and I'm eager to share my knowledge and answer questions. So thanks for the opportunity to be here.
Thank you so much. Thank you so much. And talking about it, let's get to know what are your thoughts on the latest update on the second lottery coming up for H1B cap.
Yes, it's so exciting. So a couple days ago, USCIS just announced they are going to conduct a second lottery, or the random selection for the previously submitted H1Bs. So this means that if an employer put you in the lottery in March and you were not selected in April, you now get another chance. And It's really exciting. And it's also super exciting for most people in the world because they've already reached the master's cap of the 20,000 set aside for people with advanced degrees from the US. And so it means that everybody is eligible for this second lottery now. So if you have a master's degree and you're going for the master's cap, you know, great, you still get another chance, but everybody else who just has like a bachelor's degree or the equivalent, they also get a second chance. So it's really exciting.
It is. For folks out there, I mean, all this while, everybody were like, is there a second lottery going to come up? And oh, by the way, is there any chances of maybe a third lottery maybe after this?
Right, right. It's so erratic every year. I mean, one year they had like 4 extra lotteries, and then other years they've had 0. And so it really fluctuates. You know, I'm sure they try to do their own like predictive analysis and statistical modeling to try to get the right number, but there's always fluctuations, interest rates, layoffs, you know, employers, whatever. So I don't know if there's going to be another this year. I have no idea, but I'm just really happy this is happening now. I wish I knew when it was happening, but I don't. They just said soon. And if you previously registered, you know, you're going to find out about it through your USCIS online account. And typically, they give employers 90 days to file the petition after the selection has happened, and it would still be to target an October 1st start date. So we have August, September, October. So theoretically, you could probably request a later start date than October 1st if your employer wanted. You could choose a start date up to 6 months into the future for the I-129 H-1B petition. But we'll see. Like if you wanted to still try to make it by October, and I don't know, let's just imagine this happens next week, I think there would still be ample time for an employer and for a visa interview to go through the process. So it's really exciting.
Exciting, it is. Let's stay hopeful, folks, I would just say, and all the very best to all you folks out there who have the second chance. Let's pray for the best, okay?
Yeah.
So, yeah. And let's get to today's topic. Our topic for today's discussion is top visa options for employers for a quick hire, H1B versus H1B exempt versus L1 versus O1. And basically, it's the second episode, but since we couldn't cover it properly in the first episode, maybe, Sophie, if you could just give us, you know, like a roundup or like what can folks expect from us in today's webinar?
Wonderful. Okay. Well, I will share a little bit more. And thank you for the warm introduction. I really appreciate it. You know, I started my law firm. My dad was an immigration lawyer. My mom's an immigrant from Germany. And I just see the grit, resilience, determination, creativity, innovation that come from our immigration system in the US. And I believe that we should live in a world where every kid has the chance to grow up and live their dreams. And so that involves, you know, removing artificial barriers like immigration to allow people to live their best lives. So happy to keep in touch with everybody. And you had an amazing disclaimer. This is mine. This is not legal advice. Talk to a lawyer if you need individual legal advice. Obviously, whatever questions you ask are not confidential. This is just an educational service. And in my slides, I do have this QR code, which is our consultation booking link if you do need help. And let's see. And would you like me to now go into some of the overview about some of the background on H1Bs and Ls for a few minutes? Would that work for you?
Yes, we should do that. I think without further ado, let's get on to whatever you have for us today. And we are absolutely ready. And I hope the other folks out there are as well.
Wonderful. Well, I'll go through my slides. Feel free to jump in if anything's unclear, but I'll try to go through them in maybe, 5 to 10 minutes, give everybody a brief overview of H1Bs, cap exempt H1Bs, L1s, other types of visas, green cards, and then we can turn it over to questions. Okay?
Absolutely. Thank you so much.
All right. You're so welcome. Okay. So high level immigration context. Lots of reasons people want to come to Silicon Valley where I practice immigration law. They want to launch new technologies. They want to increase their profit. They want to move really fast. They want to work with the brightest minds from the world. They want to raise money and venture capital from US investors. Now, you're probably all very familiar with this in the audience, but in general, the US has visas, green cards, and citizenship. So most people, like from India, for example, would come here on a non-immigrant visa, such as a B1, B2 visitor visa for 10 years, where you can stay 6 months at a time, or an F1 student visa. And then after you're here, you have various options, such as changing your status. Maybe if you got selected in the H1B lottery, or you're going to pursue an O1 visa for extraordinary ability. And then you can be sponsored for a green card, either by a family member or an employer usually. And a green card is the same thing as permanent residence. Sometimes it's called an immigrant visa. If you're already in the US, you can get it through a process called adjustment of status. You might be qualified for a work permit along the way. There might be travel restrictions at some point, but you would get an advance parole document to allow you to travel. And then 5 years after having a green card, if you want to naturalize and become a US citizen, that's something you can apply for yourself. You don't need an employer. And once you're a citizen, you can sponsor your parents for green cards. And you always have to pay taxes in the US, but you can be gone as long as you want. So lots of advantages for that. So most people come here on a visa and then get a green card. Some people do, like some folks from India who are EB1A qualified. They might, for various reasons, choose to apply for the green card from India before moving here, but usually that can take several years. So often people want to move here quicker through a visa. And then there's a lot of international students in the US. Along the way, they can have work options such as curricular practical training, optional practical training, pre-completion or post-completion, the 24-month STEM OPT extension, after the up to 12 months of regular OPT after they graduate. And historically, the hope was always, I'm going to go to the US, I'm going to graduate, I'm going to get a job that'll sponsor me for the H1B. They'll put me in the lottery every year until I'm selected, and then they'll sponsor me for a perm and an I-140. But several big companies recently announced that with all the tech layoffs, they're no longer engaging in their perm programs for their employees. So these this path is not as secure as it used to be. And so, definitely excited to provide alternative options. So for work visas, the most common, we talked a little bit about the H1B lottery, so that's very exciting. It is possible to hire people with H1B transfers, and you would need current or previous H1B status. The new US employer has to proactively file the H1B visa transfer petition. They have to prove that they have the ability to pay the prevailing wage. And if somebody's already maxed out their 6 years on H1B status, there are ways to get extensions beyond the 6 years through a law called AC-21. And that is based on having a perm or an I-140 approved. And then you can get either 3-year or 1-year extensions. So lots of people from India utilize that. Now, we did get a question about what is a cap exempt H1B. So these are H1Bs that do not require the lottery. They are available at any time of the year. And the best way to use it to have a job at a private company is to obtain 2 concurrent H1Bs at the same time. So step 1 is to either get a part-time job at a qualifying cap exempt employer. So that could be a university for a part-time teaching assistant job. It could be at a nonprofit associated with a university or a nonprofit research institution. There are various global talent fellowships and organizations that have sprung up to support this. So you basically work for them for 5 hours or 10 hours a week to get your first H1B. And then while you're doing that job, you don't have to go through the lottery to get a second concurrent H1B with a private employer. So your other employer can then sponsor a part-time or full-time concurrent H1B. So that's been very, very beneficial. And just to recap, those cap exempt organizations that you could get the first job at include universities, government research organizations, nonprofit research organizations, and nonprofits affiliated with universities. Okay, so those were H's. And just another note on H's before I move forward, because we work with a lot of startup founders. We've gotten H1Bs approved for CEOs of pre-revenue startups, even where they're the 100% owner, and even where there's no major venture capital investor. The government is very interested in allowing folks on H1B to become startup founders because they recognize the innovation potential that people on H1B have to develop new critical and emerging technologies and AI and ML and other areas. So if you are on an H1B and want to be a founder before getting a green card, it is definitely possible. And you could even do that with a cap exempt H1B. Okay, so now for employers, another option that they look at would be an L1 intracompany transferee visa. And the basic setup would be there's, and we work with a lot of startups. So typically for a startup, it would be a parent company with an office in San Francisco, maybe incorporated in Delaware, and it has like a wholly owned subsidiary, like private limited company in India. And there's people who've been employed at the Indian office for at least 1 year out of the last 3 years as managers or executives or people with specialized knowledge. And now the US office is transferring them over to be a manager, executive, or person with specialized knowledge in the US. So you can come for up to 3 years initially, or 1 year if it's a new office. You can get 2-year extensions. The L1A can be extended up to 7 years. The L1B can be extended up to 5 years. And the other really cool thing about the L1A for managers and executives is that it provides a path to the EB1C green card pathway, which is the fastest. EB1 is the fastest green card pathway. So if you're from India and you don't qualify for extraordinary ability yet, it can be very helpful to get that EB1C approved as well. Now, the O1s are also very popular right now. It's typically a 3-year initial petition for extraordinary ability. And then beyond the first 3 years, you can either get 1-year extensions or new 3-year petitions can be renewed indefinitely. If you are from India, you get a 5-year multiple entry visa in your passport. The O1 visa interviews are usually pretty fast. To qualify for an O1, you need 3 of the 8 categories that are pretty well established. So that could be like awards, people writing about you, what did you create or invent? Are you a leader? Are you a member of organizations that are hard to get into? Are you a judge of who is an expert in your field? Are you an author or a speaker? Have you earned a high amount of money relative to your other people in a similar role in your geographic area? So these factors can be mixed and matched. You can do it if you are a founder, a researcher, an engineer, a TikTok influencer, an inventor. We just mix and match the categories in different ways. And the other cool thing about the O1 is you can be self-employed, you can have multiple streams of income, you can have one job at an employer, you can have many projects. So it's a very flexible thing, although the drawback would be that your spouse does not automatically get a work permit. So just various factors to keep in mind. And I am absolutely here to help, and we'll be sharing my contact information more, but you can always reach out to me and my firm at alcorn.law. And my book, Ask Sophie, is available on Amazon and Audible. And yeah, okay. So there we go. That is the overview. And I'm so delighted now to ask questions, to answer questions or chat or anything else that would be helpful.
Thank you so much, Sophie, for that wonderful presentation, I would say. And you made it so much clearer with all these slides you had to provide for us. So
Thank you.
really happy to have you.
Appreciate it.
All right. So it was good. And I'm sure folks already have questions. I can see actually. So Rocky Berman, thank you so much for your questions. Raja Shaker, hi, thank you. Just stay with us. We will take up your questions. And absolutely great. So far, so good. So a lot of things going on. I mean, as far as immigration is concerned, and with the elections coming up, I think everybody, they have questions in their head. What is going to happen if Kamala Harris is going to be selected, or what is going to happen if Donald Trump is going to be selected? What do you think? What do you have to share with our folks out there?
It's been such a roller coaster this year, and I'm always like recalculating what the immigration landscape will look like. Okay, here's what I can say about both as it stands now, not knowing what the outcome will be. So, first of all, we've had a lovely 4 years of this Biden administration from an immigration perspective. We got out of the COVID backlogs. Consular processing is back to decent times for most countries around the world. Premium processing is available for more cases. The online lottery H1B system's working. So there's been a lot of improvements. And also for startup founders, international entrepreneur parole is now another option as well. If you get the levels are about to increase, but say you get $320,000 of investment from a U.S. angel or VC investor, that could qualify you for our equivalent of a startup visa now. So all those things are wonderful improvements from this Biden administration. If there is a Republican administration, what we saw during the last Trump administration was the Muslim ban, high levels of RFEs for H1Bs, stopping H1Bs for computer programmers, litigation about H1B third-party contractors, slower processing times because State Department officials were leaving their consular posts. The whole system got slower, and there was more friction. That being said, one of the things that former President Trump mentioned on a podcast with some venture capital investors a few weeks ago was that he's actually in favor of a proposal that Hillary Clinton originally came up with, which is essentially like the staple the green card to the diploma sort of idea, which is like, look, if you're smart enough to come here and be enrolled in our universities on an F1, you should theoretically have a path to a green card and citizenship. So what that looks like, I have no idea in practice. I think if there's a Republican administration, it would take some resolution of the US-Mexico border and asylum situation that would need to get clarified before anybody's going to move forward on high skilled. But if that's in place, high skilled would become very easy. If it's a Democrat administration, like under Harris, for example, I think we'll see general similar positive trends to what we've seen for the last 4 years, but she's also very different. And she might have, I mean, she's been focusing very intently on the southern border, on getting investment into Latin American countries to try to create more economic abundance there. So there's less migration flows to the US. So her stance on high skilled is probably slightly different. Maybe she'll be more proactive, but in general, I think the Democratic Party wants to see an increase of high skilled, even for example, making O1s and EB1A and EB2NIW self-petition green card pathways more accessible. So that's my analysis now. Now, depending on who either of them hire to actually implement their campaign ideas, then that's like a completely different thing as well, because former President Trump was kind of like pro high skilled. He wanted a skills based thing like Canada and Australia when he ran before. But then the person he put in charge of immigration had very different perspectives. So, well, I don't know.
So true. And there are things changing. There's still a few more months, so anything can happen.
Yeah, anything. It's going to be a wild ride in the reality TV show of American politics for the next several months. But in general, what I've been telling people is, if you want to move here and you're eligible now, like, don't dilly dally. It would probably be a good idea if you qualify to just get it done now, and then at least you're in line, in the queue, waiting, and then that would be an advantage for whatever happens in the future.
Yes, just keep your game up. I think, see what chances you have and try to put your game up. I think, that's how it always works. All right. Thank you, Sophie. That was very nice and good to know your views on this as well. So let's get back to our topic and let's get back to the questions folks have for us as well. All right. So let's take let's take this one from Rajat. Rajat is asking on YouTube. If someone is selected in the first round of the H1B lottery and their employer submits a petition, is there still a possibility that they might not receive a call for a visa interview from the embassy?
It would be very, very rare and unlikely. So typically what would happen is the employer had to submit the petition by June 30th. And
Okay.
the employer could pay for premium processing, but doesn't have to. So you could find out if they did. If they did, you should have already gotten an approval or a request for evidence by now, because it's been a month and they are supposed to take action within 15 days. If your employer does not want to pay for premium processing, then you are able to. So you can ask them to upgrade it, and you can, in that situation, you can personally pay the $2,805 to ask for premium processing. Once there is a decision, your petition will go through the electronic system to be transferred to the State Department. And then you should be able to schedule your visa interview at a consulate of your choosing based on the available processing times of the different consulates, which fluctuate a lot. And then you go for your visa stamping interview. And usually the visa is granted pretty directly after that. There is a situation called administrative processing, where the government can do additional background checks or look at the company that's sponsoring you, or maybe there's maybe your name is similar to somebody else's, so they have to disambiguate your background check with somebody else's. So that can take a long, indeterminate amount of time, but that's extremely rare. So in most cases, but you don't just randomly receive a call for a visa interview. You have to work with your employer and your immigration attorney to proactively schedule the visa interview.
Mm-hmm.
It's not just going to magically happen. You have to take action.
Right. Plus, this year, I think it was very beneficiary centric. So only employers or people who were registering for the folks with H1B, only they get to see what the status is, right?
Yeah, the employers are responsible for the process. So they create the online accounts, they put their candidates into the system.
Exactly.
So you need to be kind to your HR person so that they're willing to share information with you. Don't annoy them too much.
For sure. So, but anyway, I mean, a call, if it ever happens, it's only going to go directly to the employers, right?
Yeah. The employer has to check the online system to see if there's been an
Exactly.
update and to see if you've been selected. Yeah.
Right. Thank you, Rajat, for your question. I hope that's pretty clear now, since Sophie has answered that. Should we take up another one, Sophie, from the audience?
Let's do it.
Okay. This is from Pedoju. Filed H1B with my PG from India, post-graduation from India. I want to know that my application will be in regular pool only, no? Yeah.
Probably. Yeah. Because the US master's cap is for people who got an advanced degree from a qualifying. So if you had a master's degree from the US, you would go into the master's cap. But if you have a master's degree from India, you would go into the regular cap. But everybody in the world is going to be included in the next round, in the second lottery round. So you should be included in the regular pool now.
Okay. All the best, Peduju. I hope you make it. Let's take another one. This is also from YouTube. This is from Rag. Heard elsewhere from Sophie that L1s are heavily scrutinized and not encouraged to jump into. What do you have to say about your own comment, Sophie?
Thanks for holding me to task, Rag, and thanks for listening to various things I've said in the world. I'm trying to make this more accessible for people. This is something that fluctuates a lot. So I would say recently we've been quite successful with L1s. Sometimes there's trends in the immigration lawyer forums where it's like, what the heck? They have 10 employees and there was still a horrendous RFE. So I think it just fluctuates, but really the principle that I would take away from the last few years from Republicans and Democrats alike is if you want to get an L1, you need to have a functional company abroad that's going to keep going without the person who's transferring to the US. That organization, let's just say in India, needs to have employees, a revenue stream, growth plans. If you're the sole employee in India, you're not going to be able to transfer to the US. They want to see that you're supporting a multinational growing business. Now, the smallest possible size for the foreign employer, I think that we've gotten it improved with like 5 to 10 employees to transfer an executive to the US. So it doesn't have to be that big, but it should still have a presence. And then you should be able to withstand any L1 scrutiny. I think that's my current approach.
Thank you so much. And Rag, I'm sure you are a total immigration enthusiast. I mean, really good to have you back on our show because I remember you from yesterday's show as well. So thank you, Rag. And yeah, thank you for watching Sophie and her comments as well. Sophie, you're watched, so be careful.
I know. I go to coffee
so
shops now in the Bay Area, and when people I'm like, I don't know if you're recognizing me or if you're just looking at me. I don't know. But if you see me,
I'm sure people recognize you. And you just go walking around like that? I'm sure they recognize you. I mean, from your book, from your podcast.
I'm in the heart of Silicon Valley. And so now I'm like, I don't know.
Yeah, wow. You will meet, what do you call, people are, I mean, your, what do you call them? Who will have to look after you?
Oh.
Gods, like not gods. There's another word. I'm so sorry. That's just slipping out of my mind. But yeah. All right. Let's take this one from Rocky. Yeah.
Okay.
Heard about H1B exempt visas, but I'm not sure how they work. Can you tell me about the advantages and disadvantages of pursuing H1B exempt status for my company and how it differs from regular H1B visas?
Yeah. Thank you. And thank you, Rocky. This is a great question. So I mentioned it a little bit in the presentation. The disadvantage of pursuing cap exempt H1B status is it takes time and money. And so if you get somebody selected in the lottery, overall it's cheaper, but it's just risky because they might never get selected. There's about a 25% chance. So if you have a company and it's like a for-profit LLC or corporation or something doing business with revenue, for your organization to become cap exempt itself, you would have to incorporate a new 501c3 and have revenue there and set up a whole additional company. Most employers don't want to do that. Most employers would work with one of these nonprofit affiliated with universities, institutions to do the cap exempt H1B sponsorship for their employees. And so that's worked very successfully for candidates around the world, for my clients for years. And there's different organizations springing up with different price points to do that and different offerings. The drawbacks of working with them are you're paying another organization to employ your candidate for several hours a week. Your candidate has to do other stuff that fits with the educational nature of the nonprofit, like training American students on an internship that they have. But you can set that up to be beneficial for your company and have a domestic talent pipeline as well with, students who are familiar with the work you're doing. So your employee, has some additional obligations they need to maintain during the whole course of the H1B or until they get selected for the lottery or until they get a green card. But if you're if your organization has cash flow and if getting somebody to the US is important and urgent, and if that person is not otherwise qualified for an L1 or an O1 or some other type of visa, and if you don't want to go through the pain of trying to organize a part-time TA-ship with an H1B at a university yourself for your candidate, I mean, these are wonderful cap exempt organizations that can help you get somebody to the US working with you in person in 2 to 3 months with very little risk. So from that perspective, it can be worth it. It's different cost benefit analysis for every employer. So.
All right. Thank you so much. I think that makes it very clear. I mean, to Rocky, thank you so much, Rocky. Very interesting question. And Sophie as well for taking that up.
Thank you.
Moving on, I think we will take up your questions, folks, but I think now it's time for a short break. So if you have questions and want to contact Attorney Sophie Alcorn directly, why not call her in this number, 855-644-2581. And you can email her hello@alcorn.law. That's how you can get in touch with Sophie Alcorn. She is also the founder of Alcorn Law and a best-selling author. Thank you so much. And definitely go visit www.alcorn.law to get to know more about Alcorn Law. And thank you, folks, for being here. Don't go anywhere because we're going to definitely talk more for the top visa options out there for you. So stay with us here on Immigration and Jobs Talk Show. This is Nipasa Pradhan with Sophie Alcorn.
Thank you so much.
IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we are discussing on this topic, top visa options for employers for a quick hire, H1B versus H1B exempt versus L1 versus O1. And this is the second episode with none other than our guest for today, Sophie Alcorn. So good to have you, Sophie, once again, and welcome back to this second half of this webinar. I hope you're having a good time.
Thank you so much. I am. I love all the questions, and it's so great chatting with you about all this. So thanks for the opportunity to be here.
Thank you. It's truly an honor and a pleasure to have you. And folks out there, for those of you who have been seeing Sophie and you know that she's a familiar face, let me tell you a little more about her. She is Sophie Alcorn, the founder of Alcorn Immigration Law, and has been recognized as the top 10 immigration attorney in the state of California. And she also is the host of the Sophie Alcorn podcast and the author of the best-selling book, Ask Sophie, The Founder's Guide to Visa and Green Cards. And maybe, Sophie, would you like to tell us what sorts of things do you discuss in your podcast, maybe, and how's it going?
Sure. Yeah, the podcast is really fun for me, and I hope everybody subscribes and listens. I will put the link in the chat window so that you can find it on Spotify and Apple Podcasts. But it's a weekly podcast, and it's about everything I am interested in. So definitely subscribe. It changes all the time. Most recently this year, and the archive is, I think, a tremendous resource because I have over 100 episodes on what is an H1B, what is an O1, what is an L1, how do I get a green card, how do I consular process, what do I do with an RFE? So I did that for 100 episodes. Then I wanted to change it up. So recently I've been interviewing people. My most recent nerd fascination is outer space immigration, which I think as a planet we need to prepare for the future.
Wow, that's very exciting and futuristic for sure. So you can tell us more. That's totally out of the box, so out of this world.
out of these, absolutely. I've been interviewing space law professors, space startup founders, former fighter pilots, people doing intellectual property law for space tech. It's fascinating stuff, and it's really brand new territory. And I just want to make sure that when we have hotels in space and a moon base and people are going to Mars, that we have a clear, clean, wonderful immigration system that allows people to effortlessly go between the Earth and other destinations. And like that kids born in space will have a citizenship after multiple generations so they can come back, right? This is like far-fetched sci-fi, but I love it.
Me too. You say it sounds so exciting, and wow, yes, we're going to have some immigration law for space too, for sure.
Yeah, I would love to be in the room and help write the treaty because the law is super antiquated, I figured out, and people who, like, technically, if you send something into outer space, it's still the property of your country. And if it lands back in your country, it's like it never left. But if it lands in somebody else's country, then there would be immigration and export. But if you're just like on the moon, you're still in the US or in India, if that's where you left from. But you can't own property in space. You own your equipment, but you don't own the surface of the moon. So it's super confusing. And there's like a lot of legal concepts, like if you have a slip and fall in a space hotel, do you have to take it to the UN, or is there some like private right of action? So I'm just fascinated. I want to help with this. Now for the fall with the podcast, I was just at the Capitol yesterday in Washington, D.C., and I've been really involved in conversations about artificial intelligence and bringing startup founders to the US and helping people to be able to innovate these new technologies. And so for the fall, my focus for the podcast is going to be talking to bipartisan lawmakers, former members of Congress, about prospects for high-skilled immigration reform, because that's something I'm really, really passionate about.
Very nice, very nice. And talking about AI, it's taking over so many spaces, workspaces, whether it's media or any field for that matter. So do you have to say a little bit about artificial intelligence as well?
Oh, God. Well, it's affecting everything. And if people don't know it yet, then maybe have a look, because it is happening. And it's one of those things that's like happening exponentially. So it's like, oh, doesn't matter. And then all of a sudden it's like, oh, wow, it matters. It's happening. And there's huge potential for innovation in the field. And, it's even going to affect like our power grid to have data centers that can actually, run all of these LLMs and different like GPUs and LPUs and all of that. So there's a lot of like logistical and infrastructure opportunities. So if anybody wants to, this was my learning yesterday, knowing about AI and electrical engineering with the power grid is like a job of the future that will be very, very important in the United States, definitely in the national interest. So there's like new opportunities like that coming up all the time. And Biden's executive order very much promotes AI as well as any other critical and emerging technology in the national interest. So if you want to pursue one of these fields, there's funding, there's visa and green card opportunities. Like, we want you here. And there's a lot of potential for what you can create that can help the world.
So folks out there who are still fortunate to be a student maybe so far, I think you can think about pursuing something with artificial intelligence, because I think that is the future for sure.
Absolutely. And it's not even just artificial intelligence, which is the other interesting thing. And I'll provide this link to your team.
And it's not just future. I mean, it is happening already.
It's happening now, but our government isn't just interested in AI. It got all smushed together in the AI executive order, but it's advanced computing, advanced engineering materials, advanced networking, AI, biotech, clean energy, data privacy, cybersecurity, autonomous vehicles, human-machine interfaces, quantum, semiconductor, space tech. So there's actually a lot of really, really exciting opportunities for careers.
Sure. So Thank you so much, Sophie. I mean, that was very enlightening, and I'm sure folks are going to be more interested to get to know more about this. So don't forget to check out Sophie Alcorn, folks. Her, uh, information is scrolling on the screen. You just note them down, and we will go on to the questions now because we just have a little more time. And Rag, who had questioned us earlier, has more questions for us. What documents should the employer periodically submit to the USCIS during the L1 visa holder's tenure?
Great question, Rog. There's no like random compliance checks where you just have to send in information as an employer, but they will evaluate everything on the renewal, such as the extension. So at that point, you're going to need to be able to show that your company is still doing business, revenue, tax filings, your org chart, that the job still exists, that the person's been working there, that you've been paying them properly, if they've, been growing in their career at all or their responsibilities. All of those things are super helpful to show.
Thank you so much, Rag, for your question again. And Rag says that he liked the NVCA podcast of yours. Very nice.
Thank you. Appreciate that. That was a fun one. The National Venture Capital Association is a really great organization. They actually litigated to keep to keep the International Entrepreneur Parole Program, which is like our startup visa, to keep it alive. And it's been really great working with them. Silicon Valley investors are very interested and motivated to keep immigrant entrepreneurs coming to Silicon Valley. So there are supporters for immigrants who are very vocal and who definitely do a lot to help.
Lovely, lovely. Thank you so much for sharing that as well. And thank you, Rag. Like I was saying earlier, you totally are an immigration enthusiast, and it's lovely to see that you're following up. Thank you for joining us here. Yeah. Let's move on to Raja Sekhar. H1B visa petition was selected in the initial lottery, but the employer is now facing financial difficulties and may need to withdraw the petition. If we withdraw the petition, can we still participate in the second lottery, or will that impact our client's eligibility?
Withdrawing the petition will remove the beneficiary's eligibility. So it would be really lovely if this employer could maybe just wait a few weeks to see if this person is chosen in the second lottery before making any sudden moves. If so, an H1B, let's just pretend this person gets selected. The H1B has to be filed in good faith. So if the employer is having financial difficulties, and really would never hire this person, they just shouldn't file it. If they're having financial difficulties, but they would still love to have this person work on October 1st, but they just don't know if their financials would qualify, it might be worth it to move through with the petition. Maybe the person will get selected. And, if they have to fire you because they can't pay you after October 1st, at least at that point, you would have, approved H1B petition, you would have been counted against the lottery, and then you could try to do an H1B transfer to another employer.
Mm-hmm. Thank you. Thank you for taking that up. I'm sure Raja Sekhar is very happy with your answer. All right, let's take up this next one. This is from Ankit. I have heard that O1 visas are a great option for hiring top talent quickly, but I want to learn more. Can you explain the eligibility requirements and application processes for O1 visas and how they differ from H1B and L1 visas?
Great question, Ankit. Absolutely. So in one sense, they're all visas. There's a petition with USCIS. You can pay for premium processing. USCIS will make a decision. Once there's an approval, you go schedule a visa appointment. You get a visa in your passport. You come in. You do the job you said you would do. So they're all similar in that respect. But who qualifies is very, very different. So the H1B, super straightforward. Bachelor's degree or equivalent, company that's offering you a professional job that has the ability to pay you. That's that super easy to get through. The L1 is like, hey, you've been working for us abroad for a year and we got to transfer you here now to help run things in the States. The O1 is a different beast. It's saying, hey, Ankit is the very best XYZ, the very best AI enterprise SaaS AI startup founder of India, focusing on helping the healthcare vertical. And now, because he's so extraordinary in India, we want him to be able to come to the US to do XYZ, whatever you want. Start a company, get a part-time job, get a full-time job, be a consultant, do all of those things at once. So the O1's very different. It's like, hey, we already know you're the best at something in your country. So come on here, tell us what you're going to do, but you can basically do anything you want as long as you get pre-clearance for that and set it up in the petition. So there's a lot of flexibility. It doesn't have to be from your home country. You could be famous in a third country. You could be famous in the US. And what famous means is very, there's a lot of grace within that standard. So if you think that you even might have 3 of the 8 criteria for an O1, whether you're a researcher or a TikTok star or like an entrepreneur, at least get an assessment from an attorney. Will do that for you because it's a really great option. If you're not married or if your spouse doesn't need to work, it's a really, really great option because you have a ton of job flexibility in your field. It's basically like having a work permit to do whatever you love. So definitely would encourage people. And the other critical thing I just want to mention is you do not need to have an employer to petition you. You can also have an agent. And this is something we copied and pasted from Hollywood where movie stars have agents. Now we're doing that for Silicon Valley clients where software engineers have agents. So that's the method by which you don't have to have just one job. We can include an itinerary of your services. You can have projects come and go, consulting work, startups, all of that. So if you don't, you could even get the O1 first through an agent, through a subset of jobs, and then go to I don't think big tech likes to hire people with O1 agents, but they could just transfer your O1 to them. Or a small company would be like, oh yeah, you can just work part-time for us. Great. We don't have to do your visa. Great. So it's a really wonderful option.
Yes. And like you were saying, I mean, especially if you're talking about famous people, it's not like a one-man band or anything. I'm sure they'll have managers, they'll have people who make them who they are, makeup artists or dress up artists. I don't know.
I had one guy at a big tech company that was like, do you think I qualify? I've written like 40 letters of recommendations for my direct reports and they all got extraordinary ability, but can I qualify? I'm like, yes, sir. You're very, very qualified. So there's lots of different ways to qualify.
Right. And then there's also the P3, right? Which is pretty similar, a little different.
Yeah.
That also. But Ankit, I would just say it's always best to consult an attorney where you tell them your whole case, your whole situation, and they can guide you best where you fit. So,
absolutely.
All right, let's move on now. We have another question. This is from Afreen. Is there a minimum salary for a job in H1B status? What status would my spouse and children have when I am granted H1B status? Also, I want to know in details how concurrent H1B visa work.
Okay. There is a minimum salary for a job in H1B. It depends on the job, your level of responsibility and experience, and the geographic area. It is the employer's responsibility, working with the immigration attorney, to calculate it's called the prevailing wage for your job. So there's a government website. You can do like a government wage search on the FLAG Department of Labor website to try to estimate it, but it's part of the legal process to figure it out. The spouse and children of an H1B holder have H4 dependent status, which does not automatically authorize spouses to work, but everybody can be here with you. Kids can go to school. They're considered your kids till they're 21. And then how does the concurrent H1B visa work? Well, the 2 programs that I'm aware of right now, one of them, they both involve your employer's participation. So really you should have your employer reach out to my law firm to figure out how to support you. But 2 of the programs I've worked with, the more established one is called Open Avenues Foundation. They have the Build Fellowship. And the new one is called the Parachute Project, and they have different pricing models and different requirements. There may be more out there as well, but those are the two I've heard of.
Lovely. Thank you, Afreen, for your question, and Sophie as well for taking that up. All right, we have Ankit again. Another question. Can I sponsor an employee for an O1 visa if they are already in the US on a different visa status, such
Absolutely.
as an F1 or J1? Yeah. Okay.
Yeah, that's just called a change of status. And then if they want to go for a stamping interview for the new O1 petition, they can schedule that. But that's very straightforward as long as they're maintaining valid F1 or J1 status. The exception is if somebody is subject to the 212E 2-year foreign residence requirement for their J1 because they got government funding or a Fulbright scholarship or something, they're supposed to go back home for 2 years after their J1. But even if they are subject to that 2-year requirement, they can still qualify for an O1. They're just not eligible for a change of status. They have to go back in consular process to activate it.
Thank you. Thank you for taking that. All right, this next one, this is Nirlip. He has 2 questions. We'll take this first one first. Can I sponsor an employee? Oh, this is the same one. Sorry. Are there any specific requirements or procedures for converting their status to an O1 visa? And how will it impact their stay in the US?
Yes, it is a specific process. So you have to meet the O1 requirements. You have to do the O1 change of status petition. If you have selected a change of status to O1, when their I-797 approval notice comes, it will have the start and end dates for the requested O1 status, which will take effect automatically when they're in the US on that date. So this becomes their new I-94, and they will have a new date by which to leave the United States.
Okay. Thank you. Thank you for your question, Nirlep. And thank you, Sophie, as well. Rag also says thank you. Thanks, Sophie and Napasa. So sweet. Thank
You're
you.
welcome.
Thank you. I think we have covered most of our questions, but just in case if I've missed anything, let me just have a look. Yeah, I think that is. Oh, we have this next one. This is from Esther. What can be like a hindrance for your H1B petition filed? How long does it take to get a response from the USCIS currently?
What can be a hindrance? Well, you have to meet the requirements. So if the government wants to scrutinize the employer's ability to pay you, or if they are concerned that it's not a specialty occupation under the laws about if that job role qualifies, they might issue a request for evidence. If they're concerned whether you've been maintaining your status, they could ask you for more documents. So those are some of the common requests for evidence triggers. Now, how long does it take to get a response? It depends on if you have requested premium processing. If you did, then it's 15 days to get an answer. And if you didn't, it's usually many months. Let's check this out. I'm just looking at the USCIS case processing time website. So if you are being sponsored by an employer in California for an H1B to be issued abroad, then, and if you don't choose premium processing, they're going to take 6 months to make a decision on the petition. So most of my clients proactively choose premium processing every single time because they can't wait around for this. But it's a range depending on where you are, where the company is, when you filed it, but it's usually many months. But you can always upgrade. If your employer didn't want to pay for premium processing, you can be like, hey, let me pay the $2,805 myself, and then you can get it done.
There you go, Esther. I think you have your options there, and all the best. It should work. Yes. And thank you so much. I mean, I think with this, we can wrap up our show for today because I think we've covered most of our questions from the audience, and it was a lovely presentation, making things so much clearer for us. You know, today we spoke about top visa options for employers for a quick hire. and of course the different visas. Thank you so much, Sophie. And maybe before we go off, if you could just give an end note to all our audience out there, and yeah, that'll be great.
Absolutely. Thank you, Nipasa. Well, this was really fun, and I love everybody's questions. And thank you for those folks who have been following my work. I really appreciate it. That always feels great to hear that I've been able to help you and maybe make a little bit of a difference in your life. So that's super exciting. In summary, I just want to end on a positive note because I feel like people don't realize how much power and control they have over their immigration destiny. So like if you have a burning desire to move to the US, to live here, to get a green card, yeah, you can do it by, 90-day fiance, marrying somebody, falling in love, probably fall in love first and then marry them. You can do it by getting a job. Those are very unreliable. So I built my practice on people who are self-petitioning their own way. And that way, whether it's an O1, whether it's an EB2 national interest waiver, I-140 self-petition, followed by an upgrade to like an EB1A for extraordinary ability to fast track your green card. Like I've really built my practice on helping people take responsibility for their immigration into their own hands. And I just want to encourage everybody, like it is so wonderful when you have a kind employer who respects you and who wants to help you through this journey. That's like the best. But if you don't have that yet, you don't have to just like wait around wondering. You can actively build up your profile to qualify for many types of options. So I just want to give you that note of encouragement and hope that this is actually within your control, which surprises a lot of people. So, so thank you for that opportunity, Nipasa.
Thank you so much. Really, I mean, you're giving us a total different perspective, and absolutely nothing better than depending on your own self, who you can trust entirely. So why not?
Exactly.
Thank you. Thank you, Sophie. It was really wonderful to have you. You have a great day ahead, but I would really love you to join us once again. So I will look forward for that.
I would love that anytime. It's so fun chatting with you. Thank you for doing this. And thank you to your amazing team.
Thank you.
Okay. Bye-bye.
Thank you. Yay. Awesome. Bye-bye. Have a great day. And folks out there, thank you so much today. It was really lovely having all your questions as well. And thank you. Sophie, you were amazing once again. Let me tell you that. And folks, feel free to contact Sophie. Her number is 855-644-2581. And you can even email her hello@alcorn.law and visit her website, www.alcorn.law.com. www.alcorn.law. That's her website. And thank you, friends. You can even contact me. And if you're looking for a project placement, H4, green cards, anything related to immigration or jobs, feel free to contact me as well. My number is 408-335-6444. And my email address is nipa@hirightpeople.com. And visit our website, www.hirightpeople.com, to get to know more about us. For now, this is it, but definitely stay tuned to our space. Our handle is Immigration and Jobs Talk Show. Don't forget to subscribe to us, like, share, and also look out for another webinar that I'm going to be joining you with, another guest, and that's going to happen at 2 p.m. EDT. So look out for that. Thank you so much for joining us now, and have a great day ahead. This is Nipasa Pradhan signing off from Immigration and Jobs Talk Show.
Consultants seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or